In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendants committed the main crime of which they are accused, there may be evidence that he committed other acts that would constitute a lesser included crime. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crime indicated in the definition of murder in the first degree is manslaughter. State, would you be able to display count 1 verdict forms on the evidence cart, please? So you are seeing, members of the juries, the verdict forms for count 1. And members of the yellow jury, you will see that your verdict form is different and contains additional findings. That's the additional findings that I read to you that were not directed to the red jury. So, as to count 1, to prove the lesser included crime of manslaughter, the state must prove the following 2 elements beyond a reasonable doubt. 1, Prince Holland is dead. 2, Marcel Joshua Johnson intentionally committed an act or acts that caused the death of Prince Holland, or, for yellow jury, 2, Contravious Tyree Gerard intentionally committed an act or acts that caused the death of Prince Holland. Every person has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed you. In order to convict of manslaughter, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. If you find that Marcel Joshua Johnson, members of the red jury, committed manslaughter with a firearm, and you also find beyond a reasonable doubt that during the commission of the crime, he personally carried, displayed, used, threatened to use, or attempted to use a firearm, you should find him guilty of manslaughter with a firearm. A firearm has been previously defined. Members of the yellow jury, if you find that Contravious Tyree Gerard committed manslaughter, and you also find beyond a reasonable doubt that during the commission of the crime, he personally carried, displayed, used, or threatened to use, attempted to use a firearm, you should find him guilty of manslaughter with a firearm. A firearm has been previously defined. If you find that members of the red jury, Marcel Joshua Johnson, committed manslaughter, but you're not convinced beyond a reasonable doubt that he personally carried, displayed, used, threatened to use, or attempted to use a firearm, then you should find him guilty only of manslaughter. As to the yellow jury, if you find that Contravious Gerard committed manslaughter, but you are not convinced beyond a reasonable doubt that he personally carried, displayed, used, threatened to use, or attempted to use a firearm, then you should find him guilty only of manslaughter. Marcel Johnson is accused of attempted murder in the first degree in count 2 and attempted murder in the second degree in counts 3, 4, and 5. Contravious Gerard is accused of attempted murder in the first degree in count 2 and attempted murder in the second degree in counts 3, 4, and 5. Attempted first degree murder includes the lesser crimes of attempted second degree and attempted manslaughter by act. Attempted second degree murder includes the lesser crime of attempted manslaughter by act, all of which are forms of attempted homicide and all of which are unlawful. However, an attempted homicide that was excusable or that was committed by the justifiable use of deadly force is lawful. If you find there was an attempted homicide of Jalen McIntyre Burroughs as to count 2, or Talent Walker as to count 3, or Rashid Green as to count 4, or Ezekiel Cooper as to count 5, by Marcel Joshua Johnson, members of the red jury, you will then consider the circumstances surrounding the attempted homicide in deciding whether it was attempted first-degree murder or attempted second-degree murder or attempted manslaughter by act, or whether the attempted homicide was excusable or resulted from the justifiable use of deadly force. Members of the yellow jury, if you find that there was an attempted homicide of Jalen McIntyre Burroughs as to count 2, or Talent Walker as to count 3, or Rashid Green as to count 4, or Ezekiel Cooper as to count 5 by Contravious Gerard, you will then consider the circumstances surrounding the attempted homicide in deciding whether it was attempted first-degree murder or attempted second-degree murder or attempted manslaughter by act, or whether the attempted homicide was excusable or resulted from the justifiable use of deadly force. The use of deadly force to attempt to kill a human being is justifiable and therefore lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in or upon any dwelling house in which the defendant was at the time of the attempted killing. Deadly force means force likely to cause death or great bodily harm. Great bodily harm means harm that is more than slight, trivial, minor, or moderate. An attempted homicide is excusable and therefore lawful under any one of the 3 following circumstances. 1, when the attempted homicide is committed by accident and misfortune in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent. Or 2, when the attempted homicide occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation. Or 3, when the attempted homicide is committed by accident and misfortune resulting from a sudden combat if a dangerous weapon is not used and the attempted killing is not done in a cruel and unusual manner. A dangerous weapon is any object that will likely cause death or great bodily harm if used in the ordinary and usual manner contemplated by its design and construction. Great bodily harm has been previously defined. I now instruct you, members of the red jury, on the circumstances that must be proved before Marcel Johnson may be found guilty of attempted first-degree murder, attempted second-degree murder, or attempted manslaughter by act. I now instruct you, members of the yellow jury, on the circumstances that must be proved before Contravious Gerard may be found guilty of attempted first-degree murder, attempted second-degree murder, or attempted manslaughter by act. Members of the red jury, as to count 2, to prove the crime of attempted first-degree premeditated murder, the state must prove the following 3 elements beyond a reasonable doubt. 1, Marcel Joshua Johnson intended to commit the crime of first-degree premeditated murder. 2, Marcel Johnson committed an overt act toward the commission of first-degree premeditated murder that went beyond mere preparation. And 3, Marcel Johnson failed to complete the first-degree premeditated murder. Members of the yellow jury, as to count 2, to prove the crime of attempted first-degree premeditated murder, the state must prove the following 3 elements beyond a reasonable doubt. 1, Contravious Gerard intended to commit the crime of first-degree premeditated murder. 2, Contravious Gerard committed an overt act toward the commission of first-degree premeditated murder that went beyond mere preparation. 3, Contravious Gerard failed to complete the first-degree premeditated murder. The line between mere preparation and an overt act is a question of fact for you to decide. Mere preparation consists of devising or arranging the means or measures necessary to commit the crime. An overt act consists of some movement toward committing the crime after mere preparation. An overt act need not be the last possible act toward completing the crime. To prove that a first-degree premeditated murder had taken place, the state would have to prove the following three elements beyond a reasonable doubt. 1, Jalen McIntyre Burroughs is dead. 2, the death was caused by the criminal act of Marcel Johnson, as to the red jury. 2, the death was caused by the criminal act of Contravious Gerard, as to the yellow jury. 3, there was a premeditated killing of Jalen McIntyre Burroughs. A premeditated killing is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. As to the yellow jury, if you find that Contravious Gerard committed attempted murder in the first degree, and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm and in doing so caused great bodily harm to Jalen McIntyre Burroughs, you should find the defendant guilty of attempted murder in the first degree with discharge of a firearm causing great bodily harm. Great bodily harm has been previously defined. If you find that Contravious Gerard committed attempted murder in the first degree, and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm, you should find the defendant guilty of attempted murder in the first degree with discharge of a firearm device. And you'll see the verdict form for count 2 displayed on your screen, and you'll see that as to Mr. Gerard, those findings are in that verdict form. If you find that Contravious Gerard committed attempted murder in the first degree, and you also find beyond a reasonable doubt that during the commission of the crime he actually possessed a firearm, you should find the defendant guilty of attempted murder in the first degree with actual possession of a firearm. A firearm has been previously defined. To actually possess a firearm has been previously defined. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crimes of which he is accused, there may be evidence that he committed other acts that would constitute a lesser included crime. Therefore, if you decide the main accusation has not been proven beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crimes indicated in the definition of attempted murder in the first degree are attempted second degree murder, attempted manslaughter by act, aggravated battery, and battery. As to count 2, to prove the lesser included crime of attempted second degree murder, the state must prove the following 3 elements beyond a reasonable doubt. 1, members of the red jury, as to that Marcel Johnson intentionally committed an overt act that could have resulted in the death of Jalen McIntyre Burroughs, but did not result in Jalen McIntyre Burroughs' death. Members of the yellow jury, as to element 1, Contravious Gerard intentionally committed an overt act that could have resulted in the death of Jalen McIntyre Burroughs, but did not result in Jalen McIntyre Burroughs' death. 2, the act was imminently dangerous to another and demonstrated a depraved mind without regard to human life. 3, the overt act went beyond mere preparation. An act is imminently dangerous to another and demonstrated a depraved mind if it is an act or series of acts that 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2, is done from ill will, hatred, spite, or an evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. The line between mere preparation and an overt act is a question of fact for you to decide. Mere preparation consists of some movement toward committing the crime after mere preparation. An overt act need not be the last possible act toward completing the crime. To convict the defendant of attempted second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. Members of the yellow jury, if you find that Contravious Tyree Gerard committed attempted murder in the second degree, and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm and in doing so caused great bodily harm to Jalen McIntyre Burroughs, you should find the defendant guilty of attempted murder in the second degree with discharge of a firearm causing great bodily harm. Great bodily harm has been previously defined. If you find that Contravious Gerard committed attempted murder in the second degree, and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm, you should find the defendant guilty of attempted murder in the second degree with discharge of a firearm device. If you find that Contravious Gerard committed attempted murder in the second degree, and you also find beyond a reasonable doubt that during the commission of the crime he actually possessed a firearm, you should find the defendant guilty of attempted murder in the second degree with actual possession of a firearm. A firearm has been previously defined. To actually possess a firearm has been previously defined. As to count 2, to prove the lesser included crime of attempted manslaughter by act, the state must prove the following 2 elements beyond a reasonable doubt. Red jury, as to Marcel Johnson, the state must prove that he intentionally committed an overt act that could have resulted in the death of Jalen McIntyre Burroughs, but did not result in Jalen McIntyre Burroughs' death. That's element 1. Yellow jury, element 1 is that Contravious Tyree Gerard intentionally committed an overt act that could have resulted in the death of Jalen McIntyre Burroughs, but did not result in Jalen McIntyre Burroughs' death. Element 2, the overt act went beyond mere preparation. The line between mere preparation and an overt act is a question of fact for you to decide. Mere preparation consists of devising or arranging the means or measures necessary to commit the crime. An overt act consists of some movement toward committing the crime after mere preparation. An overt act need not be the last possible act toward completing the crime. However, the defendant cannot be guilty of attempted manslaughter by act by committing a merely negligent act. Every person has a duty to act reasonably and use ordinary care towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. To convict of attempted manslaughter, it is not necessary for the state to prove the defendant had an intent to cause death, only an intent to commit an act that could have caused death and was not justifiable or excusable attempted homicide, as I've previously instructed you. If you find, members of the red jury, that Marcel Johnson committed attempted manslaughter, and you also find beyond a reasonable doubt that during the commission of the crime he personally carried, displayed, used, threatened to use, attempted to use a firearm, you should find him guilty of manslaughter with a firearm. A firearm has been previously defined. Members of the yellow jury, if you find that Contravious Gerard committed attempted manslaughter, and you also find beyond a reasonable doubt that during the commission of the crime he personally carried, displayed, used, threatened to use, or attempted to use a firearm, you should find him guilty of attempted manslaughter with a firearm. A firearm has been previously defined. Red jury, if you find that Marcel Johnson committed attempted manslaughter, but you are not convinced beyond a reasonable doubt that he personally carried, displayed, used, threatened to use, or attempted to use a firearm, then you should find him guilty only of attempted manslaughter. Yellow jury, if you find that Contravious Gerard committed attempted manslaughter, but you are not convinced beyond a reasonable doubt that he personally carried, displayed, used, threatened, or used, or attempted to use a firearm, then you should find him guilty only of attempted manslaughter. As to count 2, to prove the lesser included crime of aggravated battery, the state must prove the following 2 elements beyond a reasonable doubt. The first element is a definition of battery. As to Marcel Johnson, members of the red jury, first element is Marcel Johnson actually and intentionally touched or struck Jalen McIntyre Burroughs against his will or intentionally caused bodily harm to Jalen McIntyre Burroughs. Element 2, Marcel Johnson, in committing the battery, intentionally or knowingly caused great bodily harm to Jalen McIntyre Burroughs or used a deadly weapon. Yellow jury. Element 1, Contravious Gerard actually intentionally touched or struck Jalen McIntyre Burroughs against his will or intentionally caused bodily harm to Jalen McIntyre Burroughs. 2, Contravious Gerard, in committing the battery, intentionally or knowingly caused great bodily harm to Jalen McIntyre Burroughs or used a deadly weapon. A deadly weapon is an object that will likely cause death or great bodily harm if used or threatened to be used in the ordinary and usual manner contemplated by its design and construction. An object not designed to inflict bodily harm may nonetheless be a deadly weapon if it was used or threatened to be used in a manner likely to cause death or great bodily harm. Great bodily harm has been previously defined. An intentional touching or striking includes situations where a defendant knows that a touch or strike is substantially certain to result from his or her act. A battery may be found as a result of the intentional touching or intentional striking of something other than the actual body of the person. However, the object that is touched or struck must have such an intimate connection with the person that it is to be regarded as part of or an extension of the person. Yellow jury. If you find that Contravious Gerard committed aggravated battery, and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm and in doing so caused great bodily harm to Jalen McIntyre Burroughs, you should find the defendant guilty of aggravated battery with discharge of a firearm causing great bodily harm. Great bodily harm has been previously defined. If you find that Contravious Gerard committed aggravated battery, and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm, you should find the defendant guilty of aggravated battery with discharge of a firearm. If you find that Contravious Gerard committed aggravated battery, you also find beyond a reasonable doubt that during the commission of the crime he actually possessed a firearm, you should find the defendant guilty of aggravated battery with actual possession of a firearm. A firearm has been previously defined. To actually possess has been previously defined. As to count 2, to prove the lesser included crime of battery, the state must prove the following element beyond a reasonable doubt. And if you're tracking the verdict forms, you'll see those lesser included offenses there. Red jury. 1, Marcel Johnson actually and intentionally touched or struck Jalen McIntyre Burroughs against his will and or intentionally caused bodily harm to Jalen McIntyre Burroughs. Yellow jury. Contravious Gerard actually and intentionally touched or struck Jalen McIntyre Burroughs against his will and or intentionally caused bodily harm to Jalen McIntyre Burroughs. An intentional touching or striking includes situations where a defendant knows that a touch or strike is substantially certain to result from his or her act. A battery may be found as a result of the intentional touching or intentional striking of something other than the actual body of the person. However, The object that is touched or struck must have such an intimate connection with the person that it is to be regarded as part of or an extension of the person. As to counts 3, 4, and 5, to prove the crime of attempted second-degree murder, the state must prove the following 3 elements beyond a reasonable doubt. Counsel, approach, please. We don't need the court reporter. All right, sorry about that interruption, members of the juries. So once again, the state must prove the following 3 elements beyond a reasonable doubt for attempted second-degree murder. Red jury, as to count 3, element 1 is, or element 1, as to count 3, Marcel Johnson intentionally committed an overt act that could have resulted in the death of Talent Walker, but did not result in Talent Walker's death. As to count 4, Marcel Johnson intentionally committed an overt act that could have resulted in the death of Rashid Green, but did not result in Rashid Green's death. As to count 5, Marcel Johnson intentionally committed an overt act that could have resulted in the death of Ezekiel Cooper, but did not result in Ezekiel Cooper's death. Members of the red jury, as to count 3, Contravious Gerard, this is element 1, intentionally committed an overt act that could have resulted in the death of Talent Walker, but did not result in Talent Walker's death. As to count 4, Contravious Gerard intentionally committed an overt act that could have resulted in the death of Rashid Green, but did not result in Rashid Green's death. As to count 5, Contravious Gerard intentionally committed an overt act that could have resulted in the death of Ezekiel Cooper, but did not result in Ezekiel Cooper's death. Elements 2 and 3 are the same for each defendant. 2, the act was eminently dangerous to another and demonstrated a depraved mind without regard for human life. 3, the overt act went beyond mere preparation. An act is eminently dangerous to another and demonstrated a depraved mind if it is an act or series of acts that, 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2, is done from ill will, hatred, spite, or an evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. The line between mere preparation and an overt act is a question of fact for you to decide. Mere preparation consists of devising or arranging the means or measures necessary to commit the crime. An overt act consists of some movement toward committing the crime after mere preparation. An overt act need not be the last possible act toward completing the crime. To convict the defendant of attempted second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. Yellow jury. Excuse me. If you find that Contravious Gerard committed attempted murder in the second degree, and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm and in doing so caused great bodily harm to Talent Walker as to count 3, or Rashid Green as to count 4, or Ezekiel Cooper as to count 5, you should find the defendant guilty of attempted murder in the second degree with discharge of a firearm causing great bodily harm. Great bodily harm has been previously defined. If you find that Contravious Gerard committed attempted murder in the second degree, and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm, you should find the defendant guilty of attempted murder in the second degree with discharge of a firearm device. If you find that Contravious Tyree Gerard committed attempted murder in the second degree, and you also find beyond a reasonable doubt that during the commission of the crime he actually possessed a firearm, you should find the defendant guilty of attempted murder in the second degree with actual possession of a firearm. A firearm has been previously defined. To actually possess a firearm has been previously defined. And of course, on the verdict forms, there are the places for you to make those specific findings. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crimes of which he is accused, there may be evidence that he committed other acts that would constitute a lesser included crime. Therefore, if you decide that the main accusation has not been proven beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser included crime indicated in the definition of attempted murder in the second degree is attempted manslaughter by act. As to counts 3, 4, and 5, to prove the lesser included crime of attempted manslaughter by act, the state must prove the following 2 elements beyond a reasonable doubt. First element, as to Marcel Johnson, red jury. As to count 3, Marcel Joshua Johnson intentionally committed an overt act which would have resulted in the death of Talent Walker, but did not result in Talent Walker's death. As to count 4, Marcel Johnson intentionally committed an overt act which would have resulted in the death of Rashid Green, but did not result in Rashid Green's death. As to count 4, Marcel Johnson intentionally committed an overt act which would have resulted in the death of Ezekiel Cooper, but did not result in Ezekiel Cooper's death. 2, the overt act went beyond mere preparation. Yellow jury, first element, as to Contravious Gerard. As to count 3, Contravious Gerard intentionally committed an overt act which would have resulted in the death of Talent Walker, but did not result in Talent Walker's death. As to count 4, Contravious Gerard intentionally committed an overt act which would have resulted in the death of Rashid Green, but did not result in Rashid Green's death. As to count 4, Contravious Gerard intentionally committed an overt act which would have resulted in the death of Ezekiel Cooper, but did not result in Ezekiel Cooper's death. Element 2, the overt act went beyond mere preparation. The line between mere preparation and an overt act is a question of fact for you to decide. Mere preparation consists of devising or arranging the means or measures necessary to commit the crime. An overt act consists of some movement toward committing the crime after mere preparation. An overt act need not be the last possible act toward completing the crime. However, the defendant cannot be guilty of attempted manslaughter by act by committing a merely negligent act. Every person has a duty to act reasonably and use ordinary care toward others. If there's a violation of that duty without any conscious intention to harm, that violation is negligence. To convict of attempted manslaughter by act, it is not necessary for the state to prove the defendant had an intent to cause death, only an intent to commit an act that could have caused death and was not justifiable or excusable homicide, as I have previously instructed you. Red jury, if you find that Marcel Johnson committed attempted manslaughter by act, and you also find beyond a reasonable doubt that during the commission of the crime, he personally carried, displayed, used, threatened to use, or attempted to use a firearm, you should find him guilty of attempted manslaughter by act with a firearm. Firearm has been previously defined. If you find that Marcel Johnson committed attempted manslaughter by act, but you are not convinced beyond a reasonable doubt that he personally carried, displayed, used, or threatened to use a firearm, then you should find him guilty only of attempted manslaughter by act. Yellow jury, if you find that Contravious Gerard committed attempted manslaughter by act, and you also find beyond a reasonable doubt that during the commission of the crime he personally carried, displayed, used, threatened to use, or attempted to use a firearm, you should find him guilty of attempted manslaughter by act with a firearm. A firearm has been previously defined. If you find that Contravious Gerard committed attempted manslaughter by act, but you are not convinced beyond a reasonable doubt that he personally carried, displayed, used, threatened to use, or attempted to use a firearm, then you should find him guilty only of attempted manslaughter by act. If the defendant helped another person or persons commit or attempt to commit a crime, the defendant is a principal and must be treated as if he had done all the things the other person or persons did if the state proved beyond a reasonable doubt the defendant intended the crime to occur and the defendant did some act or said something that was intended to and did incite, cause, encourage, assist, or advise the other person or persons to actually commit or attempt to commit the crime. To be a principal, the defendant does not have to be present when the crime is committed or attempted. For attempted first-degree premeditated murder, the state must prove the defendant intended the killing of Jalen McIntyre Burroughs occur. For first-degree felony murder and attempted second-degree murder, it is not necessary for the state to prove the defendant intended the death of Prince Holland, Talent Walker, Rasheed Green, or Ezekiel Cooper. It is not necessary for a principal to know every detail of how a manslaughter, attempted manslaughter, or aggravated battery will be committed as long as the principal intended the manslaughter, attempted manslaughter, or aggravated battery to occur and did some act or said something that was intended to help and did help the manslaughter, attempted manslaughter, or aggravated battery occur. To be found guilty of manslaughter, attempted manslaughter, or aggravated battery with a firearm as a principal is not necessary for the state to prove the defendant knew another participant of the manslaughter, attempted manslaughter, or aggravated battery would be armed. Counsel, let me have you all approach briefly again. Don't need the court reporter. was committed. An issue in this case is whether the crime of first-degree felony murder, manslaughter, attempted first-degree murder, attempted manslaughter by act, aggravated battery, or attempted second-degree murder was an independent act of a person other than the defendant. An independent act occurs when a person other than the defendant commits or attempts to commit a crime which the defendant did not intend to incur and in which the defendant did not participate and which was outside of and not a reasonably foreseeable consequence of the common design or unlawful act contemplated by the defendant. If you find the defendant was not present when the crime of first-degree felony murder, manslaughter, attempted first-degree murder, attempted manslaughter by act, aggravated battery, or attempted second-degree murder occurred, that in and of itself does not establish that the first-degree felony murder, manslaughter, attempted first-degree murder, attempted manslaughter by act, aggravated battery, or attempted second-degree murder was an independent act of another. If you find that the first-degree murder, felony murder, attempted first-degree murder, attempted manslaughter by act, aggravated battery, or attempted second-degree murder was an independent act of another, red jury, then you should find Marcel Johnson not guilty of the crime of first-degree felony murder, manslaughter, attempted first-degree murder, attempted manslaughter by act, aggravated battery, or attempted second-degree murder. Yellow jury. If you find that the first-degree felony murder, manslaughter, attempted first-degree murder, attempted manslaughter by act, aggravated battery, or attempted second-degree murder was an independent act of another, then you should find Contravious Gerard not guilty of the crime of first-degree felony murder, manslaughter, attempted first-degree murder, attempted manslaughter by act, aggravated battery, or attempted second-degree murder. Mere knowledge that an offense is being committed is not the same as participation with criminal intent, and mere presence at the scene is insufficient to establish participation in the offense. The state must prove the crimes were committed on December 3rd, 2022. The state must prove by a preponderance of the evidence that the alleged crimes were committed in Duval County. The defendants have entered pleas of not guilty. This means you must presume or believe the defendants are innocent. The presumption stays with the defendant as to each material allegation in the information through each stage of the trial unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully comparing and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: 1, did the witness seem to have an opportunity to see and know the things about which the witness testified? 2, did the witness seem to have an accurate memory? 3, Was the witness honest and straightforward in answering the attorney's questions? 4, did the witness have some interest in how the case should be decided? 5, does the witness's testimony agree with the other testimony and other evidence in the case? 6, has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? 7, had any pressure or threat been used against the witness that affected the truth of the witness's testimony? 8, did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. You must consider the testimony of some witnesses with more caution than others. For example, a witness who hopes to gain more favorable treatment in his or her own case may have a reason to make a false statement in order to strike a good bargain with the state. This is particularly true when there is no other evidence tending to agree with what the witness says about the defendant. So while a witness of that kind may be entirely truthful when testifying, you should consider his testimony with more caution than the testimony of other witnesses. However, if the testimony of such a witness convinces you beyond a reasonable doubt of the defendant's guilt, or the other evidence in the case does so, then you should find the defendant guilty. You have heard the testimony of a child. No witness is disqualified just because of age. There is no precise age that determines whether a witness may testify. The critical consideration is not the witness's age, but whether the witness understands the difference between what is true and what is not true, and understands the duty to tell the truth. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely on your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. A statement claimed to have been made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. If you conclude that the defendant made the statement, you must also determine from the evidence whether the defendant's statement was freely and voluntarily made. In making this determination, you should consider the total circumstances, including but not limited to: 1, whether when the defendant made the statement, he had been threatened in order to get him to make it, and 2, whether anyone had promised him anything in order to get him to make it. If you conclude the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. 1, you must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. 2, the case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of exhibits in evidence and these instructions. 3, this case must not be decided for or against anyone because you feel sorry for anyone or angry at anyone. 4, remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. 5, your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. 6, whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. 7, your verdict should not be influenced by any feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. You may find the defendant guilty as charged or guilty of such lesser included crimes as the evidence may justify or not guilty. If you return a verdict of guilty, it should be for the highest offense on the verdict form for each count that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. The verdict must be in writing, and for your convenience, the necessary verdict forms have been prepared for you. And I'll review these, although you've been able to see them. Give me just a moment, members of the jury. I just want to make sure that I have everything arranged the way I want it to be. And State, if you would display the verdict forms for me while I review them, please. Because the verdict forms differ for each defendant, I will review them individually with the juries. Red jury, this is the verdict form for count 1. All of the verdict forms have blanks to check, and it may be on a separate page, but they will all have a place for the foreperson to sign it and to date it. Goes to count 1. We, the jury, and you'll check one of these blanks, find the defendant guilty of first-degree murder, as charged in the information. We, the jury, find the defendant guilty of manslaughter, a lesser-included offense. If you find the defendant guilty of this offense, you must choose one of the following findings. We find the defendant did carry, display, use, threaten to use, or attempt to use a firearm during the commission of the offense. We find the defendant did not carry, display, use, or threaten to or attempt to use a firearm during the commission of the offense. We, the jury, find the defendant not guilty. Once again, foreperson will sign and date. This is the verdict form for count 2. Very similar structure.
Your Honor, I think for that one, we had forgotten an attempted second-degree murder, so I manually added that in, and it's on your screen.
Okay, thank you. Give me just a moment. Tell me that revision again, Mr. Corral.
The lesser included attempted second-degree murder was not included.
Okay.
I've now included it on the screen, but it's not on.
I see. All right, so members of the jury, for the verdict form for count 2, just simply reference your screen. You'll see that unfortunately the verdict form I have in my hand does not include the lesser included offense of attempted second-degree murder, but it does follow the basic pattern. Blanks to check. The first blank is we find the defendant guilty of attempted first-degree murder is charged in the information. The verdict form that you actually have with you back in the jury room will not be what I'm holding in my hand. It'll be what you see on the screen with the lesser included offense for we, the jury, find the defendant guilty of attempted second-degree murder, a lesser included offense. Sub-findings, we find the defendant did carry, display, or use a firearm during the commission of the offense. We find the defendant did not carry, display, or use a firearm during the commission of the offense. Then the next lesser included offense, if you recall back to your jury instructions, and this is where they follow through, is we, the jury, find the defendant guilty of aggravated battery, a lesser included offense. If you find the defendant guilty of this offense, you must choose one of the following findings. We find the defendant discharged a firearm causing great bodily harm during the commission of the offense. We find the defendant did actually possess and discharge a firearm during the commission of the offense. We find the defendant did actually possess a firearm during the commission of the offense. We find the defendant did not actually possess a firearm during the commission of the offense. And then we, the jury, find the defendant guilty of battery, a lesser included offense. We find the defendant not guilty, four-person signs and dates. This is the verdict form for count 3. Talent Walker. We, the jury, find the defendant guilty of attempted second-degree murder as charged in the information. We, the jury, find the defendant guilty of attempted manslaughter by act, a lesser included offense. You find the defendant guilty of this offense, you must choose one of the following findings. We find the defendant did carry, display, or use a firearm during the commission of the offense. We find the defendant did not carry, display, or use a firearm during the commission of the offense. We, the jury, find the defendant not guilty. Four-person will sign and date. It's the verdict form for count 4, Rashid Green. Same structure, they'll all follow the same structure. Make your findings by checking in the blank. We, the jury, find the defendant guilty of attempted second-degree murder as charged in the information. We find the defendant guilty of attempted manslaughter by act, a lesser included offense. If you find the defendant guilty of this offense, you must choose one of the following findings. We find the defendant did carry, display, or use a firearm during the commission of the offense. We find the defendant did not carry, display, or use a firearm during the commission of the offense. We find the defendant not guilty. Sign and date. This is the verdict form for count 5, Ezekiel Cooper. We, the jury, find the defendant guilty of attempted second-degree murder as charged in the information. We, the jury, find the defendant guilty of attempted manslaughter by act, a lesser included offense. You find the defendant guilty of this offense, you must choose one of the following findings. We find the defendant did carry, display, or use a firearm during the commission of the offense. We find the defendant did not carry, display, or use a firearm during the commission of the offense. We, the jury, find the defendant not guilty. As with all the others, four-person signs and dates. Members of the yellow jury, your verdict forms are somewhat different as we went over in the instructions. They follow the same structure. You have blanks to make your findings by making check marks in those blanks. This is the verdict form for count 1. We, the jury, find the defendant guilty of first-degree felony murder as charged in the information. If you find the defendant guilty of this offense, you must choose one of the following findings. We find the defendant discharged a firearm causing death or great bodily harm during the commission of the offense. We find the defendant did actually possess and discharge a firearm during the commission of the offense. We find the defendant did actually possess a firearm during the commission of the offense. We find the defendant did not actually possess a firearm during the commission of the offense. We, the jury, find the defendant guilty of manslaughter, a lesser included offense. If you find the defendant guilty of this offense, you must choose one of the following findings. We find the defendant did carry, display, use, threaten to use, or attempt to use a firearm during the commission of the offense. We find the defendant did not carry, display, use, threaten to use, or attempt to use a firearm during the commission of the offense. We, the jury, find the defendant not guilty. As with all of them, foreperson signs and dates. This is the verdict form for count 2, at least the first page of it. Same structure, blanks to check to make your findings. We, the jury, find the defendant guilty of attempted first-degree murder as charged in the information. If you find the defendant guilty of this offense, you must choose one of the following findings. We find the defendant discharged a firearm causing death or great bodily harm during the commission of the offense. We find the defendant did actually possess and discharged a firearm during the commission of the offense. We find the defendant did actually possess a firearm during the commission of the offense. We find the defendant did not actually possess a firearm during the commission of the offense. We, the jury, find the defendant guilty of attempted manslaughter by act, a lesser included offense. If you find the defendant guilty of this offense, you must choose one of the following findings. We find the defendant did carry, display, or use a firearm during the commission of the offense. We find the defendant did not carry, display, or use a firearm during the commission of the offense. That is page 1 of the verdict form for count 2.
And Your Honor, that one above is also the attempted second-degree murder was added back in per your screen.
Oh, okay. Yes. So if you'll look at the screen, members of the jury, you'll see that there's that additional lesser included offense that was not in the verdict form I was holding up for you. It's we, the jury, find the defendant guilty of attempted second-degree murder, a lesser included offense, same structure where you make your finding. If you find the defendant guilty of this offense, you must choose one of the following findings. We find the defendant discharged a firearm causing death or great bodily harm during the commission of the offense. We find the defendant did actually possess a firearm and discharged a firearm during the commission of the offense. We find the defendant did actually possess a firearm during the commission of the offense. And finally, we find the defendant did not actually possess a firearm during the commission of the offense. Moving on to what I have as page 2, the next lesser included offense. We, the jury, find the defendant guilty of aggravated battery, a lesser included offense. If you find the defendant guilty of this offense, you must choose one of the following findings. We find the defendant discharged a firearm causing great bodily harm during the commission of the offense. We find the defendant did actually possess and discharged a firearm during the commission of the offense. We find the defendant did actually possess a firearm during the commission of the offense. We find the defendant did not actually possess a firearm during the commission of the offense. We, the jury, find the defendant guilty of battery, a lesser included offense, or we, the jury, find the defendant not guilty. Foreperson signs, dates. It's the verdict form for count 3, Talent Walker. We, the jury, find the defendant guilty of attempted second-degree murder as charged in the information. If you find the defendant guilty of this offense, you must choose one of the following findings. We find the defendant discharged a firearm causing death or great bodily harm during the commission of the offense. We find the defendant did actually possess and discharged a firearm during the commission of the offense. We find the defendant did actually possess a firearm during the commission of the offense. We find the defendant did not actually possess a firearm during the commission of the offense. Next, we, the jury, find the defendant guilty of attempted manslaughter by act, a lesser included offense. If you find the defendant guilty of this offense, you must choose one of the following findings. We find the defendant did carry, display, or use a firearm during the commission of the offense. We find the defendant did not carry, display, or use a firearm during the commission of the offense. Finally, we, the jury, find the defendant not guilty. Foreperson signs and dates. This is the verdict form for count 4, Rashid Green. You'll be making your findings as with all the others. We, the jury, find the defendant guilty of attempted second-degree murder as charged in the information. If you find the defendant guilty of this offense, you must choose one of the following findings. We find the defendant discharged a firearm causing death or great bodily harm during the commission of the offense. We find the defendant did actually possess and discharged a firearm during the commission of the offense. We find the defendant did actually possess a firearm during the commission of the offense. We find the defendant did not actually possess a firearm during the commission of the offense. Next, we, the jury, find the defendant guilty of attempted manslaughter by act, a lesser included offense. If you find the defendant guilty of this offense, you must choose one of the following findings. We find the defendant did carry, display, or use a firearm during the commission of the offense. We find the defendant did not carry, display, or use a firearm during the commission of the offense. Finally, we, the jury, find the defendant not guilty. Foreperson will sign and date. This is the verdict form for count 5, Ezekiel Cooper. Same structure. We, the jury, find the defendant guilty of attempted second-degree murder as charged in the information. If you find the defendant guilty of this offense, you must choose one of the following findings. We find the defendant discharged a firearm causing death or great bodily harm during the commission of the offense. We find the defendant did actually possess and discharged a firearm during the commission of the offense. We find the defendant did actually possess a firearm during the commission of the offense. We find the defendant did not actually possess a firearm during the commission of the offense. Next, we, the jury, find the defendant guilty of attempted manslaughter by act, a lesser included offense. If you find the defendant guilty of this offense, you must choose one of the following findings. We find the defendant did carry, display, or use a firearm during the commission of the offense. We find the defendant did not carry, display, or use a firearm during the commission of the offense. Then finally, we, the jury, find the defendant not guilty. Foreperson signs and dates. So thank you for bearing with me through that. I know it's tedious. Let's have a few more instructions. One of the reasons we have to do it in this manner is it gives everybody one last chance to make sure everything is 100% correct before these instructions go back with you. And as you can see, that's not always the case, and it allows it to be caught to make sure everything is done correctly. All right, moving on to your final instructions. A separate crime is charged against each defendant in each count of the indictment. The defendants have been tried together. However, the charges against each defendant and the evidence applicable to him must be considered separately. A finding of guilty or not guilty as to one or more of the charges must not affect your verdict as to any other defendant or other crimes charged. Count 1, first-degree felony murder, and count 2, attempted murder in the first degree, are linked in that the crime charged in count 2, attempted murder in the first degree, is an essential element of the crime charged in count 1, first-degree felony murder. You should first consider the evidence applicable to count 2, attempted murder in the first degree. If you find the crime in count 2, attempted murder in the first degree, has not been proven beyond a reasonable doubt, you must find the defendant not guilty on both counts 1 and 2. If, on the other hand, you find that the crime charged in count 2, attempted murder in the first degree, has been proven beyond a reasonable doubt, you must then consider the evidence applicable to count 1, first-degree felony murder. A guilty verdict on count 2, attempted murder in the first degree, does not require a guilty verdict on count 1, first-degree felony murder. You should find the defendant guilty on count 1, first-degree felony murder, only if you find all the elements of that crime, including the essential elements contained in count 2, attempted murder in the first degree, were proven beyond a reasonable doubt. In just a few moments, you will be taken to the jury room by the bailiff. I will add this to that sentence. It's usually more common to give instructions after closing argument. As we discussed before, you're getting them before closing argument. So it's going to be more than just a few moments before you go to the jury room to begin deliberating. That'll be after closing arguments. I'll give some further instructions on that in a moment as well. When you do go back to deliberations, the first thing you should do is choose a foreperson who will preside over your deliberations. I will say that again. The first thing you should do is choose a foreperson who will preside over your deliberations. The bailiffs will give you instructions on how to tell us that you have chosen a foreperson, so we know that that was, in fact, the first thing you did. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It's also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict and to bring the verdict form back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberation should stop until the juror returns. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication such as email or any other means. Do not contact anyone to assist you during deliberations. These communications rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the bailiff. Many of you have cell phones, tablets, laptops, or electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room during deliberations. Kindly leave those devices on your seats where they will be guarded by the bailiff while you deliberate. If you need to communicate with me, send a note through the bailiff, signed by the foreperson. If you have voted, do not disclose the vote in the note. If you have questions, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions, if I can, in writing or orally here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help in your deliberations. These exhibits will be sent into the jury room with you when you begin to deliberate. The clerk will give you some more information about this. If it's an exhibit that could be copied, you will each have your own copy of that exhibit. A couple of things are items of actual physical evidence. Obviously, only one jury can have the physical evidence at a time. If you need to see it and the other jury has it, the clerk can assist with that exchange. In closing, let me remind you that it is important that you follow the law as spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate these rules that we all share. So, before we begin closing arguments, we are going to take a short recess. Red jury, you will hear closing arguments first. Yellow jury, you will hear closing arguments second. So this next part really pertains to the yellow jury. You've heard all the evidence. You've heard your instructions on the law, but you have not yet heard the arguments of the attorneys. That means your deliberations have not begun. So until you hear those closing arguments, you are not to discuss the case with anybody. That includes amongst yourselves, and certainly maintain that discipline and vigilance in making sure that you don't have any exposure to any information about the case. So as soon as the red jury receives their closing arguments, we will bring you out here, you will get the closing, and then you will begin your deliberations. We are going to take a 10-minute recess, so we will come back to court at 11:27, and red jury, yellow jury, you can stay in the jury room. Also, I will have lunch brought in. All right, so members of the red jury, I do have some additional brief instructions for you. An issue in this case is whether Marcel Johnson acted out of duress in committing the crime of first-degree felony murder, manslaughter, attempted first-degree murder, attempted manslaughter by act, aggravated battery, battery, or attempted second-degree murder. It is a defense to those crimes if the defendant acted out of duress or necessity to find the defendant committed the first-degree felony murder, manslaughter, attempted first-degree murder, attempted manslaughter by act, aggravated battery, or attempted second-degree murder out of duress. You must find the following 8 elements. The defendant reasonably believed a danger existed. The defendant reasonably believed the danger would cause death or serious bodily harm to himself. 3, those were 1 and 2. Number 3, the perceived harm of death or serious bodily injury was imminent and impending. Number 4, the defendant did not intentionally or recklessly place himself in a situation in which it was probable that he would be forced to choose the criminal conduct. Number 5, the defendant had no reasonable means to avoid the danger except by committing the first-degree felony murder, manslaughter, attempted first-degree murder, attempted manslaughter by act, aggravated battery, battery, or attempted second-degree murder. Number 6, the first-degree felony murder, manslaughter, attempted first-degree murder, attempted manslaughter by act, aggravated battery, battery, or attempted second-degree murder was committed out of duress to avoid the danger. 7, the perceived harm that the defendant avoided outweighed the harm caused by committing the first-degree felony murder, manslaughter, attempted first-degree murder, attempted manslaughter by act, aggravated battery, battery, or attempted second-degree murder. Number 8, the defendant ceased his criminal conduct as soon as the necessity or apparent necessity for the criminal conduct ended. Imminent and impending means the danger is about to take place and cannot be avoided by using other means. A threat of future harm is not sufficient for this defense to apply. The reasonableness of the defendant's belief that a danger existed should be examined in the light of all the evidence. In deciding whether it was necessary for the defendant to commit the first-degree felony murder, manslaughter, attempted first-degree murder, attempted manslaughter by act, aggravated battery, battery, or attempted second-degree murder, you must judge the defendant by the circumstances by which he was surrounded at the time the crime was committed. The danger facing the defendant need not have been actual. However, to justify the commission of the first-degree felony murder, manslaughter, attempted first-degree murder, attempted manslaughter by act, aggravated battery, battery, or attempted second-degree murder, the appearance of the danger must have been so real that a reasonably cautious and prudent person under the same circumstances would have believed that the danger could be avoided only by committing the first-degree felony murder, manslaughter, attempted first-degree murder, attempted manslaughter by act, aggravated battery, battery, or attempted second-degree murder. Furthermore, the defendant must have actually believed the danger was real. Last instruction. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove his innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by his decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in this case. All right, so both the state and the defendant have now rested their case. You've heard all of your instructions on the law. The attorneys will now present their final arguments. Please remember that what the attorneys say is not evidence or your instruction on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has given its closing argument. State.
Thank you, Your Honor.
Yes.
Members of the jury,
He knew that at some point he would have an opportunity. The person in the passenger seat, Prince Gerard, would have an opportunity. And he waited for that opportunity, the perfect opportunity, to open fire on that red SUV. And when Prince Gerard unloaded 22 rounds into that SUV, Marcel Johnson got exactly what he wanted. Vengeance. Revenge for himself. Revenge for his brother. Revenge for 320. And in that, of course, request for revenge, he did not care who got in the way. Tragically, Prince Holland did get in the way. His life has been ripped away from him. 13 years of age. Jalen McIntyre also got in the way. He was the target. Tom Walker struck in the back by a bullet. Ezekiel Cooper and Rasheed Green have to live the rest of their lives with this traumatic event. Members of the jury, starting with the basics. In order to prove a criminal case, the state must prove two things. One, that a crime was committed. And two, that the defendant committed the crime. Typically, attorneys don't like to predict what is going to be said by the other side. But I can say with pretty high confidence that nobody's going to get up here with a straight face and tell you that a crime was not committed here. I'll take it a step further. I don't think anybody's going to get up here and tell you that the crimes that are charged were not committed. But I anticipate you delivering me whether or not the defendant committed the crime. And even though, again, these charges speak for themselves, I can't take that for granted. Because it is the state's burden to prove to you beyond a reasonable doubt. What I'm going to do is I'm going to run through the main charges, the elements that the state must prove. What I'll do is I'm going to speak sort of in the abstract. We're going to take the defendant out of the equation for a moment. Speak in the abstract as far as somebody doing these actions and how somebody would commit these crimes. Let's start with the first element. Prince Holland is dead. That is not in dispute. That while engaged in an attempt to commit murder in the first degree, nobody caused the death of Prince Holland. And we'll talk a minute about the attempted murder in the first degree, attempted premeditated murder in the first degree. But again, that charge is almost a given because we're talking about, again, 22 rounds being unloaded into a car. Somebody does not do that unless they are trying to kill somebody in that vehicle. They're not trying to scare them. They're not trying to hurt them. They're trying to kill somebody in that vehicle. It was Jalen McIntyre in that vehicle, or juveniles. There's no reason, the evidence does not support any theory or thought that any of those juveniles were the target of this attempted first degree. In any event, we talked about felony murder in jury selection, and what we would call the underlying offense is that attempted murder in the first degree. And we'll talk about again in a moment. Third element the state must prove is that Prince Holland was killed by a person other than the person who was involved in this, and the person who killed Prince Holland were principals in the commission of the murder in the first degree. And I probably got to speak a little bit less in the abstract here. The person driving the vehicle in this instance was a principal of the person who actually killed Prince Holland. And in order to convict the defendant of first-degree felony murder, the state does not have to prove that the defendant had a premeditated design or intent to kill. And again, this applies to Prince Holland, so there does not have to be any proof that the state or that the persons that were responsible for this intended to kill Prince Holland specifically. Again, obviously, as to the charge of attempted first-degree premeditated murder, the state does need to prove that intent. As to count 2, to prove the crime of attempted first-degree premeditated murder, the state must prove the following 3 elements beyond a reasonable doubt. And again, taking the abstract, somebody intended to commit the crime of first-degree premeditated murder. That person committed an overt act toward the commission of first-degree premeditated murder that went beyond mere preparation. And so, just to take 2 steps back here, again, we have an individual who is driving a vehicle from which a passenger is firing off 22 rounds at and into an SUV. As far as count 1 is concerned, the evidence that you have does not contradict that or show that there was not an intent to commit premeditated murder in this instance. And of course, these individuals drove a vehicle, they pulled up on somebody and fired rounds. Obviously, there was an attempt there. There was an overt act. And that the person failed to complete the first-degree premeditated murder. Now again, make sure we parse this out. This applies to Jalen McIntyre Burroughs. And they did fail. They failed to kill Jalen incident. Going further, if the state had proven the actual murder, if Jalen had died, the state would have had to have proven beyond a reasonable doubt that he was dead. That the death was caused by the criminal act of this abstract person. It's the argument here, the person was driving a vehicle, the person shot into that vehicle, the person driving the vehicle assisted and aided. And that there was a premeditated killing of Jalen McIntyre Burroughs. Beating a dead horse here, but again, 22 rounds. There's no other reasonable explanation as to why somebody would shoot 22 rounds. Now to counts 3, 4, and 5. Attempted second-degree murder. This applies to Ezekiel Cooper, Rasheed Green, and Talent Walker. And to prove the crime of attempted second-degree murder, the state must prove the following 3 elements beyond a reasonable doubt. A person intentionally committed an overt act that could have resulted in the death of Talent Walker, but did not result in Talent Walker's death. And then you can exchange Ezekiel Cooper and Rasheed Green in there. And that's why that count 1 is worded the way it is. The act was eminently dangerous to another and demonstrated a depraved mind without regard for human life. We'll get to that definition in a moment. Called legal jargon. And lastly, the act went beyond mere preparation. This act absolutely, very clearly went beyond mere. So an act that is eminently dangerous to another and demonstrates a depraved mind is that if it is an act or series of acts that a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another. So even though these individuals intended to kill Jalen and did kill Prince Holland, as it applies to the 3 surviving juveniles, the fact that Prince Holland died shows that this is an act that would reasonably be believed to lead to death or great bodily harm. Serious bodily injury. The act is done from ill will, hatred, spite, or evil intent. The actions speak for themselves. This was an infringement act. This was not an act of, oops, my gun's going off 22 times. This is an act that was done intentionally with ill will, evil intent. It is of such a nature that the act itself indicates an indifference to human life. And human life was lost here. The person shooting in that video did not care that person was did not care that these 3 juveniles were in. Convicted defendant of attempted second-degree murder, it's not necessary for the state to prove the defendant had an intent to cause death. So again, there does not have to be any intent whatsoever that the person firing this vehicle or firing these shots, that the person driving the vehicle, there's no proof, there's no need for proof that they intended to kill the 3 people who did not die and were not the target of this premeditated murder. All right, so the judge went through these lengthy lesser included offenses, and I'm going to spare you. I'm not going to go through all of these Because again, this is a situation about whether these defendants committed the act, not whether these acts were committed, not whether the state has proven that these acts were committed, that these crimes were committed. So what lesser included are, again, are just basically charges or crimes that the main charge has several elements. These lesser included essentially are missing maybe one or more of those elements. They're sort of subsumed into the main charge, if you will. So for first degree felony murder, the lesser included is manslaughter. For attempted first degree premeditated murder, the lesser included are attempted second degree murder, attempted manslaughter by act, aggravated battery, and battery. And for attempted second degree murder, the lesser included is attempted manslaughter by act. And one thing that I'll point out, as you saw on the verdict form, is that there will be also a choice that you have to make whenever you are making your findings. We'll have to make a finding as to whether or not the defendant was in actual possession of a firearm, whether that was discharged, and whether that discharge caused death or great bodily harm. That's not on all the charges, but on some of those charges. That will be a finding that you have to make if you find the defendant guilty on some of those lesser included. Okay, so, like I said, that brings us to where we're really here, why we're really here. What did the defendant commit the crime? What I'm going to show is just a brief outline of what I'm going to show here. It shows that this defendant absolutely committed a crime, intended this crime to be committed. So first off, Mr. Johnson had motive and intent for this crime to occur. And that will come, I'll explain that, why that's important in a moment. The cell data and the surveillance demonstrate that this was an incident where the defendant intended for this act to occur. And of course, you have the defendant's confession, his own words that demonstrate that this was something he intended to occur. So before I get into the evidence, one last thing I want to touch upon regarding the instructions. Talked about this in jury selection. The example that I used was the driver of a bank robbery. Even though that person doesn't even go to the bank, they can be found guilty because they aided in the commission of the bank robbery. Well, just as that is the case with that example, this defendant was the driver of a vehicle, an individual in that vehicle who committed a crime, and he aided that individual committing the crime by driving him to the location where the crime occurred. You'll be instructed that if the defendant helped another person or persons commit or attempt to commit a crime, the defendant is a principal and must be treated as if he had done all the things the other person or persons did if the state proved beyond reasonable doubt two things. One, that the defendant intended the crime to occur. And two, that the defendant did some act or said something that was intended to and that did incite, cause, encourage, assist, or advise the other person or persons to actually commit or attempt to commit the crime. If we go back to the abstract, we can say that the person that was involved in this was driving the vehicle and took the person, fired the gun into the SUV. That is absolutely an act that is intended to assist the individual who's actually firing the gun. For attempted first-degree premeditated murder, the state must prove the defendant intended that the killing of Jalen McIntyre Burrs occurred. And again, we're going to get to that in a moment. Now, as to the first-degree felony murder and attempted second-degree murder, it is not necessary to prove that the state proved that the defendant intended the death of Prince Holland, Talent Walker, Ezekiel Cooper, and Rasheed Green. So as it applies to those charges, the state does not have to prove that he intended on those individuals being killed. Keep that in mind, and you'll have instructions back to it. All right, so what evidence have you seen that demonstrates that this defendant had a motive and intent that this crime occurred? Let's start with the background here. The backdrop that kind of lays everything, sets the stage for what happened here. We've heard a lot about 3 and 320. Two groups that don't like each other and have had multiple instances in the years preceding this incident of violence. Starting with the 2019 barbershop incident. It was an incident where Isaiah Pringle, who was Emmanuel Pringle's brother, was shot and permanently blinded. This defendant was also shot during this incident. And for Kobe Johnson's testimony, Jalen McIntyre Burroughs is the person that they suspect of committing this crime. But as you heard through testimony, nobody cooperated in this case. Moving forward to 2022, an individual known as Wicks, who was a member of 3, he's killed. June 2022, Joshua Holmes, who is a member of 320, is killed. And again, per Kobe, 3 was suspected as being responsible for the killing of Joshua Holmes. One thing that I'll insert in here also is just keep in mind is that in January 2022, that is when Kobe bought the Zastava rifle that was used in this incident. After Joshua Holmes, member of 320, is killed, Corey Poole then takes to a rap and disrespects Holmes in a rap, and further inciting this cycle of violence, further inciting 320. September 20, 2022, that's when Kobe was jumped at the car wash fundraiser. He stated that Jalen was there at a distance, and that when he was jumped, Marquise Holloway, who is Jalen's brother, was there and actually was involved in the jumping of Kobe. Kobe suspected that Jalen is the one that alerted these other individuals who came and jumped him that he was there. And as they're jumping him, they're chanting, F Josh, R.I.P. Wicks, according to Kobe. After this happens, and also by the way, Kobe stated that while he's getting jumped, he's also yelling threats to him that basically telling him he's going to get back at him. So after this happens, Kobe FaceTimes the defendant. And you've seen a photo of that, and that's in evidence. FaceTimes him, you can clearly see that Kobe has these injuries that result from this jumping. So now this defendant is aware of what has happened to his little brother. And what you see in 2022 is this violence happening more frequently for something. Because again, the barbershop incident was 2019. And there was an incident at a football game where Kobe got into a fight with Jalen. And they got better on him. But in 2022, for some reason, it seems to ramp up. Kobe also talked about being at a gun range, firing off a gun, and that apparently he claims that Jalen laughed in a reaction on a post or something along those lines at his post about shooting at a gun range. He also talked about how Marquise Holloway, again, the brother of Jalen, was threatening to kill Kobe. And Kobe took that threat seriously enough for him to leave and skip town for a while and go to Tallahassee. He also began driving rental cars instead of the car that he was known to drive. The defendant was also producing rap, and according to Kobe, because of the raps that the defendant was producing, again, this further incited threats from Marquise Holloway. So let's move on. We've got, like I said, we got the background here. We've seen what is leading up to this incident, the back and forth going on here, retaliation going on here. So let's move to this specific incident, start getting into what the state has proven in terms of connecting this defendant and linking him to the vehicle that was driven in this incident. So let's talk about cell data. Calls and location. Well, as you learn, calls to Mr. Gerard start at around 12 p.m. At 3:58 p.m., Bennett calls Gerard after dropping off his grandmother a few minutes afterwards, and he is in a blue Kia Rio. And I'll back up a little bit. You also saw the surveillance footage showing the defendant at around 2 p.m. exiting a building and getting into that blue Kia Rio. Location data shows the defendant traveling towards 7th Street, which is where Mr. Gerard lived at the time. At 4:19, the defendant called Mr. Gerard while pinging at the closest tower to Mr. Gerard's house. And after that call, at 4:19, calls to Mr. Gerard stopped. Now, I'll submit to you that because they were then together at that time. Multiple calls before. And after that 4:19 call, there were only two calls shortly thereafter, the last one being at 4:24 p.m. There's not another call from the defendant until 6:37 p.m. That's to anybody, to be clear, that's to anybody, not just to Mr. Gerard. At 5:45, this defendant's cell phone stops communicating completely with the network. And I know that you've heard testimony or claims that could have been due to the phone being dying, being low battery and dying. And perhaps that happened. I'm not going to sit there and pretend that I know what happened in that situation. But what we do know happened is that after that 5:45 point, his airplane mode was turned on. We do know that. For some reason, cell data doesn't document whenever airplane mode is turned on, but it definitely does document it when it's turned back off. 6:15, the only other activity you really see on the defendant's phone is brief access to maps. Murder happens at 6:19 p.m. And then the phone is then turned on again 15 minutes after the murder. And more importantly, airplane mode is then turned off. Members of the jury, that is called what we call consciousness of guilt. Somebody that is doing something to try and hide evidence or because they are guilty of doing something wrong. In that cell activity, indicative of his intent, that is, he's doing these things because he knows that he is about to participate in this crime. It's not just coincidences. He's not just a very unlucky guy. He's doing these things because he knows that he and Mr. Gerard are about to go looking for Jalen McIntyre Burroughs. He does not want to be tracked. He does not want to be shown to be at the crime scene. Let's talk about surveillance. Again, I mentioned we see the defendant get into the blue Kia Rio around 2 p.m. Fast forward to the footage off of Sutel Drive. You see, again, the red SUV coming down Sutel, heading towards Moncrief. And one thing to point out is you learned through testimony again that Jalen's brother Marquise sometimes drove that SUV. Jalen was driving it on this occasion, and he had, again, the 4 individuals with him, leaving this football tryout or practice. Within 10 seconds, and from the distance, you see the blue car come to the picture. You see it come off a side road and turn onto Sutel Drive. Start driving at a pretty fast rate, frankly, following behind the red SUV. Now, this is not part of the plan for the defendant. An ambulance shows up and causes Jalen to pull over, to try and stop, causes this other vehicle to not know what it's doing and awkwardly kind of drive in the middle of the road. And then there's an accident a little bit further down that causes Jalen to have to stop and wait. And what you see in the liquor store video is you see the SUV sitting there. You see the defendant's blue Kia Rio sitting there. And because it had passed the SUV. And it's just sitting there waiting. It's almost like you can feel like they don't know what to do. And then you see this red SUV pull up next to the vehicle. And they're literally right next to each other. And again, it's almost palpable, the awkwardness. You see the blue Kia kind of pull off to the side, going to the parking lot. You don't see where it goes, but Detective Mittling, one of the detectives testified that basically where that car went, there was a side road that feeds right back onto Sutel Drive. What you see after that point is the Walgreens footage. See, again, what you can kind of see from, coming down Moncrief, coming at you, going behind you, and crossing over in front of you, you see Sutel Drive. And you see the red SUV sort of pull up and slow down because the oncoming traffic is coming down Moncrief Road. And then at 6:18, there's the footage of the murder itself, taken from a gas station. And, I encourage you to look as much as you need to. But you can make out who is who from a distance whenever you watch that footage. And what you see is that the white Charger that's at issue, we'll talk about that in a second. That white Charger that's been made an issue pulls up and is in front of the red SUV. As a matter of fact, it's in front of that red SUV at all times. And then you see the red SUV coming up, you can make it out by the fog lights on it. It pulls up, and then you also see two headlights to the left of it coming up at a faster rate, and you see one of the muzzle flashes. But you clearly know that something's happening because from the footage, people start kind of ducking, that you can tell that they're hearing the gunshots going off. Then, of course, Mr. Olds, who's just trying to protect his family, books it, takes off. So this is the footage we're talking about. And again, this pauses automatically, so I'm not going to be able to keep it paused. But again, you see the white Charger coming up to the light, stopping in the middle lane where you can go straight on Moncrief. See this car coming, turning onto the right, Kings Road, and that car in the back there with the fog lights on, that is the red SUV. You see that pulling up. And what you see from there is you can see the car on the left pulling up beside it. There's the muzzle flash. See the white Charger take off. And you can't see it actually happen, but behind that post is where that blue Kia Rio cuts off somebody going straight and comes down New Kings Road. So, that white Charger been made such an issue. But it does not make any sense for that white Charger to be involved. And the evidence excludes, it literally excludes this white Charger from being involved in this incident. Practically, at least. Nobody knows who Jacob Olds is. Toby Johnson was asked, no idea. Yeah, I actually had to ask Mr. Brown, who are you talking about? Daniel Pringle, no idea. Jacob Olds is. He's not somebody that's been in any of these rap videos. He's not somebody who is related by blood or close friendship to somebody who was shot or had violence done to them by three. Why? And if he's involved in this, why would he be there? And I asked that question because, as I stated earlier, he is in front of the SUV at all times. We know that the SUV was struck with gunfire from behind. There are 3 or 4 gunshots to the back of the SUV. It is impossible. Unless somebody has a magic bullet in that white Charger, it is impossible for that person in the white Charger to have done that shooting. And we know that the shooting was all done from one gun. That gun is a stop. That's because Megan Sarnak with FDLE came in and told us. She compared them. They all matched. They all came from the same gun. So it's not like some came from one end, some came from another end. These all came from one gun. And it is literally impossible for the person in the SUV, in the white Charger, to have conducted a shooting. So what in the world is he doing there if he's somehow involved in this? Is he on a walkie-talkie talking about, hey, they're coming up? Well, we know that's not true, and the reason being, we'll get to that in a second, and what actually we talked about. So the reason being is that this footage, again, that is from the Walgreens at the corner of Sutel and Moncrief. Again, I encourage you to watch this as much as you need to watch it. Because what you will see is the victim's SUV pulls up. There's no other cars right behind it or anything at that moment. It stops because the oncoming traffic is coming down Moncrief Road. And all of the cars coming down Moncrief Road, all those cars coming down Moncrief Road in front of the red SUV are coming from Moncrief. They are not coming from Sutel. So unless one of these vehicles that has been made at issue has some sort of magic device where they can predict where the SUV is going to come from, there's no way that they are involved. They're just coming from Moncrief. There's no way they can know where the victim vehicle was. There's no way for them to know that. And again, you watch this video, and every single vehicle you see in the rec center video, every single one of those is a vehicle that's crossing over Moncrief, except for this car that's turning out of Walgreens. That's the only other vehicle that ends up behind the red SUV. So again, that excludes any of those other vehicles being involved. The only vehicle that you see continuing to follow the red SUV is a vehicle being driven by the defendant. Again, you got the video from the rec center, you see the white Charger just go by. Literally 7 seconds after the white Charger goes by, that's when you see the SUV. If he is trying to monitor the SUV in some fashion, he's doing a really, really bad job of it. But right behind it, you see that blue Kia Rio, right on its tail, ready to make its move. And so at the end of the day, the white Charger, I call that a red herring, something to distract you from the evidence that you really need to pay attention to in this case. And Juwan Thomas, he's another one. He's another red herring. Juwan Thomas was not involved in this incident. You have a statement on social media 37 minutes after the incident. Why would somebody immediately jump on social media and incriminate themselves? Something where they know it's going out, everybody can see it, and incriminate themselves and say, I think I did it, yes I did. But I'm not going to stand up here and pretend that there aren't some sick individuals out there that would claim responsibility for a 13-year-old's death, because there are. There are other individuals out there, and Mr. Thomas demonstrated that he is one of those individuals. Because at a later point in time, he did say something whenever somebody asked him about the shooter. He said, well, you might be talking to him. He was not the shooter. The reason why we know he's not the shooter is because they still treated it as a lead in the case. They didn't just ignore it, as the defense might want you to believe. They did not just ignore Juwan Thomas. They looked into Juwan Thomas. Detective Mittling testified that he still investigated it. He found no known numbers that could be confirmed as belonging to Juwan Thomas. One number that he could find, or that they somewhat connected to him, showed that that phone was in a different location from the crime scene at the time of the crime. Detective Mittling looked up his family, his friends, any close associates that might have a blue Kia Rio or blue sedan, and found nobody that had a blue sedan to which the defendant, or excuse me, that Mr. Thomas would have had access. He made no confirmed connections from Juwan Thomas to this crime. And to also kind of put it in perspective, at the same time, while he's investigating Juwan Thomas, he is also following leads on this defendant. And part of those leads involves the defendant's cell phone records that show his phone call, Mr. Gerard, shortly before the murder happened. So that is a lead that they followed based on that. So they're following up on these other leads. And then, of course, the defendant confessed. He admitted to being the driver. What kind of use of police resources would it be if the defendant admits to being the driver of the vehicle, tries to point the finger, and they say, well, you know what? Even though he told us he did it and he had something over it, let's keep investigating this Juwan Thomas character. Let's keep pouring resources into that guy. And we have no reason to believe he's involved. Again, distraction, red herring. So it's moving further with the cellular data. Next activity that we see on the defendant's phone is being powered back on and airplane mode being turned off. And as I stated earlier, it doesn't show when it's turned on, it does show when it's turned off. So we know that it was turned off at some point between 5:45 when it stopped communicating with the network, or at 5:45 exactly, perhaps. But at some point after 5:45 at least, it stopped communicating with the network and airplane mode was turned on. I know that because it was then turned off at 6:36. You have the phone call at 7:50 where Mr. Gerard calls Kobe. Kobe and Emmanuel Pringle go to Gerard's house. And the location data for the cell phones is all consistent. It shows these three individuals congregating at the defendant, or at Mr. Gerard's house. And I know there's been some, questioning being made of, well, we can't say exactly where we can't pinpoint the exact very location that they are. And that's true. I'm not going to sit there and claim that's not true, but you have phone calls to these individuals, and phone calls previously between these individuals. It does not make any reasonable sense to conclude that they were not congregating together, that they were not together at Mr. Gerard's house. And on top of all that, Mr. Pringle's GPS shows him there too. So we know that they all gathered and met at that location. And that's consistent with all of the evidence that you've heard. They all met up in Mr. Gerard's house. Also consistent is that they then, from there, went to a friend, Pete's, a guy that cleans cars. Why on earth would they do that? Well, they just need to clean the car, apparently. Well, no. They're going to get the car cleaned quickly because they know what they just did. The defendant had Kobe take the car back to his grandmother's, but because Kobe was driving his own vehicle, he had Emmanuel Pringle drive the blue Kia Rio. At 8:18, they all again congregate at the park, which is consistent with the records, it's consistent with the testimony. When this happened. During this incident, Travius Gerard brags Emmanuel Pringle, Kobe Johnson, that he sprayed that bitch up. Think about it for a second. Why is he bragging those two people? Because Emmanuel Pringle's brother is permanently blinded, shot in 2019. Because Marcel Johnson, the defendant, was shot during that incident. These are people that he wants them to know he got vengeance. Now, as far as Kobe Johnson's involvement, first denied everything. And it's not uncommon, not unusual to hear that somebody that may be affiliated with activity might deny being completely involved and deny any knowledge whatsoever. Claims he didn't know anything about the barbershop, or didn't say anything about the barbershop at least. Didn't say anything about this stopping a rifle, didn't say anything about being jumped. Complete denial across the board. He did not want to be involved, he did not want to be a snitch. Now, when he took the stand, at no point in time did you hear him say, I lied when I said that defendant, or that he heard Gerard's statement about spraying that bitch up. At no point in time did he say that. He said he felt pressured to say what they needed me to say. And perhaps he did. He was subpoenaed, forced to show up. And we needed to hear the truth. So yeah, he was forced to show up and tell us the truth. His attorney was there. This talk about him being threatened or feeling threatened or pressured, he had an attorney there with him. As Mr. Grau pointed out on cross-examination, there's no, an attorney being there, a cop or a police officer is not going to blatantly pressure a witness in front of an attorney, a barred attorney. That's not going to happen. There's been some talk about a probation officer also maybe giving some pressure. Probation officer does not care whether or not Mr. Johnson is involved. Their job is to monitor people. Their job is to make sure people show up for things. They're not there. They don't care. They don't have a dog in the fight, so to speak. He said something about somebody telling him what Emmanuel Pringle said. We know that is absolutely false because Emmanuel Pringle was not interviewed until a month after Kobe Johnson gave his statement. There's no way that anybody could put any sort of statement in front of him and said, this is what Emmanuel said, what do you say? It didn't happen. That didn't happen in that order. This is coming from Kobe Johnson. This is from his own memory as far as what happened. But this also demonstrates his attempt to distance himself from what he has done. He knows he got the defendant in trouble because he implicated Mr. Gerard. But he is trying to backtrack now and say, well, I felt pressure, this, that, and the other. It's not consistent with evidence. It's not consistent with common sense. During his testimony, that said nothing about playing Grand Theft Auto. I want to talk about NBA 2K in a football game. And that becomes important when it comes to Mr. Pringle's statement. And the question is, why would he implicate it? Why would he make up this statement and attributable to Mr. Gerard? Why would he do that? There's nothing for him to gain. The idea is that for some reason he felt compelled to implicate it. But if he felt compelled to lie, why not pick just a random Joe? Why not pick a Drop or a Slim or some other person that doesn't have the kind of connections that Mr. Gerard has to the defendant? It makes zero sense for him to completely pull this statement out of thin air. More importantly, why add the part about seeing Prince's head hit the window? Why? That adds nothing. And so he has nothing to gain by fabricating that. He's already testified about the statement. If all he has to do is come in and say, yep, that's what I said, see you later. That's all he had to do. But no, in that proceeding, he added that part what he heard. And there's no reason for him to have done that. Other than one reasonable explanation, and that is because he was placed under oath. Now, Emmanuel Pringle, same situation. He did not want to be here. You can tell it by his testimony, you can tell it by his plain words. He did not want to be here to testify. Again, at no point in time during his testimony did he say, I lied about what I heard. Also, he never said anything about hearing anything, he never said anything about Grand Theft Auto or playing Grand Theft Auto when he first spoke to police. He talked about the statement made by Mr. Gerard multiple times, but not at any point in time did he clarify and say, but we were playing Grand Theft Auto, and that's what we're talking about. He didn't do that until he was deposed and when he came in here and spoke to you. And let's just think about that concept briefly. And that is, does it make any sense whatsoever for grown men to go to a park and brag about a video game, what they did on a video game? I don't play video games myself, but I know common sense. That makes zero sense for people to gather and brag about what they did on a video game. And again, why implicate Mr. Gerard? Consider him his brother. And then he knew that he got Mr. Gerard in trouble. That's why he came in and tried to say that they were playing Grand Theft Auto, and that's what he was talking about. All right, I know I got a little sidetracked there, but let's go back to, and that's just to kind of show you the connection between the defendant and Mr. Gerard and what they did together. Because again, you have the evidence showing that he went to Mr. Gerard's house, that they were together, and at some point after that point, the murder happened, 6/19. So what other evidence do we have that this defendant had the intent, the motive for this crime to occur? Well, we also know that he had the opportunity, because you saw the video where he has the Zastava style rifle. And as Kobe testified back, that he bought it in January 2022, but when he went to jail for something, somebody stole it. Somebody had his Zastava rifle, and he doesn't know who had it. We know who had it. It's his defendant. We know the murder was committed with Zastava because of Ms. Sarnak's testimony. Firing and creating a unique ring around the casing. Never fired from the Zastava. Holding this rifle in the video that we saw, and that you'll have if you want to watch. Got to get ahead of myself, apparently. So we talked about how he bought the Zastava, and said now the last time he saw it was in August of 2022. He did admit, however, that he saw the defendant with the Zastava once or twice. So, again, this rifle belonged to, it technically belonged to Mr. Johnson, Kobe Johnson, but the defendant clearly had taken possession of the rifle and had it. So this rifle did not belong to Mr. Gerard. The defendant brought this rifle to the table, and that again is part of what proves that he intended on this happening. He brought the murder weapon to the murder. That's not proof of what he intended on happening. I don't know what is. And how do we know he had that murder weapon up to days before the murder occurred? Because you have a photograph that was pulled from his phone. A photo that was created on November 29th, 2022. Again, a mere days before the murder occurred. Then, of course, we have his confession. And as you saw, picks up where he's speaking to detectives. He asks to see them, asks to talk to them. And when they start questioning him about, all right, why'd you want to talk to us? He just begins telling a similar version of events as before. Slim and Drop somehow got his vehicle after telling him to go to the store or something. And that Slim and Drop disappeared with the vehicle for some time until they came back at some point, like an hour or so later. And he gives this completely detailed account of what happened on December 3rd, 2022. Down to the turns that he made at points, who he spoke to, what he did. Don't remember anything in detail about the next day, December 4th. For some reason, December 3rd, he was able to give details of that. About that following Sunday, he had nothing to give. So what we had here was statements being made over and over again by the defendant, being refuted, being shown evidence by Detective Mittling, contradicting what the defendant was saying in the interview. And he keeps changing and adding details to try and keep up with the evidence that keeps being shown. But it's becoming clear to him that that ain't working. He's not able to talk himself out of this. So he finally confesses. Finally comes clean what happened. And when you'll notice that whenever he starts talking about what happened, it flows. It flows freely. He's not, the detective is not leading him. Detective's not saying, did this happen, right? Did that happen, right? Right. The defendant is just flowing with the information. The detective is just saying, well, what next? What then? It wasn't like what before, whenever he would say something and the detective would ask him a question and he'd say, huh? What? And would repeat the question, things like that. He discusses the events leading up to following the SUV, talking about meeting with Gerard at Gerard's house. He said that Gerard had an agenda. He wanted to kill Jalen. Said that they discussed, or at least Mr. Gerard discussed the plan, but they were both discussing the plan and how they're going to affect this. Discussed following the SUV, and then they actually do begin. They go back out to, or they go out to Legends Field where they had seen the vehicle before. They started following it, and according to the defendant's interview, he's feeling this pressure that Mr. Gerard is pressuring him into it. He's driving along, and that Mr. Gerard is just telling him things, trying to encourage him, or again, pushing him into doing this, as if he's not the one that brought the rifle to as if he's not the one that's driving his grandmother's vehicle. And he claims that he got sort of cold feet, tried to act as if he lost the vehicle. But that didn't work either, supposedly. And all this time, first off, the gun was already in the vehicle, as he admitted. And at some point, Mr. Gerard puts the gun between his legs, ready to go. And he said that Mr. Gerard then just opens fire. The evidence does not support that. Like I said before, all statements flowed freely. The evidence does not support that version of events. It shows the defendant driving that vehicle methodically, following, stalking, and at one point having to figure out what the heck to do once he caught up and passed the SUV. That's what the evidence shows. That's not somebody who is feeling pressured doing something. At no point in time during the interview did he say that Mr. Gerard threatened him or tried to say, if you don't do this, then I'm going to, shoot you as well. Nothing along those lines. Never at any point in time. Never pointed the gun at him. No point. Let's talk about this confession. And let's be clear here. I'm moving towards voluntariness of the confession because the questions posed to Detective Midland imply that this was something that was forced out of the defendant. So now it's gone from, I didn't know this was going to happen, to now, I falsely confessed. I was forced to confess this. That's what we're dealing with now. And so that's why I'm going to go into the voluntariness of this. So, his confession, voluntary and uncoerced. This was the second interview. The defendant knew what to expect. This was not like he was ambushed, dragged in from somewhere, and this is the first interview without anything, like having no idea how it goes. He knew exactly how it was going to go. Despite that, he initiated the interview. He reached out and said, I got something I want to say. He acknowledged his rights again. That commitment made sure that he saw the form again, he read it again, signed it again. He knew his rights at that point in time. He's a 22-year-old man. This isn't some 14-year-old juvenile being pressured by two mean, big, bad adults. This is a 22-year-old man in there being interviewed. He said he's been sleeping fine. Even when the detective gave him a chance and said, you haven't been sleeping well, have you? He said, yeah, I've been sleeping fine. I might do some medication, but the bottom line is he's not sleep deprived, he's not in some vulnerable state. He's completely fine. Interviews at 1:30 p.m. And I point that out because, again, this is not some situation where they drag him out at 3 o'clock in the morning with dead sleep. Say, all right, tell us what happened. What do you want to talk about? This is in the middle of the afternoon. There's no kind of, tactic here to try and get him to say something he didn't want to say. The confession happened about an hour and 15 minutes of that interview, that second interview. This is not a situation where this was dragged out for hours on end, where the defendant is just finally just caving to this never-ending questioning. And yeah, at one point in time, Detective Dravick does say, Dravick says, we're not going to stop. And that, to you, what that means is we're going to keep investigating this. We're going to keep getting evidence. And he even kind of corroborates that at some point by saying, you know, either jump on the train or not. So again, paraphrase, but either get on board or not, because we're not going to come on and talk to you once we have more evidence, once we've got something strong. Or even strong. No threats or physical acts. I had some light touching, that is something that detectives do during interviews. But he's not being roughed up, not being held against his will. They're not just completely, at times they raise their voice, yeah. This is not a constant, never-ending berating. And again, there are no threats whatsoever that are made to him. If you don't confess, we're going to do X, Y, Z, nothing like that. As I stated earlier, there's no leading. Detective was letting this flow from the defendant without giving him the information that he wanted to hear. It was just what next? What next? The only thing that doesn't make sense is he admits to, early on when he talks about, he admits to that it's his grandmother's vehicle that was used. So yeah, it was my grandmother's vehicle, and admits that it was his brother's Estado that was used in crime. Was that coerced? None of it was. One thing that I'll point out about the interview is that even though he comes clean and admits to driving the vehicle being driven by, or driving the vehicle that Mr. Gerard shot from, he still stopped short of admitting, again, that he knew this was going to happen. And the reason he does that, and it's because of his inability to admit what he can't deny and deny what he can't. That's the saying we have in our world. Admit what you can't deny what you can't say. So finally he realized that he had to admit what he couldn't deny. He was the driver of that vehicle. The evidence, again, Detective Midland was feeding the evidence. He knew that eventually he had to admit that he was the driver of that vehicle. But he maintained and denied because he could not admit that he knew that this shooting was going to happen that ended up killing 13-year-old Prince Holland. That's why he did not go that final step of admitting that he was involved in this purposefully, intently. So let's talk about this video that happens, that's seen on December 5th with the defendant.
Mr. Powell, I'm going to get you to pause just before you start talking about the video while they open that door. Officer Mills, tell Miss James to knock before she comes back out, and then I'll call for another brief pause. We're all done. All right, that closed all the way? All right, you may proceed.
Thank you, Your Honor. So this video that the defendant posts on Instagram Live on December 5th, this video demonstrates this is not somebody who did not want this crime to occur. This video shows that this was not a coerced confession from somebody that had no involvement in this. This is the video of somebody who's bragging and gloating. We don't need to hear what's said. That's one of the highlights. Trying to be distracted to the movie going on. So during this interview, or not this interview, but this Instagram live.
Bro, you can't. You supposed to be at the hospital or something, dude. Folks ass barely making it in that bitch. Fuck old niggas. Damn. Shit, it's really around the way. It's busting around the way. They say it's busting on 8th Street. Like, you don't got no cube or nothing, so we really can't be talking. You not part of the club, Jet. Get you a cube or go do something to somebody. Till then, you come back talk to the big homies when you do one of those. Till then, he talking about, I think it's an award ceremony. Yeah. At the grave site, nigga. Oh, yeah. If you ain't, your shit ain't, just stay in the crib, bro. That's my best suggestion. Your shit ain't buttoned up, stay your ass in the house. You don't got shit to do with nothing. Phone them grave. If you ain't yeah with the yeah, stay your ass under them roofs. I'm telling you. What you telling? Damn, 3. Thought you would have your way out here. Don't you got a jet? You got a baby on the way or some jet. Go take care of your jet. Pull out of here. You know, got 3. You know how the fuck we coming, man. Missing my homie for him, we get back. Banging 3 smoke out of K, don't do that. Don't do that. Especially if you ain't got no cubing on the back of that bitch. Alright, my brothers, man. Niggas know how the fuck we coming. 320, she's 13, shit.
That's not a video from somebody who was just taken by surprise or upset about Mr. Gerard opening fire without his expectation or knowledge. And as somebody who was proud of what he has done. Somebody who's proud of acting on behalf of his brother, on behalf of 320. Members of the jury, as I stated at the beginning, the defendant knew exactly what he was doing. Knew what was going to happen. In his interview, maybe a talented rapper, he could not find the words to talk himself out of this one. That is why he confessed. That is why he admitted he did. But the confession is only telling us what we know, just like the detectives. It was just telling them what they already knew. Now, that confession is just confirming what you already know. That this defendant is guilty as charged on all counts.
Thank you, Mr. Powell. Recess. Melanie. Recess. Okay. 12:40. Councilor Johnson, you ready to go now, or do you need a short recess? Okay, members of the jury, we've been in just a little over an hour. We'll take a very short recess. It'll be a 10-minute recess. We'll be back at 12:56. Remember, you've only heard part of Yes.
Members of the jury, this has been a long trial. You have seen many witnesses, you've heard many exhibits, seen many exhibits. Now the case is in your hands. I want to begin by thanking you for your attention, your service throughout this trial, because what you do here matters. It matters greatly to my client, Marcel Johnson. It matters to the families involved. It matters to the integrity of our criminal justice system. Now, before we get into the evidence itself, I want to say, by all accounts, Prince Holland was an innocent person, truly a victim. We do not dispute this. We acknowledge this, and we respect this, along with the other victims that were involved with this case. But while we all here grieve for Mr. Holland, that is not why we are here. That is not why you are here. You are here to determine if the government proved beyond all of your reasonable doubts that Marcel Johnson committed this crime. And the answer to that question, based on the law and based on all of the evidence that has been presented to you, is simply no, they have not. Here's the evidence that Marcel committed this crime, members of the jury. A confession. That's where we are. How could someone confess to a crime that they did not commit? I know it's hard to imagine, but I think you can believe this. I think you should believe this. Because when you really think about it, a false confession is simply just a lie. But why? Why would Marcel lie? Your Honor, permission to publish.
This is your last opportunity to speak to us in reference to this, and then the story that gets put on the news in reference to you getting arrested for this, imagine what they're going to think about you over there.
Don't say I did.
Well, then you need to fucking sit in here and tell the true story.
Marcel Johnson killed a 13-year-old kid. That's the story right now.
Everyone's waiting for that story. Everybody.
Why y'all trying to make me the face of it? I didn't.
Because you're not giving us the story. Look at the evidence.
I didn't. I don't get what you asking me. How do I?
You ain't been sleeping well, have you?
I've been asleep. They've been giving me the medicine.
But you ain't been sleeping. Why are they giving you medicine? You ain't been sleeping well, have you?
Yeah.
You've been sleeping just fine. So
I
you're
go
a
to
heartless
sleep.
killer. You kill a 13-year-old.
Bruh, can you
And
stop saying
no,
I'm a killer? I'm
I
not
won't
no
stop
killer.
saying
I'm
that
not
because
no
you
killer.
are. Done.
I gotta save my ass now. Tell the truth. We're not fucking stopping, dude. You better take your opportunity and tell your fucking side before that shit hits. Because then, once that shit hits, we ain't fucking talking to you. Not a chance.
Marcel.
Members of the jury, the state said in their closings a few minutes ago that no threats were ever made. I don't know about you, those seem like threats to me. Detective Mittling, now Sergeant Mittling, after getting a promotion since this investigation, arrested Marcel just weeks after the shooting. He interrogated Marcel 3 times over 12 hours. Do you think Sergeant Mittling isn't investigated in this case? He's in the audience watching these proceedings right now. Absolutely he is. 12 hours. 2 seasoned homicide detectives against a 22-year-old sitting alone in that interrogation room, scared, being told over and over and over again what we just saw. And we heard Sergeant Mitling admit to being deceptive and lying during these interrogations. Members of the jury, the law allows you to consider that when you're back in the jury room deliberating about this case. And after he finally got Marcel to confess, they open the door. What do we hear? Other detectives clapping, celebrating.
Your Honor, permission to call this? Yes.
Members of the jury, I would argue to you that is not the sound of justice. That is the sound of tunnel vision finally landing where they wanted it to. Sergeant Mitling told us after he got the confession from Marcel, he stopped looking for anybody else, no other suspects. That was it. Didn't follow other leads, didn't question other people, didn't verify other stories. And that decision, that rush to close this case, is why we are all here today. One of the most stunning things we heard about during this trial involved Juwan Thomas. The state mentioned Mr. Thomas during their closing. 37 minutes after the shooting, you already heard, posted on Instagram, "If you think I did it, then I did it." We also found out a known phone number that Juwan Thomas is associated with pinged off a tower right there, New Kings Road, the same area as the shooting, within the same time frame as the shooting. There's also a jail call. Sergeant Mitling testified to it, wrote it up in his search warrant, that Juwan Thomas's brother asked, "Who did the shooting?" And Juwan Thomas stated, "You might be talking to," quote unquote. And still, no interview, no search of the residence. They did not question Juwan Thomas. Members of the jury, that is absolutely reasonable doubt, right there. Same goes for Drop and Slim. Marcel told Sergeant Mitling. Drop and Slim told Marcel they would kill him if he said anything. Marcel confirmed to Sergeant Mitling a photograph of who this person was. No interview of this person ever done. Members of the jury, remember the so-called source at the jail who wore the wire. They tried to get Marcel to confess in jail. That backfired. The source met with Marcel several times. Came back saying to Sergeant Mitling that Marcel never confessed to this crime. And the source told Detective Mitling at the time that he believed Marcel was innocent. The government had a source, but when the source didn't give them what they wanted, never used that person again. Another very important piece of evidence in this case, members of the jury, is this Nibin lead. Sergeant Mitling testified 10 months after this shooting, the same firearm that they say was used in this case was used again, while Marcel was already in jail, arrested on this case. Sergeant Mitling found out about the Nibin lead about a month ago, 2 years after this shooting. And what did he do when he learned about the same gun that was used while Marcel was behind bars? He didn't reopen the investigation. Why? Think about that, members of the jury. The very piece of evidence that he says ties this case together, the gun, shows up again while Marcel couldn't possibly have used it or been in possession of it. Instead of re-examining this case, he just ignored it. Why? Because reopening this case would mean admitting that they may have arrested the wrong person. That wouldn't be good. That wouldn't be good for now Sergeant Mitlin. Members of the jury, there is not one person who ever puts Marcel or a blue Kia at the crime scene that night. Not one. Talent Walker testified, seeing a dark or black car cross from the Legend Center that day at the football tryouts. When the shooting stopped, he saw a dark car speed away. He never testified to ever seeing a blue Kia. Jalen McIntyre testified and said he saw only a white Dodge Charger. Never saw a blue Kia, never saw Marcel, never saw the shooting. Nancy Mega, civilian witness who came in here, testified she saw a white Dodge Charger open fire on a red Mercedes SUV and then speed away. So let's pause there for a minute. Every eyewitness who testified never described seeing a blue Kia, never described seeing Marcel, period. Miss Bees testified seeing a blue vehicle drive away from the scene, but she also testified that within that blue vehicle, there were 4 people, 4 juveniles in that vehicle. Every single eyewitness, the people who were actually there, not one confirmed that Marcel or a blue Kia was ever at the scene. Now, we learned that there were 22 shell casings recovered. Half of them went to a private lab to get tested DNA. None had usable DNA. The firearm never recovered in this case. The video surveillance, some color, some in black and white. It does not show a vehicle tag. Does not show a driver or anyone in the vehicle. Does not show a gun. Does not show a shooter. Blurry, very distant. You cannot make out any of those vehicles. That's not proof beyond a reasonable doubt, members of the jury. That is speculation. The government also showed us some Instagram videos. Marcel's holding a gun from 8 months ago. 8 months before December 3rd, 2022 shooting. They showed us a few rap videos. Most recent one uploaded on November 25th, 2021. Over a year before this shooting. Barbershop incident they talked about took place 2 or 3 years before this shooting. Instagram live video. They're throwing everything they can up against the wall and hoping that something sticks. These videos, the state is speculating, stretching, trying to link something vague to Marcel. Nowhere in these videos do you ever hear any of the victims' names. In this case, none of the videos ever identify the date, time, place of this shooting. It's there to make him look bad. Now, members of the jury, think about what they want you to do. Ignore the Instagram confession from Juwan Thomas. Ignore the jail call where Juwan Thomas is saying you might be talking to the person who actually committed this crime. Ignore a cell phone map of Juwan Thomas's associated phone number ping that shows him at the scene of the crime when it happened. Ignore that the same gun was used while Marcel sat in jail. Ignore the lack of eyewitnesses. Ignore the lack of any physical evidence or forensic evidence. Ignore their own lies, their own deceptions, they are asking you to convict a man on belief, not proof, members of the jury. On assumptions, not evidence in this case. This case, the evidence tells you, is riddled with holes and doubts and shortcuts. It's about detectives who use lies, pressure, and fear, not truth and evidence. But justice, it investigates. Justice questions. Justice demands real proof. And in this courtroom, the law demands the same from the state of Florida. Members of the jury, I want to read a brief instruction of the law that Judge Brenham already read to you, and it's about reasonable doubt. Whenever the words reasonable doubt are used, you must consider the following. If after carefully considering, comparing, and weighing all of the evidence there is not an abiding conviction of guilt, or if having a conviction it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt. And you must find the defendant not guilty, because the doubt is reasonable. Members of the jury, it's that pause in your mind that says, wait, I'm not sure about this. That's reasonable doubt. The way I like to look at this sometimes is when I leave for work in the morning, I get out of my driveway, I'm 5 minutes down the street, and I think to myself, wait, did I leave the lights on? Did I leave the garage door open? That doubt that I have in those moments is one which wavers and vacillates. It is not stable. Members of the jury, that is what we have here in this case. Right now, if you have that doubt, that wavers, then your verdict must be not guilty. Ladies and gentlemen, this case is full of noise, speculation, assumptions, and emotion. But when you separate what's proven from what's guessed, you're left with one truth in this case. The government has not proven that Marcel Johnson committed this crime. The detective said to Marcel, you're going to be known for killing a 13-year-old. But in our system, you're not known for what detectives say. You are known for what the evidence proves. And here, the evidence absolutely proves that there is a reasonable doubt in this case. Members of the jury, I will leave you with this. This case, it's not about the state, not even about Marcel, at least not the application of justice. It is about you, the jury. You all took an oath. You swore a duty that to convict, you must find proof without a reasonable doubt. And there are plenty of reasonable doubts in this case, members of the jury. The law requires proof, real proof. And when you weigh the evidence honestly, in this case, there's only one fair and lawful verdict. And that verdict is not guilty. And I ask that you all find my client, Marcel Johnson, not guilty of this crime. Thank you.
Thank you, Mr. Venuti. State, any rebuttal?
Yes, Your Honor.
All right, Mr. Grau, you may proceed when ready.
Thank you, Your Honor. I want to read the beginning part of that instruction that Mr. Venuti gave. He left out the first two sentences, and that is, proof beyond a reasonable doubt does not mean, proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, a speculative doubt, an imaginary doubt, or a forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. And a lot of the things that Mr. Venuti went over through you in regards to the pieces of evidence he brought up are possible doubts. They are speculative doubts. They are imaginary doubts, and they are forced doubts. If you are back there in the jury room and you're saying, well, maybe this, maybe I left the garage door open, maybe this one piece of evidence is this, maybe this, that is not a reasonable doubt. Maybe is not a reasonable doubt. There needs to be more. Well, maybe this. Well, is that reasonable?
Well, no, it's not. Then it's not a reasonable doubt. Maybe I left my garage door open, even though I watched myself close it 5 times. I watched myself close it. I backed out. I watched it shut, and I drove down. And 40 seconds later, I'm like, wait, did I really? Maybe I didn't. It's not reasonable because I saw myself do it. You're going to be known for killing a 13-year-old. So yes, you are telling him, tell us your side of the story. Go back and watch the interview. They're pressuring him or coercing him. They yell at him after every time, tell us your story. Who is the shooter? They don't believe he shot in this case. They believe he's the driver. It's his grandmother's car. That's their presumption. They're not thinking the worst of him, although driving and participating in a drive-by shooting is pretty terrible. They want to know who the second person is that's involved in it. They already know it's him. They know he's involved. They know it's his grandmother's car. They know the motive there. They know it's him. They're trying to get the second person out of it. That is the pressure and coercion. You're going to be known for killing a 13-year-old because we already have evidence against you. We're arresting you for it. We want to know who the second person is. If you're not going to tell us, you're going to be taking the ride on this. You're going to be the face of this. That's who they're in the jail is going to know who did this. That's what the news story is going to say. They're just going to have you, so you're going to be the murderer. So tell us who the shooter is. And what do they get? They get him to tell them who the shooter was. There is no pressure or coercion in regards to him. They're pushing him because he's lying to them. Go back and watch the interview. Sorry to make you go through an hour 13 if you want to, or you can flip through the relevant portions. But watch it. He starts out lying to them. Dropping Slim. Dropping Slim. First of all, the first story, we don't want to play you all the hours of it through it, but the detective testified to it. On December 15th, the first statement he gives is that Dropping Slim carjacked. Forcibly took his car from him. Then he starts to back off of that. Says, well, I was in the car and they kind of got in and they wanted me to take them for a ride. I told them I didn't really want to, and the next thing you know, they were in the car and then they just kind of left. How do they know that's not true? Well, there's no evidence. You heard from Detective McCullough that told you the history of this feud and the links in regards to Free and Jalen and Marquise. There's no links whatsoever to Droppin' Slim for wanting to shoot Jalen McIntyre at all. In addition, they pulled the cell site from Parnell Davis, I believe it was. They did do investigation, and they pulled his cell site. Where was the last known mappable cell site? 1214 LaBelle Street on the west side, south of I-10. Puts him away from the scene of the homicide. Doesn't have him around the Legend Center. Doesn't have him following a vehicle. So they know he's lying. That is the reason why they keep pushing him. It's not like they just have him in there with no evidence, just trying to get him to confess to a crime they have no evidence he committed. They're continuing to push him until he stops lying. Eventually he does. Almost tells the complete truth. Because like Mr. Powell said, admit what you can't deny and deny what you can't admit. Still can't admit that he was 100% in. Still a little bit protecting him. Oh, I didn't really know what happened. I was trying to lose the car. I didn't really know what... Why is he doing that? He's trying to protect himself because he was there. And he went over that he was read his right. He instigated this second interview. And he was read his rights and he still agreed to speak. Because he's trying to make sure he gets whatever story gets out that doesn't inculpate him, that doesn't show him as a guilty member of this. And he gives certain details. He gives the route. He said we took a left out of the Legends, or I think they just said they went down Sutel. They got up to the intersection where the Walgreens and the gas station is, and then to lose them. Gerard said no, they took a right, so they take a right, and then they go down, and the shooting happens. What tray of his phone with him. He's like, no, I didn't see Trey's phone at all. The cell site shows Trey's phone is back and left at Trey's house, giving details that are actually true. Why? Because he was there. If he's going to incriminate himself, the officers are going to force him into a crime not commit. Why is he then going to bring Contravious Gerard into the shoot? Why throw an innocent friend? He didn't do it. Mr. Gerard didn't do it. Testified that Mr. Gerard is the shooter. Conveniently, his cell site goes to Mr. Gerard's house before the homicide. His cell site goes to it after the homicide. And I think, like counsel said, 5:45. I think there's another data session at 6:13. If you go to the data sessions, the 5:45 one and one of the 6:13 one, Google Maps. Why is he accessing Google Maps if he's hanging out with Trey at Trey's house? Why is he putting his phone in airplane at all? 6:15, there's a data session. Airplane mode can't be on. Phone will eventually die. 6:36, he turns his phone back on. Phone back on, manually turns off the airplane. That means that sometime after 6:15, he had to turn it on in the first place. Why after 6:15? 4 or 5 minutes before a homicide, you're looking at Google Maps and explaining it. The state is only asking you to convict based on proof. But we're asking that you not leave your common sense at that door or at that door when you go back to deliberate. They say the lack of eyewitnesses, the drive-by shooting, is not have eyewitnesses. Ducking down or running away. Shots. I'm not going to have someone in the corner saying, I could see into that window right when the gunshots happened and I watched it happen and I can pick them out. Unfortunately, a lot of drive-by shootings are going to be circumstantial evidence cases. Lack of forensics. They analyzed the casings. They showed that they came back to a Zastava. Ms. Sarnak testified that she herself had never actually tested a Zastava rifle in all of her years at the FDLE. They're not very commonly coming across her desk. But she went back and looked, and they have a unique ring around it that shows that it was a Zastava-style rifle. The Zastava-style rifle, there is a Zastava-style rifle owned by Kobe Johnson. What does Marcel Johnson say in his interview? You're in the drop-in slim part. Before he confessed. You're pushing him and say, your gun was used. He goes, well, I'm not really sure. Grandmother's car was used. He goes, yes, not a doubt, grandmother's car was used. Juan Thomas. They did the investigation and they saw the Instagram post 37 minutes after the shooting. At a location that's somewhat nearby where Mr. Thomas lived. What my social media did, started saying, oh, it's over near Juan, maybe he did it. Here's Juan Thomas going, sure. Credit for something I didn't do. Prove I did it. No point, no risk in the crime. I'll get some credit out. 37 minutes. How is he supposed to know who got shot? No ID's been released yet. Went to the scene, everybody ran when they heard gunshots. Random people came to provide aid to Mr. McIntyre. How does he know who got shot? He's just taking credit for a random shooting. But what do? They try to get any number they can. They get numbers they don't even know are actually his. That's how much work they're doing. They didn't just go, oh, can't find a number for him. What about these two? They're kind of related. He may have used them at one time. They're like, can't confirm it. No, they go, sure, let's do it. And they get his cell site. One is pinging at his house, also nearby to the homicide scene. And another one is pinging over near Orange Park. They get his social media, and they go through it. And they cannot find a link to 320, to 3, to Jalen McIntyre, to anyone. So you have him saying, if they say I did it, and a jail call of, well, you might be talking to him. Other than that, he has no connection to a blue car. His cell site hits where he lives. And there is nothing on social media and nothing in regards to the motive of why he would randomly shoot up a red SUV. Where else do you go from there? I guess you could pull him in and say, hey, you shoot up a car? And he goes, no. And then what do? Well, you put the social media on there. Yeah, just bragging on something. You have no other evidence to push like they did with Marcel. In regards to Mr. Johnson's videos, the YouTube videos were before the homicide, so there's not really going to be mention of the homicide. The Instagram Live video is actually more proportionate or appropriate in regards to what happened because he's not admitting to it. Because one wouldn't do that if they actually committed the crime. They know their grandmother's car was used and their gun was used. They were at Trey's nearby the scene. They actually did it. They're not going to get on Instagram Live and be like, yeah, I did that. They say I did it. Yeah, that was me. What he is going to do is, he's going to talk some shit about 3. And that's what he does. You have to remember that the Instagram Live video was on 12/5. Go back to his phone dump on 12/4. He takes a screenshot of the article that shows that a 13-year-old boy was shot. So a day after knowing that a 13-year-old boy was shot, meditating, struggling to breathe. He is saying it's busted up by the hospital. We say 3, go check on your jail. Jail. And why does he take a screenshot of that article? Why? First of all, about 2.5 hours after the homicide, he is on news articles that day. The next day, he takes a screenshot of this news article, and it's not at the very top. You look down, there's no title of the article. It's scrolled down. There's a News for Jack's little advertisement or for themselves on the top, and then there's more text continuing the article. And right in the middle is that there's no suspect and no suspect vehicle at this time. And that he puts it in the group chat. Why? Why? If you look at Marcel's call logs, time he's going to Trey after the homicide, there are no calls or messages. So how do they end up over at Trey? Marcel's friends. How does Drop and Slim meet up at Trey's house to take Marcel's car? Because they're not. Marcel calls Trey. He goes over to Trey's house. And there is motive for both of them on why they would shoot Jake. There's a source. They send someone with a wire to see if he'll go talk about what happens. And what does he tell that source? Drop and Slim did. Tells him the same story that he eventually comes off. And Detective Mitling never uses that one inmate again. Not to say that he wasn't used, and not to say you didn't give me what I wanted, so we're never going to use you again. Now, anybody willing to wear a wire and go talk with someone, they're going to use. The gun, 10 months later, there's a shot spotter call out. No 911 call, no witnesses, nothing. My shot spotter says there's been a gunshot on this street. They go out and in the road, find a case. No one around, no 911 call, there's no witness. Detective Mitling is already in another division. So I guess homicide could have still opened it up and done what? He said at the end, Trey took that gun inside and he never saw it again. Mr. Gerard was not arrested until February the following year. That gun was given away. Now the smart thing would be to break it down and throw it in the trunk river. But also the smart thing is to not go do a drive-up shooting in your grandmother's car. The smart thing is to go burn that car after. So not have it be your grandmother's car in the first place. And Detective Mitling didn't go to cold case until 2024. And so this wasn't something where it's like, hey, I made an arrest, and in January 2023 he gets promoted from solving a big case. Not one person puts Marcel there, other than him, because it is a drive-by shooting. Mr. Venuti, and it keeps being brought in trial, that the witness sees a black car, the witness sees a white Charger. I won't do it again because I did it on redirect. Watch the surveillance video. White Charger is not involved. The dark cars in front and back are not involved. It comes from Moncrief onto Moncrief. But luck that they just happen to be driving, and Jalen and Red SUV pulls in front of them off the suit, telling them, hey, that's the car we've been looking to shoot at. Is that reasonable? No. All of those cars in that line of those 5 cars, 3 of them come from Moncrief to Moncrief. The only 2, if you go back and watch that Walgreens surveillance, is a red SUV turning right, blue Kia right behind it. And I also implore you, go back and watch how quick that vehicle comes out. When the red SUV turns to the Legend Center, how quick that blue vehicle comes out. How when Zoutel flickers, it has actually passed it because the ambulance had the red SUV stop and the blue car didn't know what to do. Kind of kept going. They end up like this. The blue car cuts through the parking lot. 40 seconds tick by. You've seen the video, there's a map that'll come up before. You have Zoutel, and there's this little angle like White Street. Zoutel's right here in the corner. Car cuts through the parking lot. You can easily get right back on the Zoutel. 40 seconds later, the red SUV cuts around the ambulance, and then a very short distance down the intersection, the red SUV is back in front of him. That blue car waiting for it to go by so it could retrack it. And watch it. Watch that Walgreens, how that red car comes in the right lane and turns, and the blue car comes right in the right-hand lane and turns. Actually kind of rolls through the stop as well. No one else at the intersection. There's no coming up in the straight lane. Oh, it's going straight. No, man, it's going right. Take a right. No. Go right in the right-hand lane, right behind it. There's no vehicle tags. He said the car was used in the shooting. There is no doubt my grandmother's car was used in the shooting. But why does it matter that the surveillance didn't get a vehicle tag? The rap videos are from 2020, 2021, I believe, might have been the most recent one in November. In March, Mr. Venuti talks about his Estava video of Mr. Johnson running around and jumping around it. What are we missing? We're missing the post from Marcel Johnson's phone on November 29, 2022. From his phone, a photo of the Estava. Different color shoes and the writing that he put on it. 4 days before the homicide, he is in possession of his Estava firearm. They didn't have any other leads. Yes, they did. They had Juwan Thomas. They looked into that. They had Drop and Slim. They found Drop. They looked at his cell records. What does he say when he gives up Drop and Slim? I don't really know them. I don't have their numbers. I wouldn't be able to get a hold of them after they took my grandmother's car to say, hey, come back. And what do they find in his phone? Drop's phone number. So he's lying in that story. Tunnel vision. Landed where they wanted to land. No, they landed where the evidence took them. They looked at all the pieces of evidence and the large amount of comment pointed towards that man right there. And at the very end of the interview, after working hard to find the correct killer, not just any Joe Schmo, not just making an arrest, they worked hard to find the correct person. And one detective claps and goes, good job. And 12 hours of talking. Well, 12 hours of maybe sitting in that room, maybe not straight of actual interviews. Over the course of 3 days, December 15th, December 22nd, and December 29th. December 22nd one, he asked to come and speak. And what odds that he gives a confession that it is him and Contravious Gerard did the shooting. That a month later, his brother testifies, and Mr. Gerard made the phrase, I sprayed that bitch up. I saw the boy's head hit the window. How does that help Marcel at all? By saying, hey, one of Marcel's closest friends whose house he was at 2 hours before the homicide made a statement about doing the shooting. That won't help my brother at all. That's what Mr. Gerard was bragging about. And I implore you that they probably talked way more about this homicide. They were bragging, celebrating. I wouldn't. You heard testimony in regards to none of them liked talking to the police. Every one of them lied in their first interaction with law. Until they were pushed with subpoena, perjury of actually telling the truth on the oath. With attorneys there telling them, hey, they're going to put you under oath. You say a lie is perjury, you can get in trouble for that. And you get the statements. You get it from Emmanuel Pringle as well in February without the Grand Theft Auto. That Mr. Gerard said I sprayed that bitch up. Matches Mr. Johnson's last story, his actual unforced, uncoerced confession. And let's say you have, let's back it up to drop and sling. Let's say we only get drop and sling, and that's it. The detectives go, you know what, we're fine. Have a good day, send you back. You have him saying that two people stole his grandmother's car to do a shooting of someone they had no reason to shoot up. You have your motive of the two of them. You have the fact that he's over at Trey's house near the homicide 2 hours before. You have the fact that his brother owns a Sestava farm. You have the fact that it's his grandmother's car. You have the fact that 2 days later he's making a Facebook Live video about it. You have the fact that he goes to a car wash after to clean the car, that drop cell site's not at the scene. You have all of that together. As while it might be circumstantial, it is beyond a reasonable doubt that Mr. Johnson shoot the driver of the vehicle, and he did the shooting in this case. Or he assisted Mr. Gerard in doing the shooting. And just to clarify one thing, I know it may have come up, but I know Ms. Sarnak said originally she received 21 to her. That was ultimately something where the 22nd was in an envelope still in the property room and had forgotten to be sent. The 22nd was sent to marry up with the 21 that were already there. So the 22 casings on scene were tested and matched each other. The 23rd comes from 10 months later. That also matches the 22 casings that were originally sent. I can have a moment, Your Honor?
Yes.
So, ladies and gentlemen, when you go back there, I ask that you look at all of the evidence. When you go back there, if there are any talks of maybe this or maybe that, please don't do it as just looking at one piece of evidence by itself. If you're looking at one piece of evidence and saying, well, maybe this was this, or maybe this person was here, then go, well, in addition to this person, this statement, this evidence, and this evidence being considered with it, you still have that maybe. Remember, maybe is not reasonable doubt. Maybe it's just a maybe. Anything. Maybe. You need an actual doubt that is actual and reasonable to return a verdict of not guilty. And in this case, it is clear, as you go through the verdict forms, it is clear in this case is that the highest charge has been proven in each of the cases. We have proven felony murder in the first degree. We have proven attempted first degree premeditation with the fact that a weapon was used. And also the interrogatories you guys are going to have in this case for some of them are going to be that a weapon was carried, used, or threatened to be used, or a weapon was not carried or threatened to be used or used. You also have the principal instruction. So while Mr. Johnson may not have had the rifle in his hands, and convict him of the interrogatory of the used, carried, or threatened to use a weapon in the course of the felony by the fact that he's a principal to Mr. Gerard doing it. And when you have those interrogatories, those second questions of was a firearm carried or used, the fact that Mr. Gerard did it, Mr. Johnson is a principal of that, you can fine for that. And so he has committed attempted murder in the first degree. He has committed 3 counts of attempted second-degree murder, and the evidence is clear is that he was the driver that day. His confession, while maybe being pushed, was not coerced in the fact he admitted to driving the vehicle and put Mr. Gerard in as the shooter that day, in which they were stopping at nothing to get back at the shootings and the beating ups that Jalen either did or was associated with. They did not care if there were other people in the vehicle. They did not care after there were other people. Thank you, Your Honor.
Thank you, Mr. Grell. All right, Mr. Ebersole. Would you identify our alternate jurors, please?
Ms. Stobar, Ms. Birch.
All right, so Ms. Stobar and Ms. Birch, you are alternate jurors. I'm going to send the rest of the jurors back to deliberate. You all are going to be discharged at this time, so that means that you will not be deliberating on the verdict with the other jurors. Can't thank you enough for your time and your attention during this trial. I know it's been lengthy and I know it's been burdensome. Just understand that I do respect and understand everything that it takes to sit on a jury of this nature. I'm actually surprised that we didn't have to use one of the alternates in this case because of its length. We have to use them quite often. If we don't impanel alternates and something happens to one of the regular jurors, then a mistrial happens and the whole process has to start over. So you can see that the amount of time and effort that it takes to do something like this. So Ms. James, if you will escort the alternates out, please. All right, the rest of you will remain seated. As soon as they have cleared the jury room, you will go back to begin your deliberations. Just remember that the first thing that we can be seated, it'll take a minute for them to clear out. The first thing you have to do is elect that foreperson. Ms. James will instruct you on how to notify her when the foreperson is elected. Keep in mind the closing arguments for the other juries, the other jury will be happening at that time. So she'll just come and let me know, and then we can confirm that a foreperson has been elected. That's also for benefit of counsel. State, presumably you will be in your portion of that closing, so there'll be a little bit of an interruption. Also, Mr. Ebersole will bring those jury instructions back with you, and you can make reference to them. Mr. Ebersole, do you need to move exhibits into the jury room at this time?
I can do it once they elect someone.
Okay. Mr. Powell, you'll be doing first open?
Yes, sir.
Okay. Do you need a recess?
Yes, briefly.
John. Ready? All right, members of the jury, you can begin your deliberations. $2 o'clock give you enough time?
Yes, sir.
All right, Officer Thomas, that can give you enough time. 2:05. Mel? How much time?
Check, check.
in this case has become a witness, you should apply the same rules to consideration of his testimony that you apply to the testimony of the other witnesses. So, with that instruction given, State, are you prepared to deliver closing argument?
Mr. Honor, may I please report?
Yes, you may proceed when ready, Mr. Powell.
Contrarious Gerard's words, where I sprayed that bitch up. Words spoken only a couple of hours after he unloaded 22 rifle rounds at and into the red SUV being driven by Jalen McIntyre Burke. He sprayed that up all right. And in his efforts to kill Jalen, he did not care who got in the way. Tragically, 13-year-old Prince Holland had his life ripped away from him at 13 years of age. In addition to Jalen, also Talent Walker was shot. Ezekiel Cooper, Sheed Green have to live the rest of her lives, having gone through this traumatic incident. That's what brings us here today. Now, members of the jury, to prove a crime, any crime of state charge, the state must prove two things. One, that a crime was committed. Two, that the defendant committed the crime. Strange things have happened, but I can say relatively confidently that nobody is going to stand up here and tell you the crime was not committed. Nobody is going to stand up here and tell you that the charged crimes were not committed. What I anticipate is that you're going to deliberate in regards to whether the defendant committed the crime. I'm not going to take it for granted, so the state does have the burden, and it's a burden that we gladly accept. And we do have to prove the elements of the charges that we have charged. So as far as murder in the first degree, and this is otherwise known as first degree felony murder, the state must prove several elements. One, that Prince Holland is dead. That is without question. Two, that while engaged in the attempt to commit murder in the first degree, Marcel Joshua Johnson or Contrarious Tyree Gerard caused the death of three, that Contrarious Tyree Gerard was the person who actually killed Prince Holland. So, just to kind of clarify here, this charge is the felony charge that we kind of discussed in jury selection. It's one of those charges where it's based on an underlying charge. And in this instance, it's attempted first-degree premeditated murder. And that, as we discussed, is a crime that is so susceptible to violence that if somebody dies during the crime, the state can charge first-degree felony murder. And we'll get into the elements of first-degree premeditated murder, because the state has to prove that underlying charge in order to prove the first-degree felony murder. As far as the first count, in order to convict the defendant of first-degree felony murder, it is not necessary for the state to prove that the defendant had a premeditated design or intent to kill. So, again, to clarify, this first count is in reference to Prince Holland alone. So what this is saying is that we do not need to prove that anybody had a premeditated design or intent to kill Prince Holland. The actual attempted first-degree murder will be as the Jalen McIntyre murder. And so to prove attempted first-degree murder, premeditated murder, the state must prove the following three elements beyond reasonable doubt. That Contrarious Tyree Gerard intended to commit the crime of first-degree premeditated murder. Two, that the defendant committed an overt act toward the commission of first-degree premeditated murder that went beyond 3, that Travis Tyree Gerard failed to complete the first-degree premeditated murder. So again, let's talk about these elements here, because this is the underlying charge for the main charge of first-degree felony murder. And what I'm going to do is I'm going to kind of speak about this in the abstract, because we're going to take the defendant out of the equation. We're going to just talk in terms of whether the crime was committed. And in this instance, what we have is 22 rounds shot at and into the SUV. As to the first element, nobody shoots into a vehicle 22 times, or at a vehicle 22 times, without trying to kill somebody inside. They're not trying to scare the people inside. They're not trying to just hurt the people inside. That is absolutely an act that is designed to kill somebody inside. That is a premeditated act, trying to kill someone inside. As far as the second element goes, again, this abstract person committed an overt act for the commission of first-degree premeditated murder. Well, obviously somebody shot 22 times. That was an overt act. 4. And 3, that this person failed to complete the first-degree premeditated murder. And in this instance, again, since this charge is in reference to Jalen is still alive. So the person trying to kill him failed to do that, failed to kill him. So, definition or the instruction that you've already received from the judge in regard to attempted first-degree murder includes a description of what the state would have to prove if we had proven first-degree murder. In other words, if Jalen had died. That would be 3 elements that Jalen is dead. That the death was caused by the criminal act of the defendant. Shooting at a vehicle, without question, criminal act. That there was a premeditated killing of Jalen McIntyre Burroughs. And if Jalen had been killed in this instance, the person firing into that vehicle, at that vehicle, 22 times, was absolutely trying to kill Jalen. Let's be clear on that. Okay, there was 4 other juveniles in that vehicle. Prince Holland was 13, Talent Walker was 11. Nobody's trying to kill those juveniles. Jalen McIntyre Burroughs, and you'll see the evidence as far as why he was the target. He was absolutely the target of the shooting. And so going back to the first-degree felony murder, again, we just have to prove that in the process of trying to accomplish this attempted first-degree murder, Prince Holland was killed. And there are 2 other elements, again, that the defendant committed the act and that he was the one that actually killed. All right. So as to the 3 other juveniles in the vehicle, Talent Walker, Ezekiel Cooper, Rasheed Green, the state has charged attempted second-degree murder. And they all survived, so that's why this is attempted second-degree murder. And what the state needs to prove in order to prove those 3 counts, following 3 elements. We've grouped this into one because it's the same as to each of the 3 juveniles. So as to that, counts 3 and 4 and 5, we need to prove that somebody intentionally committed an overt act that could have resulted in the death of Talent Walker, but did not result in Talent Walker's death. And it's the same for the other 2. And this very clearly is an act that somebody engaged in that could have killed him, because it in fact killed Prince Holland. So they just as easily could have been killed during the shooting. The act was imminently dangerous to another and demonstrated a depraved mind without regard to human life. and for human life. And we'll read this instruction in a second as far as the definition of what that means, because there's a little bit of legal jargon there. Step 3, the overt act went beyond mere preparation. Again, shooting actually occurred. It wasn't just plotting in a basement. All right, so when it comes to attempted second-degree murder, what does it mean when an act is imminently dangerous to another and demonstrates a depraved mind? Well, what that is an act, a series of acts that a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another. And nobody's going to tell you that shooting at or into a vehicle that many times is not reasonably certain to kill or do serious bodily injury. And that it is done from ill will, hatred, spite, or evil intent. Beating the dead horse here, but again, nobody does that. Nobody shoots at a vehicle that many times with a good intent. This is absolutely done out of ill will, spite, evil intent, hatred, and evil intent. It is of such a nature that the act itself indicates an indifference to human life. And fire into a vehicle with multiple people inside 22 times. That is absolutely indicative of a complete indifference to human life. And it's something that somebody does, and their mind says, I don't care who gets hit, I don't care who dies. In this instance, again, we had several people that were hit, aside from, 2 people that were hit aside from the target. And again, to convict the defendant of attempted second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. So that's what separates this from attempted first-degree murder. There does not have to be any intent to kill anybody. Something that is so depraved that it's expected to hurt or kill somebody, but there does not require any intent to kill. All right, you've been instructed on the lesser included crimes of main charges. I'm not going to go through these, so I will spare you. But what lesser included crimes are, as you were instructed, is that they are basically crimes that are essentially subsumed into the main charge. They're crimes that have the same elements but might be missing 1 or 2 elements of the main charge. And so you will be instructed on the lesser included, or you've already been instructed on the lesser included. You will have this back there to read in the event that you want to examine those further. But when it comes to first-degree felony murder, lesser included is manslaughter. When it comes to attempted first-degree premeditated murder, lesser included are attempted second-degree murder, attempted manslaughter by act, attempted aggravated battery, and attempted battery. And then when it comes to attempted second-degree murder, lesser included is attempted manslaughter by act. And one thing that you will be asked to find on your verdict form, do you find the defendant guilty of the main charges or any of these lesser included? And just about all of them, you will be asked to find whether or not the defendant possessed and discharged a firearm causing death or great bodily harm. That will be a finding that you need to find. And there are other options there as well, but it's pretty self-explanatory. I don't need.
You may.
Move the receiver to the USB hub so it ranges. Bear with me.
So, all right. So why are we here? This is the second thing that stands to prove that the crime was committed and that the defendant committed the crime. I'll just lay out an outline sort of format. What the state will show you indicates that this defendant committed the crime committed the crimes that are charged. The state has demonstrated motive, reason for him to do this. They have demonstrated consciousness of guilt. We presented cell data that is corroborated evidence that the state has presented. Then the defendant's own words will be used. One thing to be clear on when it comes to the evidence itself. The state has to prove the elements of the charges, beyond reasonable doubt. The evidence is up to you to weigh. It's up to you to determine what to disregard, what to think that weighs heavily, etc. But the state does not need to prove every piece of evidence beyond a reasonable doubt. So if there's a piece of evidence that you don't think you should regard, that doesn't mean that the state's case is sunk. Really, it's a matter of everything together, everything considered collectively, whether or not the state has met the elements. Make sure I state that before going into the evidence. Let's talk about motive. And for purposes of establishing the motive here, it would be appropriate to kind of lay out the background here. All right, provide a backdrop to what happened. So what we have here, and what you've heard, is that this ongoing dispute between groups known as 3 and 320. These disputes go back to 2019. A barbershop incident occurred where somebody shot at the barbershop, and in that incident, Emmanuel Pringle's brother, Isaiah Pringle, was shot in the head and permanently blinded. Also shot during this incident was Marcel Johnson. Things were kind of quiet between that 2019 and 2022. There was an incident after a football game where Jalen McIntyre Burroughs and Kobe Johnson got into a fight. Not a whole lot until January 2022. And that is when an individual known as Wicks was murdered. He was known as a member of the group 3. Also in January 2022, perhaps coincidentally, perhaps not, Kobe Johnson purchases a Zastava rifle that was used as a murder weapon in this case. June 2022, Joshua Holmes, who was a member of 320, was killed. And as you heard from Kobe Johnson, their thought was that 3 was responsible for killing Joshua Holmes. After Joshua Holmes is killed, Corey Poole, who is with 3, then puts out a rap video where he disrespects Joshua Holmes, deceased individual. And what you kind of see here is, again, like I said, there was an incident in 2019, one in between, but what you start to see in 2022 is sort of an escalation in a sense, more frequent incidents where things seem to be ramping up for one reason or another. Because what you also have after those incidents is in September of 2022, Kobe Johnson was jumped at a car wash fundraiser. Jalen was there, his brother Marquise Holloway was there at a later point in time, and according to Kobe, Marquise was one of the people jumping him. And as he also testified that Marquise Holloway is known as a member of 3. Kobe thought that Jalen told the others or let the others know that he was there, leading to him being jumped. And as he was being jumped, beat up on the ground, he stated that the group was chanting F. Josh, reference to Joshua Holmes, and R.I.P. Wicks was in reference to Wicks, who was murdered earlier in the year. And Kobe also testified that while he's getting beat up on the ground, he's yelling back at them, threatening them, telling them that he's going to get back at them. After this incident occurs, Kobe FaceTimes his brother, Marcel, shows him the injuries. And you've had that in evidence, you're able to see that that FaceTime shot. A couple of other incidents are in background. There was one where Kobe was at a gun range. He was shooting a gun, posted it on social media, whatever reason. He said that Jalen laughed, reacted to the post. He also said that in this post, he received comments where Marquise Holloway was threatening to kill Kobe. And there were other threats to kill Kobe, so much so that he felt the need to leave town. He went to Tallahassee for a little while. He also felt the need to get rental cars. He didn't want to be driving around in a car that people knew he drove. In addition to that, Marcel is producing rap videos, and because of some of the stuff that he's putting in his rap videos, Marquise Holloway is also threatening him. Before weeks passed, he was also making threats towards Marcel. What does that have to do with Mr. Gerard? Well, Mr. Gerard was very good friends, best friends, with Marcel Johnson, who was in 320. The defendant was known as Twin in Marcel Johnson's phone. Twin is a term of endearment for somebody who's very similar, somebody very close to you. That was his nickname in Marcel Johnson's phone. And Kobe also talked about how they were really close. And so one of the motives here is that based on that friendship, the defendant wanted to get revenge for Marcel Johnson being shot in that 2019 barbershop incident. He was also best friends with Emmanuel Pringle. Again, Mr. Pringle testified and said that he considered him a brother. Another reason why this defendant wanted to get revenge, because Emmanuel Pringle's little brother, Isaiah Pringle, got shot and was blinded. On top of this, there was the jumping of Kobe. That's another thing where, again, his best friends, or one of his best friends, younger brothers, got jumped. That's another reason why he wants to make sure he gets revenge in some fashion. He's in rap videos with Marcel, showing that they have this close connection. I don't know anything about it, but I don't think people put just anybody in their videos or any music that they put out. They're close friends. That was this defendant. He was close with Marcel. He was in rap videos with him. Bottom line is as much as the defendant wants to distance himself from 320, he was close to 320. He testified himself that he was good friends with Emmanuel Pringle, 320. He was good friends with Marcel Johnson, 320. Good friends with Kobe Johnson, 320. He was friends with all these members of 320. So yeah, he's close. He is invested in this group and wants to help them do whatever revenge that they might want to get on Jalen. Then there was the testimony from Jalen, the message he saw to Marquise Holloway. This defendant said, better slippers count. As Jalen explained, slip means to basically be caught off guard. Caught with your pants down, however you want to put it. Basically caught without being ready to protect yourself. And I would submit to you that what this message means, that people who are good at evading being attacked or being ambushed or whatever, that they count more. Then, of course, you have the photo of the Zastava on the defendant's iCloud account. And I recognize that this was months before. And also, I'm not going to sit up here and pretend that this indicates that this is a photo he took. We recognize that this was a photo that was on his phone, therefore he could have received it. The bottom line is whether he took it or whether he received it, it shows that he absolutely had knowledge of this Zastava rifle, which is on the right side of this photo. And this is the Zastava rifle that Kobe bought. It's the one that was used in this shooting. What other evidence do we have that ties this defendant in? Well, the calls and location data. Calls from Marcel Johnson to this defendant start around 12 also seen surveillance where he gets into, or leaves the building around 2 o'clock p.m. and gets into the Blue Key. Location data shows that Marcel traveled to 7th Street, which is where this defendant lived. And when he gets to the tower, or he's pinging from the tower that's closest to where the defendant lives, at 4:19 p.m., he calls Gerard. And after that call stopped. Why did they stop? Because they were together at that point. Don't need to call him, he's right there. Multiple calls before, and there were a couple calls after that. Last one being around 4:24 p.m. And then after that, the next call that comes out of Marcel's phone is around 6:36 p.m. About 15 minutes or more after the murder. 5:45, Johnson's cell phone stops communicating with the network. And you've heard testimony about how that could mean that it might have just died, and perhaps that happened. But we know that the phone was put in airplane mode. As I believe it was Agent Blythe testified. It doesn't show, the data does not show, for some reason, when a phone is put in airplane mode, but it does show when airplane mode is turned off. So Marcel's cell phone is communicating with the network up to about 5:45. Granted, there was a brief moment where it was turned back on, or showed usage at 6:13 or 6:15 p.m. access maps. But otherwise, there was no communication with it. We had a murder at 6:19. And then Johnson's phone is turned on again 15 minutes after the murder. And we know that it was in airplane mode because airplane mode was then turned off. Now let's talk about the usage or lack thereof of Gerard's phone. That's because there's been a little bit of an issue made of that. And this is not a damned if you do, damned if you don't situation that counsel told you in openings. But because that presumes there are only two possibilities here. Either that he has it on him or he doesn't have it on. But there's a third possibility. He's at home with the phone. One would still expect to see usage, calls, texts, answering calls coming in. None of that is there. And this data, there's data communication that shows that there was data being uploaded or received. That's not reliable. And I don't want you to think for a second that I'm telling you just to throw it out the window. I'm telling you, if you compare it to the other data sessions that you see on that same spreadsheet, you will see one that starts at about 2 a.m. on the morning of December 3rd and goes until around the 5:15 or so, whatever that time may be. The point being is that the defendant testified that he was asleep when his girlfriend arrived late in the morning of December 3rd. He was not using his phone. So that clearly shows you that that data session spreadsheet does not indicate somebody is actually using it. And that is the only thing that the defense is pointing to, showing or claiming that this is indicative of him using his phone in some fashion. And I'm just telling you that that is something you can disregard because when you compare it to the other evidence, it doesn't indicate anything for you. But what you do know from the data, the cell data, is that he was not texting, not calling, not answering any calls, anything like that. And the reason why we know that this phone wasn't just broken or lost or whatever the case may be is because after the murder, now all of a sudden there is activity. There's a call to Kobe. There's a lot of activity showing Gerard traveling. Another thing you'll see on some of the evidence that you have in front of you regarding this phone is that there's a lot of activity on December 2nd There's a lot of activity on December 4th, but very little activity on December 3rd. So again, the phone stopped showing communication with the network. Then you have surveillance footage. And what the surveillance footage shows is that this blue car was absolutely stalking this red SUV. It is the only vehicle that you see throughout the entire series of videos. I'll show you in a moment what I mean by that. But the point is that this was a vehicle that was absolutely following the red SUV, and that this was them two. This is Mr. Gerard, Mr. Johnson looking for an opportunity to open fire on that SUV. So after you see the red SUV turn out of the Legend Center, or at least coming down Sutel Drive, about 10 seconds later, you see that blue Kia Rio pull off of a side road and quickly accelerate in the same direction. And what ends up happening is sort of unexpected, sure. Because there's an ambulance that is going towards a crash off of Sutel Drive. And what you see from a liquor store video is you see the defendant's vehicle, the blue Kia Rio, sitting there just next to the parking lot of the liquor store. And you see the red SUV come pulling up, meaning that the blue car inadvertently passed the red SUV. And then you can just kind of see the red SUV slowly kind of pull up right next to the blue car. And you can kind of even feel the awkwardness as you see that blue car sort of just peel off to the right, drive through the parking lot, the liquor store, disappears off from the camera. And as you heard Detective Mitley testify, that there is a road there that vehicle could have just gotten on that takes you right back onto Sutel Drive. So the next footage that you see is from Walgreens, and we'll look at that in a second. But that's the Walgreens that is at Sutel Drive and Moncrief Road. And then at 6:18, you have footage of the murder itself from a distance. And what you see in that footage is you see the SUV pull up behind a white Charger. And one thing to point out when we start talking about this white Charger is that the bullet holes for the red SUV, for some of the bullet holes, were found on the back of the vehicle. It was literally impossible for somebody in the white Charger to be the one shooting at this vehicle. And as a reminder, this was 22 rounds from the same firearm, according to Megan Sarnak, the FDLE. This was also 22 rounds that were fired from consistent with his Zastava rifle. It had the little ring around the backside of the casing where the pin hits, which is something that is relatively unique to the Zastava rifle. And she said that those casings all had that. So all of these casings, all of these shots come from the same firearm. So there's no way that one firearm shooting from one direction and another firearm shooting from another direction. That's not what happened here. All 22 rounds came from that Zastava rifle. But there's more about that white Charger. And in that video, you're able to see, and again, it's not easy, but I would submit to you that you absolutely can make out who is who in the video. And we'll see in a second. But what you see is the Kia Rio kind of pulled along the left side, because again, Moncrief Road at that point, at New Kings Road, has 3 lanes. You turn left, you turn right, and go straight. The red SUV is in the middle lane to go straight, and you can see the headlights of the Rio pull up along next to the SUV. And very shortly thereafter, you see muzzle flash, one of the muzzle flashes at least. Then you see the cars speed off. So, when we look at this video, again, we already have 2 vehicles that are in the middle lane waiting for the light to turn. one vehicle that is coming to the middle lane, and then behind that, see the white Charger. And you can make it out. It's white. I mean, it's not completely not visible. You see that car pull up behind. And then what you see in the distance behind, with the fog lights, is a red SUV that begins pulling up behind the white Charger. And then from here, again, I encourage you to look at this as much as you need to, but from there you see one car pass to the right, and one car come up on the left side, and then you see the muzzle flash. And then what you see are these two cars, one being a white Charger hightail. After that, you see the blue car, which is still shot there. You see it, you can't see it cut off the vehicle that's going straight, but you see it come around, and then it appears again, hauling butt in the direction that you see it hauling right now. So let's talk about this white Charger, because there's been a lot made of it, and again, the evidence, frankly, excludes this white Charger completely. The evidence actually excludes any other vehicle except for that blue vehicle. So this white Charger, let's talk about first, who's in the white Charger? Jacob Olds. You heard from Jacob Olds. Nobody knows who Jacob Olds is. He was in the wrong place at the wrong time, and he testified he was just protecting his family. But you heard from Kobe Johnson, no idea who Jacob Olds is. He had to ask Mr. Brown, who's that? You heard Emmanuel Pringle, no idea who Jacob Olds is. There's no indications, not in any of the rap videos. He's not somebody who had a close friend or family member shot by 3 or 320. He's not involved in that at all. And as I stated, he is in front of the SUV in every clip you see. Go back and watch him in front of that. Now the question is, okay, so if he's there in front of the vehicle and he's somehow involved, why is he there? What is he doing? It makes zero sense for him to be up there in front of this red SUV, at times 7 seconds ahead of the red SUV. If he's trying to help in some way, he's doing a really bad job at it. So one thing to focus on is this video from Walgreens. What you will see on this video is, and I'll stop it there. You'll see in the distance, and again, these are things that you're going to have to probably look harder at because it might not do it justice where you're looking right now. But you will see the red SUV pull up to the light at Sutel and Moncrief. You see it slow down and stop. And the reason it's doing that is because, as you can see, traffic on Moncrief is now going whichever direction that is. So they're crossing over Sutel. So that car waits, or stops and waits for vehicles to cross over Moncrief. And what you will see from this is that every vehicle that you see from this point forward, aside from the blue Kia Rio, coming across on Moncrief, coming from Moncrief over Sutel. They're not turning behind this SUV, they're not turning in front of this SUV. The other one is a vehicle that you'll see pulled out of the Walgreens parking lot. That also is one that you'll see in other footage. Then what you see is after the red SUV turns, in the video, if you play it, you can see the blue Kia then accelerating very quickly towards the red SUV. But here's another view from the rec center on Moncrief Road. And it starts with, you can see the white Charger. And you're welcome to count if you want to, but you can see it up at the top left. It's at 3:18, it's at 18:18 and 9 seconds. You see that white Charger pass? Another vehicle pass. Then you see the red SUV. So 9 seconds was when the Charger passed, the red SUV passes it. So 7 seconds ahead. But what you see right behind that red SUV is the blue Kia Rio. Right behind it. On its tail. Again, all those other vehicles that you saw in that video, you can go back and trace them back to the Walgreens video and see that they are coming from Moncrief. They were not coming down Sutel, turning onto Moncrief. Going to Guards that you see do that, let it be. But I would submit to you that that white Charger is it's called a red herring. It's something that distracts you from the important stuff. It's something that will send you on a wild goose chase if you really let it. As the evidence shows, that white Charger was not involved. And in the same vein of red herrings, Juwan Thomas falls in that category as well. So, as you heard, Juwan Thomas's statement was about 37 minutes after the shooting. About 37 minutes after the shooting, he posts on social media, "If you think I did it, then I guess I did it," or something along those lines. Much has been made of that. But one question about a statement like that is, why would you blast that on social media and implicate yourself immediately in a murder? Especially a murder where a 13-year-old has died. It doesn't make sense. But I will acknowledge the fact that there are people out there who are, quite frankly, sick.
You can proceed. Ms. James is just going to inform me what it is.
Yes, Your Honor. There are people out there who are sick and who will claim responsibility for things like this, for one reason or another. And Juwan Thomas takes it a step further in another instance where somebody's asking him about the shooter in this incident. And he says that you might be talking to him along those lines as well. So again, he's taking credit for this for some reason. He is not involved in this. How do we know that? Well, even if it doesn't make sense that he's making this post 37 minutes after the murder, it's still a lead. A lead that the detectives have to follow up on, make sure that they run it down. And they did. Detective Mittman still investigated it. He got several search warrants for cell phone numbers that might be connected to Juwan Thomas. He could not find anyone that was confirmed as connected to Juwan Thomas. One of the numbers, he was able to look it up, it pinged at the same, from the tower that's closest to the crime scene. As you heard, however, Juwan Thomas lives right there near the crime scene. The other of the numbers pings at a location nowhere near this crime scene. So again, Detective Mittman continues to follow up on this, but he goes further. He tries to determine whether or not there is anybody close to Juwan Thomas, close family, friends who have a blue sedan. Not even a Kia Rio, a blue sedan. See if there's somebody that he had access to use that blue car. Couldn't find anybody. At the end of the day, through Detective Mittman's investigation, he could not confirm any connections between Juwan Thomas and the individuals involved in this incident. So, of course, he's not going to continue down that road. And more importantly, at this point, he's got Marcel Johnson's cell phone data showing him go to 7th Street, call the defendant, immediately stop making phone calls for another couple hours up to and after the murder. So they have a much stronger lead that they're following up on in regard to this defendant. And more importantly, though, it's something that where Juwan Thomas becomes very clear to them that he is not a suspect in this, despite his foolish statements. What other things happen? Well, again, as to Marcel's phone at 6:36 is the next activity. We see that his phone is powered on, airplane mode turned off. As we stated, that is something where you can only see it being turned on, so there's no, actually I apologize, that should be, wrong. So at 7:50, you have the defendant call Kobe Johnson. We'll talk a little bit about that supposed conversation at some point, but based on that phone call, Kobe and Emmanuel Pringle go over to Gerard's house. How do we know that they went to Gerard's house? Well, we have the cell phone data, the location data that shows Kobe, Marcel, and Gerard all at the same location. And I know you've heard some testimony about, well, it doesn't tell you the exact location that, it doesn't say if I'm standing right here, then I'm standing right here. It only gives you a general idea. Well, let me ask you this. Does it make sense that the defendant's calling Kobe, and then Kobe just happens to end up in the same, very close to being specific area? That's not a coincidence, okay? They're hanging out together. They are together. And we know that because of the evidence that we continue to see after this. After this, they go to, they take the car by Pete's, who is a friend who cleans cars. I would suggest to you that that is absolutely an act to try and get the vehicle clean because of what they had just done in it. And then they had Kobe take the car back to the grandma's. And Kobe had his own car, so he had Emmanuel actually drive the blue Kia Rio. And also just going back to at Gerard's house after he called Kobe, Emmanuel Pringle's GPS also was tracking him and showed him at a more precise location, but still showed him at that 7th Street location at Gerard's house. So again, he's also one of the individuals that came over. And again, we have proof that he's over there. This is not just speculation. At 8:18, they go to the park. And how do we know that? Because we see all of that. Again, this defendant's data, Marcel's. You see Emmanuel Pringle's GPS. We track them, or they're tracked to that park, where they then, Emmanuel Pringle and Kobe Johnson hear this defendant make that statement. I sprayed that bitch up. And in front of Kobe, at least as far as Kobe testified, he also heard something about the defendant saying he saw Prince's head hit the window. Let's talk about Kobe Johnson. You will be instructed, or you have been instructed in regard to factors that you can consider in weighing the credibility of witnesses. And you'll have these instructions so you can read them back over if you need to. But there are several things that the court has instructed you what you should consider using your common sense. One of those things is, does a witness have some interest in how the case should be decided? Well, let's apply that to Kobe Johnson. Yes, he does. He does not want to see either defendant be in trouble. He testified he did not want to be here. He was forced to be here by subpoena. We picked him up and brought him here. He was forced to be here by subpoena. As far as his testimony goes, it was very evident that he was doing what he could to try and help the defendant. So what are we looking at here as far as what he has said? When he first is contacted, he first denied everything. Did not want to talk to the police. He mentions nothing about a barbershop, mentions nothing about his Zastava rifle, mentions nothing about being jumped earlier in the year. So basically, again, almost completely refused to talk to the police. But when he took the stand here and testified, at no point in time did he say, I lied. Whether that was to the detectives at a later point in time, whether that was at the prior proceeding, or whether that was even here. At no point is he saying, did he say, I lied, or did he say, I'm lying about hearing what I heard? He maintained what he heard, and that was Gerard's statement, I sprayed that bitch up and saw Prince's head hit the driving off. He talked about being pressured to say what they needed me to say. Well, again, he had to be subpoenaed to be forced to go to the prior proceeding. At the end of the day, nobody told him what to say. And you'll see in a second that he talked about Emmanuel Pringle supposedly giving a statement that the detectives then relayed to him about spraying that bitch up. And the problem with that is that Emmanuel Pringle didn't tell the detectives that until a month after they talked to Kobe and Kobe gave them that statement. So it's things like that that you see where Kobe is trying to help defendants. But going further into this prior statement with Kobe, when he first disclosed it, he had an attorney there. Barred attorney that is there making sure that nothing, goes bad or is done that's improper. Police are not going to, in front of an attorney, going to make threats, going to try and do anything that other than tell the defendant that he needs to come forward and tell the truth. Otherwise, that would be very dumb on their part to do that in front of a barred attorney. As I mentioned earlier, nobody put Emmanuel Pringle's statement in front of him because it was impossible. Pringle had not given a statement by that. Kobe Johnson's testimony, he said nothing about Grand Theft Auto. Recall, Emmanuel Pringle brought up. He said nothing about Grand Theft Auto. Talked about playing NBA 2K in some football game. But one of the main questions to ask yourself is why on earth would he implicate Gerard? This is his older brother's, or at least one of his older brother's best friends. Why on earth, if he is feeling this pressure to just pull a name out of thin air, is he going to bring up Gerard's name? Why not just make up a name? John Smith, it's Slim, it's Drop, whatever. Why would he bring up that name? Especially since it's clear after him coming in and testifying that he's trying to protect Gerard. Doesn't make sense. The other thing is, that was brought out, was that whenever Kobe first talked about what he actually heard, he didn't mention the head hitting the window. He brought that up in the proceeding where he testified. Now that is a bigger question. Why on earth would you fabricate that? That sinks Gerard even more, and it does not protect Marcel. The defendant testified that when he asked, why would Kobe make that up? He said, I don't know, he was trying to protect Johnson. Why on earth, how does that protect Marcel Johnson? When they're known good friends, when the evidence shows that they were together that day, how does that protect him by saying an additional thing that he heard about Prince's head hitting the window? Makes zero sense. And again, you all brought your common sense here, hopefully. I asked you if you would, and hopefully you have. Makes zero sense for him to make that kind of a statement up out of thin air again. And again, he'd already given his statement. All he had to do was come in and say, yep, he said that he sprayed that bitch up. Thank you, bye. He added that, again, the only explanation for him adding that is because at that point he was under oath. Talk about Emmanuel Pringle. Same boat as Kobe Johnson. Did not want to be here. Did not want to be testifying. Sure as heck did not want to get his brother, as he referred to him. But he came in anyway. Just like Kobe, at no point in time did Emmanuel Pringle say, you know what, I lied on that prior occasion. Or, I said before that, I heard him say I sprayed that bitch up, but again, that wasn't true. But what he did do, instead of saying I lied, he said, well, he was talking about Grand Theft Auto. So let's think about that for a second. These are a group of grown men going to a park to hang out at night. And they're bragging about playing a video game. I don't play video games, so maybe I'm lost on this one. But I have common sense, and I can tell you that I don't think it makes any sense whatsoever that a bunch of grown men are going to go to a location and brag about what they did on a video game earlier in the day or earlier in the week, whatever the case may be. The statement itself does not make sense. But what's more important is that statement about this being about Grand Theft Auto That was not something that was said until he was deposed. His deposition was taken. Because when he was interviewed by police, he said, what, seven plus times that about the spraying that bitch up. Not one time did he mention Grand Theft Auto. Not one time did he say, well, yeah, he said that, but, you know, we were all bragging about playing Grand Theft Auto and shooting things up on the game. Didn't happen. That's because what he realized is that he got Gerard in trouble with that statement. He knew he messed up. His way of trying to backtrack back out of that statement was to claim that this is somehow involved or somehow about Grand Theft Auto. But just like Kobe, why implicate Gerard? His brother, as he refers to him. Why? Same thing. Why not make up a random name or a random friend? Why not make up a person that you know exists but is very loosely connected to the whole situation? Why would he say that Gerard said that? Doesn't make sense for him to just make that up against Gerard. So, what you have is one of the other considerations that you will have whenever you are deliberating is the witness at some other time it gets stated that it's inconsistent with the testimony he or she gave in court. And we do have that. But again, it's not something that they changed to help the state. It's things that they are changing excuse me, to try and help Mr. Gerard. Another consideration that you'll have is, does the witness's testimony agree with the other testimony and other evidence in the case? Yes. Kobe and Emmanuel's statements agree with each other. Again, Emmanuel didn't add in the part about seeing Prince's head hit the window, but they are consistent. And what they also are consistent with is them talking about going to this park at night at 8:18, hanging out. And that's all consistent with their testimony. That's consistent with the data, cell phone data that you see. It's consistent with Emmanuel Pringle's GPS monitor. Yeah, the testimony is consistent. It was consistent with the other evidence in the case. Let's talk about Mr. Gerard's interview. One of the things he says is that he has never seen that blue Kia Rio before. Oops. He also said that he was playing NBA 2K. Didn't mention anything about Grand Theft Auto. He claimed that he was at home with his girlfriend all night. And he called Kobe to just bring a controller over for a video game. Touch upon that briefly. He talked about the fact that he was playing video games with Marcel for a while before they went off to the car. Before Kobe came over. They were playing video games for a while. Why does Kobe need to bring a controller over? Oh, well, because the controller doesn't work that well. So you've been using this controller that doesn't work. It does not make sense why he's calling Kobe to bring over a controller for a video game, because that's not what he did. He was calling Kobe over after and talk about what just happened as far as shooting goes. Before December 3rd, his interview, he said that he hadn't seen Johnson since September. Didn't hang out often. But nevertheless, he was very upset that Johnson forgot his birthday. People that don't hang out barely. Hadn't seen him since September, but he forgot his birthday in November, and that really hurt his feelings. Makes sense. And we know that it doesn't make sense because we see other statements. So, as far as the interview goes, some of the things that he said that indicates his consciousness of guilt. He downplays his friendship with Marcel. Again, he says that they hadn't hung out since September. But then he's super upset because Marcel forgot his birthday. Problem is that the day of the murder, there were multiple calls between he and Marcel earlier in the day. So if these are people that are not hanging out, why are they calling each other multiple times in the morning, early afternoon? After the murder, they are calling each other 1 or 2 times. He lied about ever seeing the blue Kia Rio before. And he's confronted with the fingerprints. And in the telephone call that you hear between he and his girlfriend, Miss Karen Yago, he acknowledges, I messed up because I lied about ever seeing that car before. And of course he says, well, of course I've been in that Rio before. It's my friend's car. But also, his statement there makes the DNA evidence practically useless, because he's admitted to being in the car. We know he's good friends with Marcel. We know that he's been in the car multiple times before. Finding his DNA in there is not going to prove anything, other than that he had been in the vehicle before. We expect to see. But it shows you how unreliable DNA can be at times, because he was excluded one or more of the samples that were collected from the car. But at the end of the day, it doesn't mean anything. He lied about never leaving the house that night. And again, he was confronted with the cell records at that point and then said, I went to Brooklyn. Typo there. I went to Brooklyn. Again, caught with the evidence, changes his story, says, oh yeah, I did go to Brooklyn. And he testified on in his direct that he had just forgotten about that. Important detail about going to Brooklyn. In that same phone call you hear with his girlfriend, he tells her to tell police what he told her. Talk about that in a moment, but he also warns her that they will try to break her down. He said, break you down. What does that mean? What are they going to break her down about? What are they going to force her to say that isn't the truth? He's worried about her breaking down. That would indicate she's got something to protect. That something to protect is that she knew that he had not been there the whole night. She knew he left. She knew that he had left earlier as well. You have his search. How do the police track a SIM card even if it's not installed in the phone? Is it possible or not? That's a pretty significant search. Especially after he admitted on the stand that he had taken his SIM card out of the number that was used to call and receive calls from Marcel Johnson before the murder and after the murder. So he's clearly trying to find a way to make sure that after taking that SIM card out, it is not going to be used against him. Hoping. Some other things about his testimony. He worked for TMS. But as he testified on cross-examination by Mr. Grau, they didn't send him on any jobs for a month after being hired, coincidentally or conveniently, which was after the murder. They hire him and then they say, okay, go home, sit down, and we'll just call you whatever. Then a month later they say, okay, come on up to Lake Placid, New York. The snow is apparently very hard. So his phone completely broke. He drops it in the snow. Completely. Again, I'm not an expert on snow, but first of all, I think it's common knowledge that it's soft, typically. And as long as the phone is picked up pretty quickly, I would submit to you that it's not going to cause the phone to just completely break. But he holds on to the phone, moves the SIM card, and gets a new phone because that phone broke. Not because he was getting kicked off the plane. That's his motive. He got that new phone, according to him, that phone broke. Why did the phone break? Question. When he was arrested, he had 3 backup phones. In case, I guess, he dropped 2 others in the snow. 3 backup phones on. One had just Wi-Fi access. Talking about how he was terrified by the search warrant that was served on his mother's house. Yet being terrified as he might have been, at no point does he reach out to the detective and say, why on earth are you searching my mother's house? Terrified, upset, whatever you want to call it. Why does he not want to get to the bottom of this? This is completely out of left field. Now he talks, again, we talked about earlier about how he downplayed his friendship with Marcel Johnson. Talked about how they were growing apart. Again, feelings getting hurt over the birthday, which is in November of 2022. Testified that he didn't agree with Johnson's activity. This is one of the reasons why he's not hanging out with Johnson anymore. Because he's selling weed. Well, he had no problem buying weed from him, going and smoking weed with him. He's not going to be around somebody when they're selling weed. He admitted that they still hung out here and there. But he had told detectives earlier that he had not hung out with Marcel since September earlier that year. And again, there are those multiple calls between the defendant and Marcel Johnson for third. His testimony was, I never said that I sprayed that bitch up. Something, again, that Kobe just completely fabricated, the manual completely fabricated. I don't know why. Kobe was trying to protect his brother. We already talked about why that makes 0 sense. Kobe not be protecting his brother by implicating one of his brother's best friends. That's not how it works. What we didn't hear was any explanation as to why Emmanuel would make up the statement. Hear any of that on stand. And again, this just kind of ties back to the data, but he said he was asleep when Karen Yaga arrived, and that goes back to the data transmission information that you have, and how that does not indicate somebody is manually using it. Showed that there was being data was being transmitted while he's supposedly asleep, waiting for Karen Yaga to arrive. One of the interesting points of his cross-examination, he stated, yeah, I went down to the park, lit up a joint, whatever, blunt, had a hit or two or whatever, shared, I don't know. He said he was there for about 5 to 10 minutes. A little quick little visit down there, say hey to my boys, go back up home. Problem is that the cell phone data shows that at the earliest he was in that location where the park is at 8:18 p.m. He used to keep him in that area until 8:45 p.m. There for 30 minutes. That's not just a quick little visit. That's not a quick conversation. That's not a quick little smoke off point or whatever. That's him there with those other individuals talking about what had happened, making the statements that Kobe and Emmanuel said he made. On cross-examination, when asked about that search, about whether they can track the SIM card, he said, I delete everything I search. Oops. Didn't delete that history showing that he searched for Marcel. Okay, so inmate search. Didn't do that. He doesn't delete everything he searched. Didn't work. He admitted that he knows about 320. Knows Emmanuel. Knows Isaiah. Knows Kobe. Knows Marcel. Good. Again, brothers with Emmanuel. Really good friends, best friends with Marcel, at least at one point, according to him. All people that he hung out with. You think he has no interest in doing anything that would benefit them? No interest in maybe getting some vengeance or retribution on their behalf, especially with Emmanuel's little brother being shot. Finding Marcel being shot in that barbershop incident. Obi getting jumped. I think he has no interest in doing something to get back at 3. And at the very end, he admitted he had lied to police multiple times to protect himself. Lied to the police multiple times to protect himself. I submit to you that that is exactly what he was doing, trying to protect himself. Members of the jury, when Mr. Gerard stated that he sprayed that bitch up in front of his friends, in front of Kobe, in front of Emmanuel, I don't think he expected that they would come into court, come to the police, and tell them what they heard. Fortunately, victims in this case, unfortunately for Mr. Gerard, they did. They came in there and testified to what they heard. But the thing is that that statement alone is not what the state is relying on. That statement is merely confirmation of the other evidence in the case showing what happened or it happened. Jury selection, defense counsel said that the defendant was cloaked in innocence. And that's true, he was. That cloak has been ripped off. Now you all see him for what he truly is. Guilty on all counts.
Thank you, Mr. Powell. Ms. Jameson, would you like a recess?
Very brief.
All right. Members of the jury, we're going to take a brief recess before we continue with closing argument. We'll be back at 3:46. Now remember, you've only heard part of the closing argument, so you are not in deliberations. The case is not over. You may not discuss anything that has transpired that includes amongst yourselves. And remember, you'll be going this way.
Ladies and gentlemen of the jury, good afternoon. I feel like everybody in this courtroom continues to get up here and promise you that we are nearing the end. We're in the home stretch. We are almost done. We promise it won't be much longer. And I'm actually going to stand up here and say exactly the same thing. But truly, we are in the home stretch. What you are doing is incredibly noble, but fatiguing and grueling work. And it is critical to our system of justice, so for that we thank you. This is truly the most important day in the life of Contravious Gerard. So please just bear with us for a little bit longer. You've paid careful attention and I've watched you take careful notes, and so stick with me for just I promise to be respectful of your time. But for your careful attention, Mr. Gerard thanks you, and I certainly thank you. My name is Attorney Nicole Jamison. Contravious Gerard is my client. He is a brother. He is a son. He is a grandson. He is a lifelong resident of Duval County, Florida, a hard worker since the age of 16, human being, a young man so softly spoken that he waited 2.5 years to tell his own legal team that we were mispronouncing his name, and he is not guilty. He is a chooser of bad friends. We talked a little bit in jury selection about individual responsibility. Now, the military is kind of a perfect example of this notion of collective responsibility. And for those of you that don't have any sort of personal experience with it, I'm sure we've all seen it on movies, right? Stripes, for instance. Bill Murray is the classic smart aleck who can't keep his mouth shut, and as a result, the entire platoon gets punished for his antics and bad behavior. Well, the military, there's actually a reason for that, right? Kind of the suffering of the collective actually encourages brotherhood and cohesiveness. It encourages leadership, right? Because the idea is that somebody will become a leader and speak up and stop that bad behavior so the entirety of the collective doesn't suffer anymore. The criminal justice system is not the place for collective responsibility. We see collective responsibility as parents, right? Especially mothers to boys. You hear shenanigans in a back bedroom, you walk in there, there's a broken lamp, and 2 of your sons are in there. You don't bother to sort out who's responsible for it. You cut corners, you punish both of them, you send them to bed, or you take away their video games, etc. Why do we do that? Well, we do it because we as parents are tired, right?
You can proceed. It's just the buzzer in here is very loud. Ms. James will let me know what it's about.
We're tired. We don't have time to sort out their shenanigans. They probably were both responsible. And cutting corners as a parent is okay, because the nature of the consequences is the loss of TV or the loss of a PlayStation, right? The loss of a privilege. It is not the loss of forever liberty like that which is at stake in a criminal courtroom. We don't cut those kinds of corners in a criminal courtroom. As parents, it's easier to punish collectively, and if we make a mistake, it's okay. It's forgotten the next day. Sometimes we apologize for it, sometimes we don't. That is simply not sufficient for a criminal courtroom. A criminal courtroom is no place for collective punishment. Evidence is necessary. Today, a man's life hangs in the balance, and as such, the highest burden under the law is required. There is absolutely no room for error. In jury selection, we talked a little bit about this. We talked about the dangers of guilt by association. Juror number 49 had actually been in a car when that car was stopped by police and the driver was actually shot. She admittedly chose a bad friend. We talked about that in jury selection. She said she did not even have any idea that the vehicle she was in was stolen. Perhaps her parents warned her to stay away from that friend and she didn't listen. But under guilt by association, she would be convicted of that crime. And we do not do that here in this courtroom. A bad friend choice is not enough. Even presence while a crime was committed is not enough. The judge will actually tell you that in your jury instructions, and I'll circle back to that in a minute. Mere knowledge that a crime has been committed, not enough. The law does not require you to report a crime that you know about. And again, the judge will tell you that as well. I will read that jury instruction to you. He has actually already told you that. You will have those jury instructions back in the room with you when you deliberate. The law does not require you to be a snitch. The wickedness of the wicked shall be upon himself. Ezekiel chapter 18, verse 20. And that in and of itself is the notion of individual responsibility, and that is what our criminal justice system is built upon. You should not concern yourself about the criminal actions of Marcel Johnson. They have absolutely nothing to do with your purpose in this courtroom. While the trials were conducted at the same time, his jury will exact their own justice against him. And that has nothing to do with my client, Contravious Gerard. A bad friend choice does not equate to evidence. In this criminal courtroom, the state has the highest burden under the law, and that is beyond and to the exclusion of every single reasonable doubt. They must prove that by way of evidence that you can rely upon, and that evidence must convince you beyond and to the exclusion of every single reasonable doubt. Going back to individual responsibility, the jury instructions that you heard, which must feel like a very long time ago, were as follows. The defendants have been tried together. However, the charges against each defendant and the evidence applicable to him must be considered separately. The guilt of Marcel Johnson has absolutely nothing to do with the guilt or innocence of Contravious Gerard in our trial. Whether or not you feel Marcel Johnson is guilty of these crimes should not influence your verdict against Contravious Gerard. That is in the instructions that the judge read to you a very long time ago. You will have them back in the jury room. You must independently determine whether the state has proven their allegations against Mr. Gerard beyond and through the exclusion of every single reasonable doubt by way of evidence that is reliable enough to support a verdict of guilt in a murder trial for which a man's life hangs in the balance. What is not evidence? Gut feelings, hunches, maybes, might haves, those things are not a substitute for evidence. In jury selection, we all agreed that if you think maybe he was involved, but the state did not prove his guilt beyond and to the exclusion of every single reasonable doubt with reliable evidence, the law mandates that your verdict be not guilty. We do not have to prove Contravious Gerard's innocence. That is not how this process works. Likewise, we chose you because in jury selection, you committed that you were capable of that surgical, steady-handed approach. You confirmed the importance of not substituting emotions or sadness for evidence. Let's be clear, what happened in this case was an unspeakable tragedy. The injuries inflicted upon young Mr. Holland Talent Walker, and Jalen Burrows were horrific. They were inexcusable. Nobody in this courtroom would deny that. Not myself, not Mr. Gerard. But we're not here today to make statements through a verdict about tragedy. All promised that in jury selection. That is not our purpose today. Mr. Gerard is not responsible for that tragedy. He has entered a plea of not guilty, and he has asserted his innocence through every single solitary step of this process. Ladies and gentlemen, there is not one single solitary shred of physical evidence that suggests Contravious Gerard did anything other than make a bad friend choice. There is not one single solitary shred of physical evidence that ties him to a homicide or the crimes of attempted murder. In this case, law enforcement developed a narrative. They tried to make innocent pieces of information fit into that narrative, and then they stayed quiet about those innocent pieces when they didn't fit the narrative. I think that industry term is tunnel vision. That law enforcement officer who was a detective at the time of this crime and shortly thereafter promoted to sergeant. Remember, my client's arrest was in February of 2023. He was promoted to sergeant shortly thereafter in 2024 after making an arrest for JSO in a high-profile case, despite what we all heard in this courtroom about the investigation. And if you think he's not invested in seeing his tunnel vision to conclusion, if you think he is not justifying his incomplete investigation, well, look over there in the galley and you will see him sitting in this courtroom even right now, his testimony long having been over. What did not fit the narrative? I'm going to circle back to some of these things again later, but namely, the DNA, Mr. Gerard's cell phone records, Emilia Karanyaga, his then at the time girlfriend, the lack of absolutely any single solitary shred of evidence in his social media to show that he even knew who these people were, that he even knew the individuals. Not one shred. The state of Florida had 26,000 pages of his social media records. The detective admitted, yes, shows deletions. And ladies and gentlemen, you can better believe that if there was anything in those records that showed he had deleted something, a comment on Mr. Burrows' social media, a comment on Mr. Marquise Holloway's social media, any chats, any discussions about this, you can better believe they would be up in living color on these screens. They are not, because they did not exist. Not just that. No proof, not one single solitary shred of proof that he even knew them. You heard his testimony. I had never seen Mr. Burrows before in my life until he walked into this courtroom, and nobody, not one single witness or not one single piece of evidence contradicts that. Did not even know what they looked like. Didn't know anything about what vehicle they drove. What else didn't fit the narrative? Well, simple things. The fact that Mr. Gerard was actually a working man at the time of his arrest. If you'll recall, now Sergeant Mittling's own testimony, well, I can't say whether he was arrested on his job or not. And then when further pressed, well, okay, I guess he was in a vest. It looked like a work vest and maybe wearing some kind of a hat. Why? Because they don't even want to admit that he is an individual who is employed, who has a job. What else did they ignore? Well, the fact that he was visiting his family in Georgia. Asked Detective Mittling, His presence in Georgia certainly looked guilty to you, right? Yes. Yes, in fact, it did. Did you even pick up the phone? I'm not even asking that you drive up to Georgia. Did you even pick up the phone and call a single solitary family member? Was he there? When did he get there? Was it planned? Is this something he does all the time? No, absolutely not. Why? Because it doesn't fit into their narrative that he had committed this crime. What else did they ignore that didn't fit into their narrative? Well, briefly, the vehicle descriptions, that it was the shooter vehicle was different than a blue car. From the actual witnesses on scene who witnessed the shooting, supported by the surveillance evidence in the case. We'll get back to that later. Jawan Thomas, ladies and gentlemen. Jawan Thomas, an individual who took responsibility for a homicide 30 minutes after it happened. 30 minutes. How would he even know that a homicide had occurred 30 minutes later unless he's the one that did it or was somehow involved? This hadn't been broadcast to the news at that period of time. It wasn't public knowledge. 30 minutes. Posted, if you think I did it, I did it. Post not even preserved for you to look at, to interpret what it meant. And then guess what? When they got his social media, it was missing to suggest it had been deleted. The state is going to stand up here and suggest to you that the Jacksonville Sheriff's Office investigated Jawan Thomas. They did the best that they could. They did not even talk to him. And the explanation for that was, well, we can't just go dragging people in. Oh, absolutely they can, and they do it all the time. You think they need an arrest warrant to bring you down and ask you to talk to them? Absolutely not. You think they need an arrest warrant to go to your house and interrogate you? Absolutely not. Did not even talk to him. Oh, well, we searched to see if he had access to a blue car. Did not interview a single solitary one of his family members. Not one. Where was he on that day? Where was he at that time? What was he doing? Does he have access to his Asava-style rifle? Who knows? Because the questions were never asked. It is a mystery, and mystery by its very definition is reasonable doubt. Jacob Olds, Kendall Brown, occupant of Jacob Olds' vehicle, did not even speak to him, did not even talk to him. What else didn't fit their narrative? Descriptions from witnesses at the actual scene. 2 cars appearing to be acting in concert with each other, filled with occupants. Ignore that, not important. Don't pay attention to what's over here. Vehicle descriptions: white Charger, dark Dodge. This is why, ladies and gentlemen, it is so crucial to have trials. This is why you, as jurors, are so important. We talked about the awesome power of the government to pluck a citizen from his ordinary life and subject him to a permanent deprivation of liberty, and you alone are the only check on that power. The only check. Because you have seen what happens when law enforcement jumps to a conclusion and does not do a thorough investigation unfold before your eyes. You, as individuals and, a collective body, are the sole determiner of the facts in this case. Not Sergeant Mitling, not Mr. Powell, not Mr. Grau. They stand up here and tell you what the facts are. Sergeant Mittling stood up here and narrated a grainy surveillance video for you. And it's been done repeatedly to tell you what it shows. Well, the blue car is doing this and the white car is doing that. And, this is the position of the vehicles and this is where the shots came out from. Not using any kind of tools or technology beyond his naked eyes, you get to say what that video showed. And you alone. You get to watch it. Your eyes are no different than his eyes. He does not get to tell you what that video shows. You watch it. You decide for yourself. He is not an expert witness. He is not a forensic crime scene reconstructionist. You have heard not one single solitary shred of testimony to support the state's suggestions of this is how the shooting happened. This is where the shots came from. You have heard not one single bit of expert testimony to support that theory. It is simply a theory, and a theory alone that fits their narrative, ignoring all other evidence in the case. The prosecutors are echoing that theory. They are presupposing that the shots occur after the white Charger moves on surveillance video at the intersection in front of the red Mercedes. Presupposing that that happens despite no evidence to support that assertion. Ladies and gentlemen, there is but one muzzle flash captured in that video surveillance. There are 22 shots. Do you think the shots started before the vehicles come into view of that particular surveillance angle? Absolutely, I suggest to you that that is consistent with the fact that you only see one muzzle flash and there are 22 shots. Remember, this assumption that it's the blue vehicle is simply that. There are no identifying characteristics about that vehicle. There's nothing unique about it beyond the way it appears straight off of the manufacturer's factory belt. Okay, nothing unique. There's no modifications. It doesn't have rims. It doesn't have any damage to it. It is no different than any other blue small sedan, and I submit to you, I do not think they can even affirmatively assert that it's a Kia Rio. There's no license plate, there's no VIN number. But when questioned about whether or not the white Charger and the gray sedan, also seen in each and every single one of those video surveillance frames, are consistent from frame to frame, well, I can't tell you that. I have no idea. I can only make those conclusions about the vehicle that supports my arrest and my theory of prosecution. Can't weigh into those other vehicles. The vehicles, which, by the way, match the descriptions of witnesses from young Mr. Walker, who was actually in the red Mercedes itself, said, I saw an unusual dark in color sedan parked across the street before we even left. And I saw the same dark in color sedan fleeing the scene after the shots. But ignore what he says, because it does not support their theory. Not one person talked to anybody or even investigated a dark in color sedan. You'll have the video surveillance in the jury room. You can watch the behavior of that dark in color sedan as the red Mercedes is first captured on video. It is incredibly unusual. And the state's explanation for that is, oh, well, there was an ambulance pulling out. Well, then you wait. You don't pull out to ensure that you stay on pace with a red Mercedes in the wrong lane of travel. You stop and wait. That dark in color sedan did not do that. It ensured that its direction of travel kept pace with the red Mercedes. Incredibly unusual, and in violation of traffic laws. The facts are what you determine them to be, and you alone. We've talked a lot about reasonable doubt. Where does reasonable doubt come from? Well, first I would start by saying, remember that it just takes one single doubt that is reasonable, just one, and the law commands that your verdict be not guilty. And remember, it's something not often said, but in our criminal justice system, not guilty doesn't even necessarily equate to innocence. It means a failure to prove. It means a failure to sustain the government's burden, which is the highest under the law. But luckily, in this case, Mr. Contravious Gerard is factually innocent, and the only just verdict is not guilty. Well, what is reasonable doubt? Ladies and gentlemen, it's whatever you as jurors determine it to be. You get to decide that. The law is instructive. The judge told you earlier, a verdict of guilty requires an abiding conviction of guilt. Or, if you have a conviction, but it's one that's not stable, but it wavers and it vacillates, then the charge is not proven by every reasonable doubt. Every single reasonable doubt. Then you must find the defendant not guilty, because the doubt is reasonable. You get to decide what is a reasonable doubt. You and you alone. And there is plenty to pick from in this case. The judge will tell you where it can come from as a sort of guiding principle. Well, it can come from the evidence itself. It can come from the conflicts in the evidence, and it can come from a lack of evidence. I'm going to talk to you briefly just about each one of those categories to help give you a roadmap to all of the reasonable doubt in this case. And remember, if you have just one single doubt that is reasonable, the law commands a not guilty verdict. I'm not going to review everything. You guys have been sitting in this trial just like us, listening carefully and taking diligent notes, but this is truly critically important. So it's essential that I highlight a few things. Let's talk about the evidence itself. Well, in this case, there just simply is none that supports a verdict of guilty. I want to talk to you briefly about Kobe Johnson and Emmanuel Pringle, admitted liars. And the issue with that is that because they have admitted to lying in one statement, you cannot believe any statement. That is the issue. You cannot and should not sort out what is the truth, and you, as jurors in this case, are permitted to disregard anything that they say, everything that they say. The judge told you that during your instructions. You can believe all of what a witness says, some of what a witness says, or just disregard it entirely. That is the awesome power that you have, and I suggest to you that that is what you should do with their testimony. Why? Mr. Powell tried to talk about this. Why? Why would they make these statements implicating Contravious Gerard? Well, he is sitting right behind Mr. Gerard. That is the reason why they made those statements. Why would they implicate Mr. Gerard? Well, because their friend, Marcel Johnson's life hangs in balance, and Kobe Johnson is his own biological brother. His quote on the stand, "I am my brother's biggest fan," admitted that he knows and understands if his brother is convicted, he will never leave prison again. Never. That is why he is lying. You must remember, not one single solitary thing that he said implicated his brother. Not one. And the state's theory is that his brother was the driver and involved. That doesn't make sense. How are you to believe part of what he says but just disregard that part? Most importantly, with respect to Kobe Johnson and Emmanuel Pringle, their testimony is inconsistent with the other evidence in the case. The state said with respect to Mr. Johnson, well, it's not unusual for people to lie to the police. He didn't want to be a snitch. Well, ladies and gentlemen, that's exactly what Mr. Gerard told you when he took the stand. Yes, I lied to the police. I did not want to be a snitch. but believe the brother of the man who did this and not Mr. Gerard. I want to talk to you about this additional detail that Mr. Johnson gives. Mr. Kobe Johnson, to be clear, I'm sorry that gets confusing. Mr. Kobe Johnson has given a number of different statements in this case. His first interview is December of 2022, during which he just admits he completely lies throughout the context of the entire interview. Does not tell one single solitary shred of truth. He then, on probation, facing up to 6 years in prison, is compelled to come back down and give another statement. And at the time of being forced to come back down and give another statement, he is performing, okay? He's got the detective there, he's got the prosecutor there, and he is on probation. And he adds this extra detail that never appears anywhere else, ever. Never. This juicy detail that is horrific. That supposedly my client said that he saw this young man's head hit the window. That is horrific, and it is completely inconsistent with the physical evidence in this case. You have pictures of this SUV, okay? You have the surveillance video that show the seconds during which this happened. Look at the windows on this SUV. That doesn't even make sense. They are tinted so dark you can't even see through them. That extra bit of information makes no sense. His statement is inconsistent with the physical evidence in this case. The state keeps suggesting that, well, Mr. Johnson and Mr. Pringle both give this consistent statement about spraying up a car, and Kobe Johnson wouldn't even know about that in January because Mr. Pringle wasn't interviewed yet. He absolutely was. He was interviewed multiple times. He was interviewed in December of 2022 for the first time. Why, the state keeps saying, why pick Mr. Gerard to blame? Well, because they all knew that their friend, fellow companion in a group that references themselves as 320, Marcel Johnson, was at my client's house the day this happened. Let me please remind you, during Mr. Powell's presentation of motive, right? Why Mr. Gerard somehow has motive. Well, because of all this horrific violence going back and forth between people, not one single solitary bit of that involves him. You have not heard one single witness suggest that he is a part of anyone that references themselves as 320. Who is Kobe Johnson, Marcel Johnson, Emmanuel Pringle, and his brother, Isaiah Pringle, a.k.a. Zabe. Who has motive in this case? Who? We're going to talk about that some more in a minute. Now remember, at the time Mr. Pringle came in here and testified, he is actively on probation, lied to the police in violation of that probation, recommended that he be sentenced to incarceration, and just, by the way, thanks for your giving us what we wanted in this criminal case, you're free to go back on probation. Back out in the community, walking amongst us. Mr. Powell, during his presentation, discussed what would be their motive for lying. Well, ladies and gentlemen, we don't have to give you one. We have no burden to prove a single solitary thing. Not motive, not who did this, not how it was done. But lack of motive is certainly a place from which you as a juror can find reasonable doubt. Lack of motive equals a reasonable doubt. And remember, with just one, the law commands a verdict of not guilty. I want to talk to you about who has the motive in this. In 2019, Marcel Johnson. In 2019, the brother of the state's witness, Emmanuel J.P. Isaiah Duress, was shot in the head and injured so severely during high school. And remember, who went to high school together? Not my client. He had nothing to do with that. Didn't even know these people. Who went to high school together? This dispute, this beef, this streak of retaliatory violence dates back to high school, having nothing to do with Contravious Gerard. Who was fighting back in high school? What started as schoolyard fights escalated to a string of horrific gun violence, none of which has anything to do with my. During the state's presentation on motive, they talked to you about all these awful things, all these murders. Not one single solitary shred of evidence suggests that he was involved or had any reason to have a disagreement with these people. Who did? Marcel Johnson, Toby Johnson, Emmanuel Pringle, Isaiah Pringle. They did. Marcel Johnson was the ringleader. He is older than his brother. Toby Johnson is his brother's biggest fan. He is a brother who exacted revenge on behalf of Kobe because he couldn't handle a schoolyard fistfight. And let's be honest, that's what it was just 2 months before this happened. End of September 2022. There was an incident having nothing to do with Contravious Gerard. He wasn't there. He had nothing to do with that. Kobe Johnson and Marcel Johnson are the only ones that involved. Jalen Burroughs and his brother Marquise Holloway. Jalen Burroughs was a coach at a charity event at a car wash next to an O'Reilly's. And that charity event was to raise money for Kobe Johnson's belief is that Jalen Burroughs saw him, picked up the phone, called his brother and a bunch of his brother's friends to come up and surround him, basically ambush him. And it was, I can't remember if they said 5 or 6 against 1. You guys can use your own recollection. And he was beat up. You see the pictures. They're in evidence. Where did those pictures come from? Marcel Johnson's phone. Not Contravious Gerard's phone. There's absolutely not one single solitary shred of evidence that those pictures were sent to my. Not one. He was not present. They did not involve him. The state offered this motive with respect to, I guess that's what it was offered for, but there was some comment from Mr. Burroughs himself on the stand that's never before been heard. He was asked extensively about this stuff during depositions, and it was something to the effect of, oh, well, one time I saw that your client made a diss comment or a mean comment on my brother's social media. Ladies and gentlemen, Sergeant Mittling on the stand acknowledged 6,000 pages social media records. Not one shred of support for that assertion in the records because it did not happen. It was the best that they could do. Well, one time back in 2020, he made this comment. My client does not even know Jalen or Marquise Holloway. Both Kobe Johnson and Emmanuel Pringle acknowledged that their friend Marcel was the reason behind all of this strife to begin with. Both acknowledged he was facing life in prison, never to be seen again. Not believing a witness is reasonable doubt. And let's talk about the murder weapon. This is Marcel Johnson and Kobe Johnson's gun. It was purchased by Kobe Johnson in 2022. Not one single solitary shred of evidence that my client has ever owned such a thing, ever. All facts that everybody forgets to admit to law enforcement. Why would they lie? I'll tell you why they lie. They're protecting Marcel Johnson. That Zastava-style rifle that Mr. Kobe Johnson says he just never saw again was posted by his brother 4 days before the homicide. Shortly after he was beat up, not by Mr. Gerard, absolutely not. And please remember, it was not discussed very frequently, but there is another 5.56 casing that is found at a shot spotter scene 10 months after my client was in jail. That gun is still out there, and I submit to you, perhaps so is the shooter. That is not our job to solve that mystery for you. The fact that it remains a mystery is by its very definition reasonable doubt. Lack of motive equals lack of evidence equals reasonable doubt equals not guilty. I want to talk to you a little bit about Mr. Gerard. Cloaked in innocence, and that presumption of innocence remains with him throughout every single material stage of the trial. Further, he has a very powerful constitutionally bestowed right. It's the right to remain silent. He does not have to prove his innocence. I don't have to prove his innocence. Not in this courtroom, not in any courtroom in this country. He set aside his constitutional right to remain silent. He didn't have to speak to detectives in this case. He knew he had a right to a lawyer. He had already discussed it with his family and planned to get one. He set that aside. He talked to detectives, and he asserted his innocence. He told them where he was. He explained the things they were confronting him with that they thought made him look guilty. And they did not look into a single solitary one of them. He volunteered phone numbers, his social media accounts. Now, the state mentioned something about cell phones. We had several cell phones. Is having multiple cell phones something you and I would perhaps do? Maybe not. Maybe so. It's not proof that you committed a murder. Some of us have the socioeconomic advantage to go down to Verizon, have our credit checked, sign a contract, pay $2,000 for the latest and greatest iPhone, and get upgrades on the regular. Some of us do not. Some of us have Straight Talk, Text Now. Some of us may have not even ever heard of those things. One of those phones was an iPhone 7, ladies and gentlemen, an iPhone 7. I can't tell you how many years ago that was, but I think we're on a 16 or a 17 at this juncture, okay? That's how old that phone was. Not everyone has the socioeconomic privilege of discarding a phone once it's broken or replacing it with the latest and greatest. There's no proof from the government of where the phones were purchased, who owned them, what the subscriber information was, and 2 of them weren't even activated. So what? Is it weird? Maybe. Weird is not evidence of a murder. It's not proof of anything in this case. Well, he deleted a search about a SIM card. Those are the actions of a man who is scared of the police upon learning that the police raided his mother's house for reasons he did not understand at the time while his 9-year-old brother was there. A man who had never before been interviewed by the police, scared of the police, taught growing up not to volunteer yourself to the police, do not speak with them, do not snitch. He didn't even want to tell you in this courtroom that Marcel Johnson sold marijuana, but he did, reluctantly. Mr. Gerard told the police where he was. He told them who could vouch for where he was, and they said, "You're lying." They referred to him as a black boy in Folkestone, a working man who had no prior record then at the time of his interview, 25 years of age. On his job at the time of his arrest, he said, "My girlfriend can vouch for where I was. She's lying. Your cell phones are lying. Your social media is lying. Your DNA is lying." The lack of any relevant evidence in his home, according to the prosecution, irrelevant. Not even in the report. The lack of any proof of a motive, irrelevant. Don't pay attention to that, would be the state's assertions. Lack of any proof of prior conflict, disregard. Lack of a Zastava-style rifle, purchased, possessed, ever displayed. Yes, there is one photo in an entire batch of extracted cell data that occupies discs upon disc upon disc from March of 22 that is absolutely taken by Marcel Johnson. How do we know that? Because it is the exact hat he was wearing and at the exact time that he makes that Triller post video. Remember that post. Marcel Johnson dancing around his apartment, having nothing to do with my client, waving the murder weapon around in this case. On cross-examination, they said, "We can't tell you that he took that photo. We can't tell you where it came from." Mr. Powell said, in his interview, he, quote, "lied multiple times to protect himself." Ladies and gentlemen, that is absolutely not who he was protecting. Marcel's motive, Marcel's gun, Marcel's strife, Marcel's gunshot wound, Marcel's blue vehicle. Mr. Gerard told the police, "Not only was I with my girlfriend, we went that afternoon to get juicy crab. Did not even go down there." The state would suggest, "Oh, well, that's irrelevant because it happened earlier in the day," but did it really? But for the work of the defense to produce the receipt and the post, you wouldn't even know. It is the state's job to seek the truth and to seek justice and not just to present the evidence that supports their theories. Not irrelevant. You know why? Because the proof of having gone there and the times that they went there absolutely corroborates where he told the detectives he was and what he did that day. "I went to Juicy Crab way over on Blanding with my then girlfriend, Amila. The receipt shows a time of approximately 2:08, way over on Blanding. What time did you get back to your house? Well, he told you, this is a long time ago. I'm only estimating. I can't be very specific, but I can give you estimates, and those estimates are supported by the 2 documents that the defense had to go get. Social media posts showing them at his dining room table eating a seafood spread at 4:25 p.m. in the afternoon. The state would have you believe that that's irrelevant. Why? Well, because it doesn't support their theory. Why is it important? He is spending the weekend with his girlfriend. Does it make sense to you that they wake up, they go to Juicy Crab, they come back, they eat a seafood feast that lasted until Well, the post was at 4:25 and they were still eating. Cleanup afterwards. That lasted until sometime after 5 o'clock, and by the way, just left, went and committed a murder and came back. Absolutely not. That is the most absurd thing I've ever heard. One of the things that the judge told you earlier, in terms of judging the credibility of a witness, you have some tools. You can use your common sense, of course, but in the jury instructions, it will say, was a witness honest and straightforward in answering the attorney's questions? Mr. Gerard, on the stand, never testified before, has never been interviewed by the police before, not a public speaker, not a professional witness, so soft-spoken, had to repeatedly ask him to lean into the microphone. The man who let people for 2.5 years mispronounce his name. He answered each and every question. He wasn't evasive. He admitted on the stand to lying to the police and explained why. Scared, did not want to be a snitch, did not want to implicate his friend by admitting he recognized that car. The state would try to suggest, well, this thing about Mr. Johnson and him growing distant, that's not believable because they still, had phone communication and hung out. He told you that. He said, look, we didn't have any kind of big blow up. There wasn't a big fight. I just started to not agree with or approve of the things that he was doing, so we weren't as close anymore. We still talked. We still hung out. He still came to my mom's house to smoke weed outside and play video games. I bought my weed from him. He did not avoid my questions. He said on the stand, much to my absolute embarrassment, because I asked a poorly crafted question, what did you do with your girlfriend when you first got there? Told everybody in this courtroom, well, we had sex. That's not what I expected him to say, but it was absolutely responsive to my bad question. He did not argue with the state attorney's office. He's not a professional witness. Nervous over the magnitude of what is at stake, certainly understandable. Versus, let's talk about professional witnesses in this case. Agent Blythe. He is with the FBI. He testifies all the time. He's testified hundreds of times. He testifies for a living. It is his job. Was Agent Blythe honest and straightforward in answering the attorney's questions? What should have been 15 minutes of questions took over an hour because he could not answer a simple yes or no question. And maybe it was me. Maybe I was off that day, but I feel like I do a pretty good job of only giving a yes or no option. Well, no, but 15 minutes of explanation to circle back around to the state's theories. We would do that 2 and 3 times. So Agent Blythe, what it sounds like you are saying is that your answer was no. Well, no, but 15 minutes of explanation. And then I would just have to again. So what you're saying is that your answer was no? Over and over and over again, to the suffering of everyone in this courtroom. The entire point of my questions for Agent Blythe were to illustrate that Mr. Gerard's phone was at his house at the time of the crime, which is consistent with every single statement he has ever given. He was home at the time of the crime. And even though Agent Blythe picked and chose which data to include on his presentation, admitting finally, after I had to go over there repeatedly, that he didn't include all of the data from the 2,400 or so lines of a spreadsheet, the activity that he himself notes on his own report shows data happening at 6:15 p.m. from Mr. Gerard's phone while Mr. Gerard is at his house. Why is that time period important? Ladies and gentlemen, on that surveillance compilation, you will see, and the state pointed it out during their presentation of evidence, that blue Kia is parked across from the Legend Center at 6:15 p.m. The time that Mr. Gerard is on his phone at his house. It is physically impossible for him to be in that blue car. Physically impossible. It is inconsistent with the cell phone data in this case. Mr. Powell said something during his first close a moment ago. Well, you would expect to see calls and texts during that time. Look at Mr. Gerard's T-Mobile records. He's not a caller or a texter. There are very brief calls and texts. Young people use all kinds of other means on the phone to communicate. Social media apps, FaceTime, etc. Calling and texting is a bit dated. And you will see that is consistent in Mr. Gerard's T-Mobile records. He just doesn't do a lot of calling and texting. They postured all kinds of hypothetical theories on how that could be explained. And ladies and gentlemen, that's all they are. They're hypotheticals and guesses that are not supported by evidence because the evidence doesn't support their theory of prosecution, so they are trying to explain it away. This is the state of Florida's burden and their burden alone. They have not shown you a single solitary shred of evidence that Mr. Gerard was anywhere other than where he said he was at 9210 7th Street, and their failure to do so is magnificent reasonable doubt in this case. One reasonable doubt commands a not guilty verdict. There is absolutely not a single shred of evidence that he was not at his house with his girlfriend and his cell phone on December the 3rd, 2022 at 6:15 and at 6:21 p.m. until he left later that night to go buy marijuana in Brooklyn well after the homicide. Just a moment ago, Mr. Powell pulled up the timestamps and said, oh, well, he said he was at Brooklyn, and never got out of the car and just bought marijuana, rolled a joint, and was only there for a short period of time. That's exactly what the records show. It was 30 minutes. 30 minutes he's discussing a homicide and supposedly cleaning up a car? It's inconsistent with the state's own evidence in the case. Whose phone was in the vicinity of the scene at the time of the murder? Jawan Thomas, a suspect never even investigated. Pay no attention to that. It would not be of any evidentiary value. But somehow Mr. Gerard's records are, which put him at his residence. Guess what else the phone records support? Well, they show him moving south at the time of his Juicy Crab purchase, which is consistent with where he says he was that afternoon and where his girlfriend says she was with him that afternoon. But that is irrelevant. It's not irrelevant. It's relevant because it's exactly consistent with what he told law enforcement, and law enforcement did nothing to investigate a single solitary thing that exonerated Mr. Gerard in this case. Professional witnesses. Was a witness honest and straightforward in answering the attorney's questions? That is a place from which you can derive reasonable doubt. Jennifer Brown, the FDLE witness. It's been some time ago, but again, remember, it was like a replay of how my cross-examination with Agent Blythe went. Let's talk about the DNA swabs in this case. They were done in December 2022. That's when that car was processed. Guess when they were submitted for testing? January of 2025. More than 2.5 years of Mr. Gerard sitting in jail. Did not even submit them until January of 2025. Mr. Gerard was excluded as a contributor from every single sample which contained sufficient DNA that was taken from that blue car. Most importantly, from the front passenger seat, which is where in the state's theory he was seated at the time of this homicide, despite no evidence to support that theory. They say, well, that's irrelevant because he said he was in the car on Mr. Pringle's birthday. That's right, but he didn't say where in the car he was. The state's theory at the time of this shooting is that he was riding in the front passenger seat, a seat that is not leather, by the way, ladies and gentlemen. It is cloth, it is spongy, and it contained sufficient DNA for testing, and he was excluded as a contributor. Don't pay any attention to that. Pay attention to a fingerprint of unknown age on a door frame. A door frame that can easily be touched from the outside, by the way. I had to confront this analyst with each and every single sample over and over and over again, and she refused to say he was excluded until I had to read her direct quotes from her own written report. And I quote, "Contravious Gerard is excluded as a contributor to this mixed DNA profile from item 8, which was the front passenger seat." And I had to do that for each and every single sample. Consider the print to be significant, but not the more scientifically reliable evidence of DNA, because it does not support their theory of prosecution, and that is a theme throughout this case. When it does not support their theory, a professional witness who testifies all the time is reluctant to give that information and is uncooperative with an attorney trying to get it. Now remember, conflicts in the evidence are a place from which you can get reasonable doubt. Detective Mittling, now sergeant. From the scene and from the mouths of the witnesses who were actually there, the best evidence of who was responsible. Dark Dodge from the young man actually in the car. White Charger, 2 cars full of young adults or teens. From Miss Beeks, they appear, she was there in the intersection, appeared to be traveling together. Saw them moments later together at an entirely different location down Moncrief in front of her house, squealing their tires and driving recklessly. Jawan Thomas, if you think I did it, I did it. 30 minutes after the homicide. A failure to investigate all possible suspects is by its very nature reasonable doubt. Jacob Olds, Kendall Brown. And let's just be clear, we've talked so much about vehicles in this case, colors of vehicles, who the shooter vehicle was, what the surveillance showed. It's not the job of the defense to prove what car was involved, who was in the car, who was the shooter. That is the job of the government. The fact that everyone is still wondering is by very definition reasonable doubt. You can decide what the shooter car was. But again, even if you believe it to be a blue car, that has absolutely nothing to do with Contravious Gerard, and it's not proof that he was even in that car. It is not proof that he was involved or responsible for committing a homicide, not one single solitary bit. I want to talk to you about the blue car, however, and I know everybody's sick of hearing about it. These pictures are in evidence. I'm going to pick this view of the car from the back. Been a very long time ago, but if you would remember, during my cross-examination of Wells, who was the evidence tech that processed this car, it's a small, in-size sedan. Very small. Yes, she agreed. In fact, it was. You didn't measure it, but would you have any reason to doubt me if I told you it was only 67 inches wide? No, I have no reason to doubt you. That sounds consistent with what I saw. 67 inches wide. I stand here before you, 5'3", maybe slightly more in heels, if I'm lucky, okay? 5'3". So I'm 63 inches, just, you turned me this other direction, just slightly smaller than the width of that vehicle. You have seen this gentleman, Marcel Johnson, come and go throughout this courtroom. You've seen him stand. Every time you enter, he stands 6'5", 77 inches tall with a wingspan of at least 77 inches or more. Longer than the entire width of that blue car. Why is that important? Power windows from the driver's seat operating the passenger side window. The state suggested through Sergeant Mittling, despite not being supported by any evidence whatsoever, it would take an expert marksman to drive and shoot. That is the style rifle. It is a pistol grip, ladies and gentlemen, and I suggest to you that unfortunately the outcome in this case dictates that we all know whoever was shooting was not an expert marksman. Jalen Burroughs was the target. Absolutely consistent with the physical evidence that Marcel Johnson is responsible solely for that shooting from the driver's seat of that blue vehicle. Why? Well, let's talk about this. You heard a lot about the presence of this mysterious GSR that cannot somehow be tested, despite the fact that FDLE used to do it. But what we heard from Wells is that there was indeed the presence of GSR on the interior headliner of that blue car. We don't have any pictures of it, unfortunately, because they elected not to take them. Why is GSR on the interior headliner consistent with a driver rolling down the window and shooting? Because GSR comes from the muzzle of a firearm, the barrel of the firearm. If the passenger was the shooter, let's consider that for a minute. If the passenger was the shooter, you would certainly see more than one muzzle flash for 22 casings, number one. If the passenger was the shooter, the firearm would be out of the window. You don't shoot holding a firearm from a passenger seat like this in front of you. No, no. If you are a passenger shooting, you extend that firearm out of a window, not leaving the presence of GSR, showing multiple muzzle flashes on video surveillance. That is not what happened, and that is not what the physical evidence shows. And again, for Mr. Gerard's purposes, it is truly irrelevant. I'm not a detective. I'm not a prosecutor. It's not my job to solve whether it was the driver or the passenger who committed this shooting. Either scenario is irrelevant for Mr. Gerard because he is neither one of those people. The fact that the question remains unanswered is in and of itself reasonable doubt. It's irrelevant also because there's not one single shred of evidence that Mr. Gerard was anywhere other than in his house. Talk to you about this. A little bit more on the evidence itself. I promise I'm not going to torture you much longer, okay? The evidence that the state has for you is this. Look over here. Look over here at this YouTube video, not over here at the evidence that's been submitted. Look over here at this video. The date of this video is more than a year prior to the homicide. The state of Florida suggests, well, we had to show you that because it shows that they knew each other. That's not in dispute. Ask yourselves, what is the point? It is not evidence of anything. It was more than 16 months before this homicide. Mr. Gerard is standing in the background, not saying a single solitary thing, not one word, not one lyric. Why do they show it to you? Well, because it shows a menacing young black man to distract you with emotion and fear. Whether or not you personally care for that kind of music is irrelevant. It's not evidence. And in fact, ladies and gentlemen, the United States Supreme Court has long held that artistic expression is constitutionally protected speech. It's constitutionally protected speech even if the lyrics are offensive. It's constitutionally protected speech even if the lyrics are violent and even if they are distasteful. It's fictional artistic expression, and it's no different than that of NWA, Johnny Cash, even Super Bowl performer Kendrick Lamar. Johnny Cash, okay? And that might surprise you. Let's talk a little bit about Johnny Cash for a second. Delia. And I met Delia here, found her in her parlor, and I tied her to a chair. Delia's gone. One more round, Delia's gone. She was low down and trifling, and she was cold and mean. Kind of evil, make me want to grab my submachine. Delia's gone. One more round, Delia's gone. The first time I shot her in the side. I had to watch her suffer. But with the second shot, she died. Delia's gone. One more round, Delia's gone. Equally violent, perhaps presented in a different, more folksy fashion. Words are the same. It's artistic expression, it's a distraction, it is not evidence. It makes you feel emotional about violence and sad about a tragic loss, and you should feel sad about a tragic loss, but your verdict is no place for that. You all promised that in jury selection. You all committed that you would be the surgeon in the operating room without that shaky hand. A few final, very more important rules, so to speak. And I'm sure you're more than tired of it, because all you have done during your service has been bossed around. Leave the courtroom. Don't leave the courtroom. Don't look at your phones. Don't watch the news. Don't talk to each other. Don't deliberate. But I promise these are crucially important. Mr. Girard does not have a burden to prove anything. Not his innocence, not who was in the car, not what car was used. He doesn't even have a burden to prove where he was, despite the fact that we have. It is the government with the absolute power to subject an innocent citizen to a deprivation of liberty, and it is their sole burden in this courtroom. If you get back to that jury room and you find yourself wondering what might have happened, what could have happened, that is another way of phrasing reasonable doubt. Common sense. This is something the state talks a lot about. They talk a lot about common sense. And ladies and gentlemen, while it's obvious that you do not check your common sense at the door, and that it is an important tool in evaluating evidence, it is not a substitute for evidence. The more the state discusses common sense, the more you should be alarmed, because it means they do not have actual evidence. On that note, is it common sense that a working man, no prior record, spending the weekend with his girlfriend, not involved in doing the things his friend was doing, who was intimate with his girlfriend as soon as she got into town, spent the day with her, went to go get juicy crab, eating a massive seafood spread at their house until probably after 5 p.m., left, ran out, committed a homicide, and attempted murders of people he did not even know, never met before, did not know what vehicle they drove, had no reason to have a single solitary disagreement with, no history of disagreements with, all because of someone he had known for just a couple of years? Absolutely not. That doesn't make sense. And it doesn't make sense because it didn't happen and there's no evidence that it did. We talked in jury selection briefly about individual verdicts. The law requires that you carefully and meaningfully deliberate by applying the facts to the law. There is absolutely no requirement that you change your own personal moral verdict. If you have carefully and thoughtfully deliberated and applied the facts to the law, and you are convinced that there is reasonable doubt in the case, then the law actually mandates that your verdict be not guilty. Nobody says you have to change your mind if other jurors disagree. There's nothing in the law that says you have to change your verdict if you're tired, if you're hungry, if you're tired of hearing from us, if you're exhausted with being here, or if you're bullied. In fact, that would not be a lawful verdict in this case. Now, the government gets the final word. Mr. Grau is going to get back up here and talk to you, and it's not for me or you to decide whether or not that's fair. It's just the way that it is. In light of that, I would urge you to consider, while he is talking, what Mr. Gerard would have wanted me to say in response. What I would or could say if I had the last word on his behalf. And please remember, what the prosecutor says is not evidence. It is simply their arguments about the evidence. The law requires you to use your recollection of the testimony. I'm going to refer you to the Independent Act jury instruction. This is something the judge gave you a very long time ago, and in part it says, an independent act occurs when a person other than the defendant commits or attempts to commit a crime, which the defendant did not intend to occur, in which the defendant did not participate. That is exactly what happened in this case. The law states that if you find the homicide and attempted homicides occurred as a result of an independent act of another, Marcel Johnson, then you should find Contravious Gerard not guilty. And finally, within that same instruction, mere knowledge that an offense is being committed is not the same as participation with criminal intent. Even mere presence at the scene of a crime is not enough to establish participation in the offense. Knowing that someone committed a crime is not a crime. It does not make you guilty of a murder or an attempted murder. The law does not impose upon anyone an obligation to snitch. It just simply doesn't. And while it might be morally offensive, it is not evidence. The jury instructions are admittedly confusing. There's a whole packet of them. They're written by lawyers, and I submit they're not ideal for understanding, but in this case, they don't even matter. As Mr. Powell suggested in his first opening, the only question is whether or not Mr. Contravious Gerard did this. We don't dispute that a crime was committed. We don't dispute that it was a tragedy. We do not dispute that the crimes charged were committed against the people in that red car. Mr. Contravious Gerard is not the person who committed them. He had absolutely nothing to do with that, and he is not guilty. The verdict forms are likewise confusing. You have to wade through a bunch of options on each count before you get to the not guilty section. We ask that you please wade through those, go to the not guilty section, and check a not guilty verdict as to each count and return Mr. Gerard to his family. Thank you.
All right, thank you, Ms. Jamison. So, members of the jury, there's a closing argument instruction. I should have read it to you before all this got started, but it's pretty basic, and Ms. Jamison touched on it. So, remember that what the attorneys say is not evidence or your instruction on the law. Listen closely to their arguments, which you appear to have been doing. The arguments are intended to aid you in your understanding of the case. Each side has equal time, but as mentioned, the state is entitled to divide that time between an opening argument and a rebuttal argument after the defense has given its closing arguments, which you have just heard. So at this time, the state will give its rebuttal argument. Yes.
It's interesting that Ms. Jamison got up and was talking about the YouTube videos and the purpose that the state presented them. We presented them to depict a black man rapping or basically demonstrating themselves in a negative connotation to try and prove his guilt in this case. And that is not the reason why the state introduced them. However, Ms. Jamison talks about Mr. Gerard being a brother, a son, a grandson, a hard worker, a human being. He is someone with no prior record who is a hard worker. How do any of those have any relevance on this case? Propensity is not proof. If someone does bad things in their past and they're on trial for a crime, those don't get to come in to prove the person's guilty. Same way the opposite. Someone can have a good resume, and that does not mean that they are not guilty. But why bring those up? Why are they relevant? They're not. They're to try to have you sympathize with Mr. Gerard. And there is an instruction you will get. This case must not be decided for or against anyone because you feel sorry at anyone, and I'll finish it, or angry at anyone. And another one that says your verdict should not be influenced by feelings of prejudice, bias, or sympathy. That is why those came out in closing arguments. Going back to the YouTube videos, I do not want you to see Mr. Gerard in those videos and have a negative connotation. You dislike the rap or you dislike the way he looks in them. If that's the case, I do not want that to be the basis for finding the defendant guilty. Not the reason why the state introduced them. The state introduced them not to show that they know each other. Had the state not introduced them, the argument would have been like, they're barely friends, they hang out a couple times, hasn't seen him since his birthday, you'll find nothing on his social media of evidence, nothing to show of what they do together. So we introduced them to show how good of friends they are. If he premieres or is in his rap videos, he's comfortable holding firearms while he's in his rap videos. Because he's also comfortable going and doing other things with guns with Mr. Johnson, if necessary. That is why they were introduced, to show the level or strength of friendship and how they hang out. The state does not want you to take them in regards to any negative of drill rap and use that towards guilt. Absolutely not. And we're going to go, and I'm going to pepper a lot on reasonable doubt, what might have happened and what could have happened. That alone is not. Okay? Reasonable doubt is a doubt that is reasonable. So if you're saying something, well, this might have happened, I just ask you to keep going with the sentence. But is it reasonable that this might have happened? If it's yes, and that thing is something other than what the state has proven, then you have a reasonable doubt. So please, if you're saying maybe or this could have, I ask you to just add on to the sentence. But if I look at all of the evidence together, is it reasonable? Yes or no? It's a very important day for Mr. Gerard. It's a very important day for a lot of other people too. But just like the sympathy thing, we ask that that not come into your play. The fact that you're holding the balance of a life should not come into play with the same thing in regards to Mr. Holland's families. What they're looking for. None of that should matter in regards to you deciding the verdict, because it should be to the evidence and the evidence alone. It's interesting, in closing, you hear the statement, presence is not enough. That is correct. Presence is not enough, and you're instructed on that. Why does that matter? Mr. Gerard wasn't there. It's the highest burden. And you're going to get an instruction in regards to, we don't want you to convict Mr. Gerard solely on the basis of guilt. You can't say, well, I think Mr. Johnson's guilty, so just by that alone, Mr. Gerard is guilty. No. But you can take the facts that Mr. Johnson is guilty of the crime and use it as evidence in regards to Mr. Gerard. Okay? You don't have to take, it's not like we only get the two statements by Mr. Pringle and Mr. Johnson, and that's it. No. All of the evidence that inculcates or goes to show Mr. Johnson's guilt also goes to show Mr. Gerard's guilt. Because Mr. Johnson went over to Mr. Gerard's house that day, and after the homicide is back at his house shortly after the homicide. We'll get into some other facts why, yes, that alone doesn't prove he's guilty. But as we go through the different things that you see with Mr. Johnson, him turning his cell site off, his airplane mode on, and then back off. Him in regards to having Kobe Johnson's firearm. The fact that Trey lives 2.2 miles away. The fact that there's a blue Kia Rio that's registered to Mr. Johnson's grandmother. The fact that there's a Zastava 4 days prior in Mr. Johnson's possession. The fact that you have motive that Mr. Johnson got shot at the barbershop by potentially Jalen. However, please don't forget that Isaiah Pringle, the brother of Emmanuel Pringle, who is Emmanuel Pringle, testified that Contravious Gerard is like a brother to him, was shot in the head and blinded. You have the statements that were both made, that Mr. Gerard made in Brooklyn. You have the search of can police track a SIM card, that was deleted. Funny, you have 2,600, I think it was stated 26,000 incorrectly in closing, 2,600 pages of social media, not anything linking to it. Surprisingly that he's trying to find how to delete a SIM card, that he might not delete social media. Remember, Detective Mittling wasn't sure if social media records actually show if there had been evidence on the social media that actually had been marked for deletion, or whether or not deletion completely removes it from it. But ultimately, you have to remember, he's arrested in February. And for the man who's deleting web search histories from his phone, there becomes an argument of whether or not he's deleting social media. But let's look at Marcel Johnson as well. We pulled his Instagram and the thousands of pages from him. One video. Him jumping around in March with the Zastava rifle. Shouldn't he have comments and messages and feuds in regards with Jalen and members of 3? One video. We pulled Juwan Thomas's social media. 0 items. So for them, they don't really have anything, but they're probably the ones that did it. Mr. Gerard doesn't have anything on his, so he's not guilty. That's reasonable doubt. Maybe gut feelings, hunches, that's not a not guilty. That's not reasonable doubt, unless those feelings are actually reasonable. Disassertation of innocence is not evidence. Going to trial is not evidence that he is not guilty in this case. Talking with law enforcement is not evidence that he is not guilty in this case. Tunnel vision. He got promoted to sergeant. Well, you have to take a sergeant's exam to be promoted to sergeant. Long and gruesome process that everyone at JSO tries to go through. He didn't get promoted till 2024, and he got promoted to the cold case division, where he has to go through old cases and try and find any evidence that other detectives have already gone through. He didn't get a commendation. He wasn't promoted. Hey, good job. We're clapping outside. You're promoted 2 weeks later. No. Through the normal course of his business, however long he's been in homicide, he's now moving on to another division where he doesn't have to be on call 1 day every 7 days of the week to go out at 4 in the morning while his family's at home to a homicide. He's in the courtroom today. He has an interest in this case. He does. They have an interest in this case. He's worked on this case. He wants to see how it ends, good or bad. He wants to see the arguments by the attorneys to see if there's anything he can do better in the future. And I think there was a statement in regards to Mr. Pringle or Mr. Kobe Johnson did confirm the 1222 live video went on. And yet, none of that shows up in any of the social media records in regards to Mr. Gerard joined that call, and none of those are found. The fact that these witnesses are being confrontational. Detective Mittling can't even say that he was arrested on the job site, because he wasn't there when he was arrested. He came in with work clothing. Detective Mittling is trying not to assume. He on his way to work, dressed at his house to go to work, and then he got arrested. He doesn't know. He wasn't there. He may have been told by marshals. He's trying not to give you hearsay. He's trying to give you evidence that he is able to confirm himself. Georgia, from the 7th to the 22nd, and this is a good point. We've been presented a lot of evidence in this case, and the point was to present to you everything the state had. There is not necessarily, well, other than statements, a lot of the pieces of evidence by this.
All right. Ready?
So there's pieces of evidence that you're going to be admitted, some of which by themselves is not the state trying to say, oh, he looked up Marcel Johnson on 1230. It's guilt. Absolutely not. One thing the state is asking you to go back there is to look at all of the evidence together, combine it together. We're going over a few facts and saying, well, these three things, but add in every other fact the state has presented in regards to Mr. Gerard. One of which is potential Georgia visit. The state presented that because that was investigations. When detectives look for people, they kind of intend to see if the person went out of town and they contain the evidence. Of course, if they're going to call up the family members and say, hey, what are they doing up there? Just visiting. They're going to say, oh, they came up here to escape because he committed a homicide. They're not going to get that. They know what they're going to get. There's no reason to do it. They're going to at least provide the information that on the 7th he goes up to Georgia and he is up there until the 22nd of the holidays, the time to now go live out of Folkston for a period of time. The state is not using that to heavily rely on the guilt in this case. Juan Thomas, 37 minutes later, if they say I did it, I did it. Why? Because word is getting around that there's a shooting near the home of. How is word getting around? Look at the surveillance of the gas station. Look at how many people go and duck. They're not going to drag him in to interview him. First of all, they went through and figured that they didn't have enough anyways. But they're not going to drag him in until they have evidence to confront him. They're going to bring him in and say, did you do that shooting? No. The Instagram video said he did it. I'll just take it. What the heck? Well, you own a specific blue Kia Rio? No. Now what? Your cell site puts you in the area of the shooting. I live there. Okay, you're free to go. They wait until they have evidence that they can confront someone with, like Mr. Gerard. Where were you the day of the homicide? I was home all alone and I never left. Lying. No, I'm not lying. Yes, you are. We have your cell site going to. Okay, well, I actually did leave the rest. That's what they need. Mystery is not reasonable doubt. So specifically, the mystery is I don't believe Contrarius Gerard did it, and I have a reasonable doubt as to it. Yes. Mystery in general, maybe Juan did it. We don't have the story of Juan. We don't have the story of Jacob Olds. We don't have the story of Kendall Brown. The lack of evidence there doesn't mean not guilty for Mr. Gerard if you believe that there is enough evidence to prove the crime beyond a reasonable doubt. Jacob Olds and Kendall Brown on closing for defense didn't speak with them. Yes, they did. They had detectives. Detective Mittling spoke that they were spoken to by other detectives who went out to meet with them. There was no evidence that they committed the crime, so that they didn't bring him down to the PMB. Ms. Beeks says 2 cars acting in cahoots, but they just disregard that because it doesn't fit the state's theory. And Detective Mittling didn't have an expert come in. Well, first of all, a lot of this is CCTV that is grainy as is. There's not much an expert can do to doctor some of this up other than the zoom in that we did at the end. And an expert really wouldn't be able to testify to this because it is the jury. In fact, there was an objection to Detective Mittling narrating this. So I don't see how an expert would be able to come in regards to telling you about surveillance. But let's look, and I will narrate. If you disagree with me, please disagree with me. It is what you see. I only do this to assist. But the intersection is empty, and here's our red car right here. Right at the intersection, right here. There's the dark car that just came from Moncrief that we're going to see in a second. There's our white Charger. Our red car is now making the right, and our blue car is entering the scene. Our white Charger has left. There's the other, I don't know if you call that gray, we can call it dark, we can call it whatever, third vehicle, vehicle after Charger. Vehicle's turning, blue car's here. Blue car's there. Here's our blue car turning. You'll see another vehicle coming from Moncrief as well. There it is crossing Moncrief, just as the two in front of the red vehicle did. And there's our dark vehicle, maybe the one that Mr. Walker saw fleeing the scene. If we go forward, what do we see? Dark car that we saw come across Moncrief. White car that we saw come across Moncrief, which is why Detective Mittling stated, I cannot tell you that that's the same car from Sutel. Why? Because it came across the intersection of Moncrief. He's not here to fit the state's theory. Only the blue car, I can tell you, is constant in all of this surveillance. Because it is. After the white car, so remember, dark, white, we can call this gray, silver, dark, whatever we want to call it. Third car, or in between Charger and red SUV. Blue car. And then our dark car. Which, after you're getting shot, and you file out of the vehicle, and you finally get out, and you look, might be the last vehicle fleeing from the scene. We go up to the surveillance. Grainy, well, not too grainy, but CCTV from across the street. There's the car in front of the white Charger getting in the right-hand turning lane. Here's the white Charger. If we zoom back out, nobody in this gas station has ducked or fled for cover because gunshots have already rang out. You saw that surveillance. That white Charger never gets behind that red SUV. There's the white Charger stopped. Here's the dark car that was in between, or gray car maybe, that was in between the white Charger and the SUV. That's going to get in the right-hand lane. Here's our victim's vehicle. They're going to get right behind the white Charger. No one's fleeing yet for any gunshots. And right behind here, we're going to have our blue car. It's going to duck this way. There's going to be the darker car that's going to come into the right-hand turning lane at the same time, so you're going to see some headlights here. Blue car, other car. Going to be in the left-hand lane, going to be in the right lane. There they go. They're splitting the SUV. There goes the white Charger. And here, rolling against the street sign, is our victim's vehicle. And what does the blue vehicle do after coming the left-hand lane? There it is. Coming up to go around the vehicle going straight, almost causing a crash, and then fleeing. That is what the surveillance shows. Please watch it as many times as you would like, and please formulate your own opinion. The officers are jumping to conclusions. Well, they didn't arrest him until February. Conveniently, that the blue sedan, a blue Kia Rio that is owned by the grandmother of Marcel Johnson, happens to have what appears to be a burn mark above the front passenger right handle, where it appears that the muzzle flash seems to be coming from. A burn mark that's not a bullet hole. You're shooting from the driver's side. Not a bullet hole. Doesn't go through and through. That is the mark of the passenger shooting, bringing the gun back into the car, and the barrel of the gun touching up against the upholstery, the hot barrel, and burning into that upholstery. And that is why you have gunshot residue on the top upholstery, because that rifle is being brought in that way and put back. They can't take a photo of gunshot residue. to have those orange glasses to see the light that's emitted after the ultraviolet is applied to them. They swabbed it. They tried. No labs in Florida, and none other than, well, that they could find in Texas, and Texas only accept in-Texas submissions, will take it. FDO used to test for it until they started realizing it doesn't give evidentiary value. I want to be hesitant when I say evidentiary value. I'm not saying it doesn't matter. I'm saying it doesn't tell you when a gun has been fired. It tells you that there are gunpowder, either residue from burnt gunpowder or dry gunpowder that doesn't get used during the explosive. That is there. Talked about people getting comments about making fun of people at the gun ranges, people owning other firearms, Marcel Johnson having other firearms other than Mrs. Stop. If you're firing firearms or you have it on you, you can transfer it to places like a vehicle. If they test a vehicle for gunshot residue, they cannot tell you that a Zastava was fired in that vehicle on December 3rd. They can tell you that someone who's been in contact with powder and then inside that vehicle. Same thing, that fingerprint. That gunshot residue is the same as that fingerprint. It tells you Mr. Gerard has been in that vehicle at some period of time. Probably a little bit more sooner than later, because it will break down over time with the elements. If it's on the metal part that's facing from a window where the sun can shine in, I know we're in December, but there's still sun in Florida. So I would say that fingerprint isn't a year or 8 months old. But listen to his jail call. He said, I fucked up. Told him I hadn't been in that car. He doesn't go, but that one time they took me to Mr. Pringle's birthday, I was in it, which I don't know if they were doing a driving Miss Daisy situation and he was in the back seat, but he says, that's my people's car. That's my people's car. What people? They weren't friends anymore. They were drifting apart. That's my people's car. Going back to the white Charger, look at the rear of the red SUV, where the bullet strikes are. The fact that Marcel Johnson is by himself and goes to go around when he gets out of the passenger to make the bullet strikes that are in the rear of the vehicle, and then comes up and continues shooting with accuracy to get as many bullet strikes on that car as he is also driving at the same time of an AR-style pistol. Semi-automatic. Yep. Shooting up this car. Not reasonable. Toby and Emmanuel are admitted liars. You should not believe their testimony. He's an admitted liar. You should believe him, which isn't. He lied to the police multiple times. You should believe everything he said on the stand, that he was at his house, Marcel Johnson. We'll get to that in a second. Why is Toby lying? You heard Toby's lying because his brother's facing life. His brother's facing all of this hardship. His brother needs help. Okay? That's one reason why he's lying. Why does he do it in the way of implicating Mr. Gerard? That's the question that's not answered. But is answered because Mr. Gerard is the one who made the statement. Because it's the truth of what he said. Testifying that Mr. Gerard is the shooter is implicating Mr. Johnson as the driver. The rifle used, Mr. Johnson's grandmother's car that's used. Mr. Johnson has beef with the people who end up getting shot up. To help his brother, he should say that it was someone that his brother doesn't associate with. Someone who stole his brother's car, maybe someone who has a blue car. Somebody else, but someone who's best friends with his brother. It doesn't make sense. What makes sense is that he was in a tough spot. Remember, he hadn't been violating on probation. He was on probation. So if he violated, he didn't listen to a subpoena and at least show up. He would violate if he committed perjury, which is a violation of the law. He told something under oath that later on they were able to prove it wasn't true. That violates his probation. That gets him up to 6 years in prison. Remember, first time they talked to him, lied about everything. He didn't say anything, including the spray that bitch up. That didn't come out the first time they talked. Came out was the proceeding in January. That is the first time he said, I sprayed that bitch up. Where he also said, we saw the boy's head hit the window and then we left. I can see there's tinted windows, at least in the rear. I believe there's also tinted windows on the side of the state. I don't know how they fare up in regards to street lights at a lit intersection. I don't know whether or not maybe Mr. Gerard said he believed he saw a head hit a window potentially. But these are statements that I don't see any reasonable reason why Mr. Johnson or Mr. Pringle would make up. And defense brought up, well, they had talked to Mr. Pringle before Mr. Kobe Johnson testified in January. They did on 12/22 when he lied. Remember, they're known admitted liars because the first time both of them were talked to, they lied. Mr. Pringle did not give the statement, spray that bitch up on 12/22. He gave it in February. Kobe Johnson had no statement provided to him. So where did he come up with that statement? And there is motive. Daniel Pringle testified. The same person was like, nah, he was talking about Grand Theft Auto. Trying to protect Mr. Jordan. But what does he also say when he testifies? I call him my brother. My brother. In 2019, Mr. Pringle's blood brother was shot in the head and blinded. And this didn't upset him? In fact, we didn't really get that far because he doesn't know Jalen McIntyre. He doesn't know Marquise Holland. You believe that? His brother had his blood brother shot in the head and lost vision when he was friends with him. And everyone else testifies. They believe Jalen or Marquise to be responsible. In fact, it was Jalen or Pico. And they don't talk about it. That name's never been mentioned. You believe that? I believe it's talked about Gerard's phone. Not one single shred of evidence. Not one single shred of evidence. Yes, Mr. Gerard shredded his phone. Just like he removed the SIM card, he made sure that phone broke in the snow. That phone didn't break in the snow. He got rid of that phone. He got rid of that phone just after 12/22, the same day he got rid of that SIM card. Not believing a witness is not reasonable doubt. That's absolutely not. If you don't believe a witness, you can just not take their testimony. You can just set it aside. And then of the remaining evidence, if you find a reasonable doubt, then your verdict is not guilty. If you don't find a reasonable doubt, then your verdict is guilty. So not believing a witness is not reasonable doubt. It was said, this is Kobe Johnson's gun. This seems to be the agreement. This is Kobe Johnson's gun. Kobe's the Stava rifle. You heard Ms. Sarnak testify that of all the guns she's tested, she's actually never tested as a Stava style rifle. Never had one across her desk. She had to look through testings of other Stava rifles to see that unique ring that led her to believe that this case involved is a Stava style rifle. But we believe it's Kobe Johnson's gun. If it's Kobe Johnson's gun, where does Juan Thomas? Fingers at Marcel. He did this by himself. He one-armed it out the window. This was Kobe Johnson's gun. Mr. Gerard's never seen that gun before. Juan Thomas is not involved. So Marcel Johnson comes over, and at 4:25, his cell site hits at the house. And after the homicide, 10 months later, they find a .556 round. The shot spotter call. He calls 911. No witnesses. He's there. They show up in the road. 5.56 case. Got it? Test it, matches ours. 10 months later. All that means is that that gun disappeared. It is a search warrant on Marshall Johnson's house on December 15th. Normal life. Remember, he took it when Kobe got arrested, then they got evicted, and he had it 4 days before the homicide. Then they do a search warrant of his house, it's not there. He got rid of it. Instead of dropping it in the Trout River or breaking it down and scattering it, he gave it to other people. 10 months later, it gets used. Now, I can't say this is a fact, but I would imagine the same person who uses his grandmother's car to do a shoot-up rather than a rental car to do a shoot-up and then go burn it at another location is probably also just going to hand off the rifle to someone else. The mystery of the rifle, the real shooters out there 10 months later doing another shoot. It's not reasonable doubt. I don't get the phone. He still had access to his aunt's plan. Breaks his phone. Why not try and go fix it? Hey, my screen's cracked, and I try and pay $100 to see, hey, can you tell me if this can be fixed for $100 so I don't have to go spend $800 on a new phone? Doesn't do that. He's still on his aunt's plan. He still has access to that 660 number until September of 2023. What does he do? He gets 2 other phones, 2 different numbers, not his aunt's plan, that are 2 different areas that are not 904. Does having 3 phones means he's guilty of this crime? No. Some of the evidence introduced are for other reasons, not for direct guilt. That at least is relevant evidence to potentially put out there, if he has 3 phones then, on December 3rd, is there a chance he had more than 1 phone that law enforcement didn't know about? Told him he was lying in his interview. He was. He absolutely was. And they had evidence to prove it, and they confronted him, and he changed his story. They called him a black boy in Folkestone. I believe they were asking about the federal marshals looking for him, and he said, yeah, my family members in Folkestone said they were looking for a black boy in dreads. And I think Detective Johnson said, well, there's other black people in dreads in Folkestone. Like, how do you know they were looking for you when they came by and said that? Lack of things in a report. The detective is not going to put in his report everything that he didn't find. The implication is that if he says, I found 1, 2, and 3, that he didn't find anything other than 1, 2, and 3. That is a forced doubt. And I actually wanted to read that other instruction of reasonable doubt. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, a speculative doubt, an imaginary doubt, or a forced doubt. That is a forced doubt. The detective didn't put the things he didn't find in his report. And so that's reasonable doubt. Why would he save the iCloud photo? That was the interesting thing. Does the photo on his iCloud mean he committed this murder by itself? No. Why is he saving that to his phone? If he's someone who's distancing himself from Marcel because he doesn't like the life that Marcel leads, why is he saving a photo Marcel sends him of Marcel's Estava-style rifle and another rifle next to it? They didn't get the receipt from the Juicy Crab because they didn't care, because it didn't fit the narrative. No, they had a cell site. The cell site shows him going down to Blanding at 3 p.m. They didn't need to go get the receipt. So I don't know how to do it. Hey, do you guys still have something for Kiran Yaga on? They have his cell site going down to the Juicy Crab at 3 p.m. So the detectives not getting a receipt is not reasonable doubt. This is forced doubt. She posted it at 4:25. That's when they started meeting. That's when they were meeting. Let's go to the evidence. It's the best thing when it comes to closing arguments. They get back up at 3:34 and 3:35 p.m. So I hope they didn't wait 50 minutes to dig in on warm seafood that they ordered at 2:10 p.m. and went down to pick up. That just shows that at 4:25 it was posted, not that they were still eating. They ate, they were done. Why were they done? Why were they done eating? Because at 4:25, when it's posted, guess who shows up? Marcel. I don't get that. He didn't want to snitch on Marcel by saying he had seen the car. I had been in the car. I don't get how that's snitching on Marcel. Yeah, I've been in that car before. Okay, well now we can prove Marcel's guilty of something. Thank you very much. No. How would that be snitching? He didn't want to put himself in that car. It's his people's car. He knew what happened. His girlfriend was home all night. He's been in that car before. He's Marcel's friend. His cell phone's at the house. Why not just say, I was in the car? Because he knew what happened in that car. Why say you've never seen that Zastava rifle? Because he knew the gun that was used to commit the crime. Kobe Johnson eventually says, that's my gun. Kobe Johnson at least admits, the murder weapon is mine. Because he knows he's not there. He's with Emmanuel Pringle. And Emmanuel Pringle testified that Kobe came over and they played video games until they left to go to Trey's house. So Emmanuel Pringle, his brother, vouches that Kobe was with him during the murder. It's not Kobe that did it. It's not Emmanuel Pringle that did it. And Agent Bly, very difficult witness, stated that Kobe Johnson's cell phone stays at the residence until it leaves with Emmanuel GPS to go up to Trey's house. I don't know what Bly testified in regards to the state's theories. He was honest in regards that there was a data session from, I believe it's 7:25.
I'm going to object to.
Overruled. It's in rebuttal to arguments made by the defense.
It was 5:27 to 7:02. I'll agree it's over the course of the homicide. You do notice there's a data session that actually ends at 5:27 in like 10 seconds, and this one starts at 5:27 in 11 seconds. Could it be a human being interrupting it and starting a manual use of the phone? Yes. Could it be the phone doing a data session and then ending and immediately starting the one that's next up? Yes. We can't tell you which. Phone records don't tell us. What would tell us is the cell phone. That unfortunately got broken in New York in the snow. Data session goes until about 7:02. Marcel Johnson comes back at 6:36. And I believe his testimony was he was playing video games. He wouldn't be on the phone. So is he on the phone watching an hour and a half video, and then Marcel comes over and goes, I'll be with you in 20 minutes, I gotta finish this? It's more than likely an unused data session. But I'll agree with you. I can't tell you one way or the other. He's not fitting in the state's theories. He's telling you the evidence that's there. Whether it's good or bad, the records don't lie. And some experts, just like Jennifer Brown, have been trained appropriately how to testify. And they're very afraid because they're giving expert opinion with just giving summary, yes, no, well, yeah, it is within the threshold for excluding. Yes or no, was he excluded? Data results fall within the threshold for exclusion. She's saying he's excluded. But some of them can't just answer yes or no questions based on what question just came out, because their answer might be misleading. And their expertise, they want to make sure they're precise. I don't get, you went through 2,400 lines of spreadsheet. He got to decide what data got included. Yeah, but all the data was disclosed in regards to the towers. They're all in the cell records that are in evidence. They're all there. Rather than plotting, you saw the RTT data. There's like 3 or 4 every minute. So rather than having just that many dots and that slideshow would go from 23 pages to probably 180, he decided to pick the ones that still accurately show what the device is doing. Mr. Gerard said he went to Brooklyn, bought some weed, took a few puffs, and then left. That's not 30 minutes. Also, why are you going to Brooklyn to do that? It's at your house. Live from there, and then he goes. He is excluded as a contributor to 3 DNA swabs that they did. 2 swabs and 1 cushion. There are 2 other swabs that were done in the car that has DNA, but not enough to actually be interpretable on who it is. So he actually might be one of those 2. We don't know. Also, just because he's not in, so he's actually not excluded from being in the car. He's excluded as being any contributor to the DNA that they did and were able to collect in 3 locations. But it doesn't matter. His jail call says he's been in the car. How is the fingerprint doesn't matter, but the DNA excludes him from ever being in the car, but the jail call says, of course I've been in that car, that's my people's car. Failure to investigate is not reasonable doubt. Jacob Olds and Kendall Brown, they were interviewed. The surveillance speaks for itself. Mr. Gerard tells the detectives, I believe that he pulls up later on Brooklyn. And on your screens, and everybody joins, at about 8 o'clock, he is somewhere on this arc. So he's either right there on the road, or he's right there on the road. Marcel Johnson, at 8:05 and 8:05, is on this arc and this arc, so he's either here or he's here. And he's most likely here because from Trey's, you go up and over to the interstate. And that's at 8:05, he's here. Mr. Gerard at 8 o'clock is here. Kobe Johnson at 8:03 is somewhere along this arc, which includes this road that leads back to the interstate. So at 8:03, Kobe's here. 8:05, Marcel's here. 8 o'clock, Mr. Gerard's there. 2 minutes, 2 minutes. They're traveling together. They got in multiple cars, and they basically carpooled it after stopping at Pete's, the car wash guy's house, and went down to Brooklyn. Going to the jail call.
What?
The same thing he got, every charge.
Wow. Well, how you feeling? Like, you not saying nothing?
Cause, yeah. Shit. But they might call you though, cause they talking about they ain't believe my story, all type of shit. And they got my phone and got your number out my shit.
You see, that's what I'm saying. What you do just don't affect you.
What you do just don't affect you.
Right.
He says, you're right. What you do don't just affect you. You're right.
So what you want me to do with that?
What I told you.
All right.
They're going to come talk to you. They got my number out of your phone. What do you want me to do with that? What I told you. And her statement is, what I told you is get my stuff and keep in touch with my family. Hey, the cops are going to come talk to you. What should I do? Get my stuff and keep in touch with my family. Now.
For real. They gon' tell you. They gon' try to break your ass down. And I know you, Miller.
But I'm not going nowhere. Like, you get what I'm saying? Like, I'm not with all that. They could call me, but I'm not with all that.
They probably gonna come get your ass. They ain't got no reason, but.
Yeah, they don't got no reason.
Right. But shit.
And even if they do, they might as well take me back, because I don't have nothing to do with nothing. I'm not saying shit.
But you probably might have, well,
You said what?
I was gonna say shit. You might have to say that though. But they talking about they found my fingerprints in the car on the passenger side.
Wow.
The thing is, cause that's my people shit. Like, what can you? But I fucked up and said I ain't never seen it type shit.
Type shit.
And he
What?
said that. He said that after.
So, besides me already knowing what you told me, what I'm supposed to do, Trey? Like,
That what I said. What I told you.
He told her, tell them I was with you all night. And that's exactly what she told the detectives. The problem is, he got arrested and was interviewed, and he told them, I was with her all night. And they confronted him with his cell site, and he had to admit he had left the house. But now he's there on a recorded jail call. He can't communicate with her and say, hey, the story's changed. And so that's why she lies for him and says, he was with me all night. They confront her and say, well, his story's different. And she goes, well, that's my story. Why would you have someone lie for you? Why would you have someone give you a fake alibi? You don't want people to know where you actually were. And in regards to the 660 number, the phone is gone, so we don't have any of the messages that would be stored on the phone or that social media sometimes actually only stores on the phone. We don't have any of that, like we do saw Marcel Johnson's reports and photos from his device. He gets rid of his number twice. He gets rid of the 660 number, goes to a 330, I can't remember the second one, gets rid of that one again, and has the three phones that he's with. He denies knowing Spaz's real name, said he never saw the Zastava, says Pringle never saw him who shot his brother. No one told him who shot Marcel. No one told him who jumped Kobe. Never heard the name Jalen or Marquise. His original statement was that Marcel came over and we played video games. And then someone came over who shouldn't have been over and I kicked them all out and then I was there by myself. Then he changed his story to Marcel came over and played video games. Then Kobe and Emmanuel, Manny came over, and then they went to Brooklyn. What's the problem with that story? Once he's arrested, once he sees discovery, once we go through trial on here, we see that at 4:28, Marcel Johnson arrives. In fact, actually at 4:25, because they're both the same distance from the tower. So at 4:25 and at 4:28, he is pinging on this arc. Since that's the longer one, the 414 is still here. So he's still en route at 414. 4:25, he's at the house. He's still at the house until I believe the call was made at 7:30 to Kobe, somewhere around that time. So Marcel's there the whole time. Well, Marcel's a lot of evidence in regards to the homicide, so he can't be with me at that point. So then he changes his story, and he changes his story and says, Marcel left and left his phone there. And then Marcel came back shirtless and puffing, and then later they called Kobe because of a controller. Yet Marcel never told him anything of what happened when he came back. And while Kobe and Emmanuel Pringle came over, and there was more discussions, never got told about anything that happened.
Mr. Grau?
Yes, Your Honor.
We have been in over 2 hours. I need to inquire of the jury, is somebody in need of a break?
Your Honor, I probably got about 5 minutes left.
Okay, well, this is what I say I do, and I do it. Anybody else here in urgent need of a break inside of the next 5 minutes or so? Okay.
Thank you, Your Honor. And I wanted to, actually, kind of the final thing is I wanted to get at was consciousness of guilt. We like to use it in DUI cases a lot in the phrase, but it really applies to any crime. It is actions by the defendant that you can use as evidence that he is showing consciousness of his guilt of the crime. So as much, and that can actually be evidence towards proving the crime beyond a reasonable doubt. Now, with the statements that I implore to you that Kobe and Emmanuel stated are in fact true of what Mr. Girard said, along with the other evidence of Marcel Johnson surrounding the homicide, as well as Mr. Girard's actions afterwards, I implore you about his testimony. He chose to talk to the detective. He chose to come up here and testify. He told the truth. Did he? His story was Marcel Johnson came over and at some point had to go to make a sale. Played for an hour, had to go and make a sale, and then he came back. Well, he gets there at about 4:25 or 4:28. And if we look on these records, and my apologies, it's how Verizon gives them. When they're +0, I got a -5. When they're -5, they're in Eastern Standard Time. So this right here would be about 1 a.m., 2 a.m., This isn't, so we'd have to go back to 13:52 on this, which is 1:52 p.m. This is 19, but it's +0, so I got a -5, so it's 14:31, so that's 2:31 p.m. Luckily, these are nicely in Eastern Standard Time for me. So 4:02, 4:03, 4:03, 6:40. And then if you go down here, 7:12, and then if we minus, that goes back to 19 as well, 7:21, 7:21. These are all after. So at least for the Verizon records, from 4:03 to 6:40, there are no phone calls. Going to Marcel's call log and message log, we have outgoing at 4:24, and then at 4:25 there's the outgoing, and then after 4:25, when he gets to Mr. Girard's house, is an incoming that he doesn't answer, an incoming that he doesn't answer, an incoming that he doesn't answer, and an outgoing at 6:37 after the homicide. There is no communication with anyone in regards to doing a drug deal. However, let's look at what the device is doing. Because remember, the device is left there. Well, the device doesn't have any calls or messages around the times. And the Verizon records, if you notice the call detail records, also includes text messages. There's none during those times. 4:05 to 6:40 for the Verizon, and then the actual call log, which would show social media FaceTime, we have nothing after 4:25 till 6:36. So, let's pretend that that phone wasn't the one that's being used for Mr. Marcel Johnson's drug deals. And so he leaves this 734 area code number at Mr. Girard's house. Girard said he left his phone here. There's no communication of drug deals, so that's not the one he took with him. What does this device do at 6:13 and 6:15 p.m.? Display comes on. Somebody turns, somebody touches, someone hits the unlock button of this phone, per this phone, at 6:13 p.m. when Marcel Johnson is out hanging around outside the Legend Center. Contravious Girard is apparently going on his phone at home. What happens at 6:15 and 6:13? Well, we have a YouTube data session and we have Apple Maps. Someone is using the maps feature of the phone at 6:13 p.m., the same phone that is left at Mr. Garrard's home. What do we have when we go to the more detailed actions of the phone? Well, here's the 6:13, 6:15, and the 6:13, the display is on. What happens at 6:15 p.m.? The device is switched to speaker mode. This is not a data session running in the background. The device is switched to speakerphone. A human being is pushing the speaker audio on the phone. And the last slide is this. On 6:15 and 43 seconds, the device is put on the speaker. It's the same one you saw from the other slide. And I've merged it with the data session of YouTube. And what's the time on that? 6:15 and 44 seconds. So somebody is manually using this 734 number that makes no communications about anything of a drug deal, and according to Mr. Garrard, is left at his house. And at 6:15 and 43 seconds, someone is putting on speaker mode, and 1 second later, a YouTube video is played. How can that happen if Mr. Garrard's testimony is the truth? Because it's not. Because at 6:13 and 6:15, this device was not left at Mr. Garrard's home. It was with Marcel Johnson in the blue Kia Rio, along with Travis Garrard in the blue Kia Rio, along with the Sestava firearm. And it was looking up maps in regards to the fact that they were about to leave the Legend Center, maybe for a good spot to do a shoot-up, and it was playing a YouTube video. Maybe it was one of those 3 old drill rap videos. Maybe it was something to get them in the mood for what they were going to do. But anyway, I understand that's speculation. What is not, that Mr. Garrard's statements, he left his phone there, is not true. Why is he continuing to tell different stories? Because he's trying to protect himself. He said Marcel was there, and they were playing video games, and then they got Kobe and Trey. And then he saw the evidence, and saw that Marcel was doing the shooting at 6:18. So then he changed his story that Marcel left, and then came back. But the problem is he added the phone. Not digging into these records to see that phone was being used 3 minutes before the homicide. Mr. Garrard's testimony to you is not true. You can use that as consciousness of guilt, that he knows that he is guilty of this crime, just as the evidence proves beyond a reasonable doubt that he is guilty of the highest charges of each count.
Thank you, Mr. Grell. Mr. Eversole, would you identify our alternate jurors, please?
Ms. Harrison and Mr. Bush.
All right, so Ms. Harrison, Mr. Bush, you are our alternate jurors. This is the hardest part of a trial for me. So you will not be deliberating with the other jurors in deciding on a verdict. We have to go into the alternate pool very frequently. If we don't impanel alternate jurors and something happens to one of the other jurors, a mistrial has to be declared and all this has to start over. So it's what you did is just as important as what the other jurors are going to do in deliberating the verdict. I thank you very much for your time and your attention to this matter. I understand what a burden this is on your lives and your time away from your ordinary life. Thank you very much for your jury service. Ms. James will show you how to be excused. Oh yeah, you'll have your things over there. Right. Take them out that way, right? So then, as soon as they go there, everybody else can go. As soon, members of the jury, as soon as they go out that door, then you all will be able to go to the jury room to retire and begin your deliberations. Evidence, the jury instructions will be brought in for you. Remember, it's been a long time. The first thing you should do is elect a foreperson, and the bailiff will tell you how to notify us about the election of the foreperson. And again, we have the ability to provide dinner. It will not be pizza. All right. All right, you ready, Ms. Sherman? Okay. All right, so we'll get them in there first. All right. So you can now retire to the jury room to begin your deliberations. All right, everybody, be seated. All right, going to the red jury. The first question that was asked, which is signed, so that's a good sign. What is the expected latest time for us to be dismissed? Can we let others know family? Obviously, that, you know, I'll tell them that's, it's going to depend on when they reach a verdict. And we don't know what the latest time will be, but, you know, typically, just for everybody's information, I'm probably not going to take this past 10 o'clock tonight before sending people home. It'll be somewhere around there. Typically, what I do when I'm getting close to the time when I'm done is I'll bring them out, poll them, see if they're getting close to a verdict. If they are, we'll keep going. I largely, when it gets that late into the evening, leave it up to the jury as to whether they want to continue to deliberate or come back. Second question. This one is not signed. LaTanya Beeks, can we get her testimony, either video or from the court reporter? Of course, there's a standard instruction for that. They'll be provided with that standard instruction. The gist of it is they should go back and try to figure it out from their collective memory, and if they can't, to specify. Third question. Can we please get picture from November 29th with sneakers? They should have that.
Can we give guidance on how to open it? Because it's in one of the reports.
Sure, of course. That one is signed. Fourth question. Some need to make arrangements for kids. Okay, so I know that we've been going a long time. We got to get these things addressed and give them some instructions. Have you already told them how to order dinner? No, so they have, what they're allowed to do is they can order from the Al's menu sandwiches and salads if they don't want pizza. If they want pizza again, they can have pizza again. All right, let's bring them out and we can address these questions on the record.
Judge, I would just need to renew any previously made motions and objections on.
Okay, certainly.
You're like me, just where to find the photo they're asking?
Sure. Yeah, tell me where it is.
It's page 14.
Okay.
It would be in what are called Marcel photos, capital F, capital A. And then there should be a report in that folder titled the same.
A report in the folder?
There's a PDF in the folder, and open, titled the same.
Tell me that title again.
Marcel photos, capital F, capital A.
Spell photos out? I'm not following you.
PHOTOS.
Oh, after photos is where the FA comes from?
Capital F, capital A, yeah.
Okay, gotcha.
For firearm photos,
Right.
then they can click the photos to make it.
Okay, bring them out. while we're waiting, I'm going to anticipate the arrangements question is going to relate to using electronic devices. Typically, they would not be allowed to do that during deliberations. If somebody wants to object to me allowing them to do that under the supervision of the bailiff, I'll hear the objection. All right, we got some in the bathroom. I mean, they could. So, let me just do this. Here's what I'm planning to do. Is I'm going to allow them to contact their family members to make arrangements for childcare under the supervision of the bailiff. Is there an objection from the state?
No, Your Honor.
Is there an objection on behalf of Defendant Johnson?
No, Your Honor.
Is there an objection on behalf of Defendant Gerard?
No, Your Honor.
Okay, very good. Everybody can be seated while we wait. Okay, never mind. Okay, everybody can be seated. So, members of the jury, I have discussed your questions and notes with the attorneys. I'm going to read all four of them as a group. If I misread any of the four, raise your hand. Number one, what is the expected latest time, that's in parentheses, for us to be dismissed? Can we let others know, in parentheses, family? Number two, LaTanya Beeks, can we get her testimony, either video or from the court reporter? Number three, can we please get picture from November 29th with sneakers? Number four, some need to make arrangements for kids. Did I misread any of those? If so, raise your hand. All right, I see no hands. Okay, so I'm going to address sort of the easiest ones first. Number one, I don't have a set latest time. That's largely depends upon whether you're able to reach a verdict. Usually around 9:30 or so at night, I'll bring you out here and ask if you're getting close to reaching a verdict. Generally see if there's a consensus on whether you want to continue to deliberate tonight or whether you want to go home and come back in the morning. So that's how that one works. As to the needing to make arrangements for your kids, number four, ordinarily you would not be allowed to use any devices during deliberations. For those of you that need to use a device to handle that issue, I'll allow you to do that in the presence of Ms. James. She'll need to take control of the device again as soon as you do it. Obviously, you can't look up anything, do any sort of information, just use it for the limited purpose under her oversight of making those arrangements. That's probably a four-person. Yeah, go ahead. Just make sure that's what it is. I'm going to go to question number three. All right. All set? They got a four-person. Okay. Yellow jury has a four-person. The picture from November 29th with the sneakers, you can find that and let me know if you need this written down for you. We can write it down. States Exhibit 14, it's going to be on one of the discs that you have. It's in a folder. It's a PD, it's called Marcel Photos FA, so it's MARCELPHOTOS, capital F, capital A. Within that folder, there should be a PDF file of the same name. Did I get that right, Mr. Grau? Yes, sir. Okay, so that's where you should find that photograph. Now, turning to LaTanya Beeks. All right, so there's a standard instruction for this. Members of the jury, you have asked the following testimony, LaTanya Beeks, be read back to you. All right, so here's what I'm going to have you do first. I'm going to have you go back to the jury room. I want you to discuss your request further. If you're not able to resolve your question about the requested testimony by relying on your collective memory, then you should write down as specific a description as possible of the part of the witness's testimony that you want to hear again. Make your request for reading back testimony as specific as possible. I'll clarify it a little bit. There won't be a video. It would have to be read back to you by the court reporter. It can take some time to prepare that. Now, I do know that you've been in there deliberating for a significant amount of time since you made the request. If you already know that you can't resolve it, then try to narrow, in other words, if you can't resolve the request by your collective memory such that you don't need it read back, try to narrow the request as much as you can. Write down the part of the testimony that you need, if you can do that. If you can't narrow it, then just say you need the whole thing read back. That's what we try to avoid the most, but we can do that. So I'm actually going to have the bailiff give you the note for Ms. Beeks' testimony back so that you can further clarify that. I'll state for purposes of the record, because these notes do get filed, that I've written on here the file name. If you have any trouble finding that picture that you're looking for, let us know. Ms. James is going to give you some instructions. There should be menus back there. If you can't find them, talk to John. So you can order your dinner if you think that you're going to need to be here a little while. You can get pizzas and sandwiches from Al's off the menu. Excuse not pizza, sandwiches and salads. So I'm trying to avoid having to have you eat pizza again. If you want pizza for a third meal in a row, you can have it, but you don't have to do that. So at this time, go back to your deliberation, see if you can narrow your request, and we'll move forward. Ms. Sherman, before you do that, hang on just a second. Take that to Ms. James so that she can get that. Yes. Everybody can be seated. I'm sorry, I should have given you that instruction before. A lot to keep up with here. You can be at ease in the courtroom.
Are we in recess? Is that?
Yes. Well, I mean, I don't know if you call it recess when we're waiting on the verdict, but if you want to call it recess. All right, so it pertains, it's not really another question, it pertains to the readback of LaTanya Beeks's testimony. What they've added in way of specificity is from sort of two paragraphs, from where she heard the shots to where she came back. Does she say blue car, and what she saw pertaining to the cars that passed her, the order blue, then white. Okay, hang on before you go in there. Hang on, but I don't want anybody going to the jury room right now. Melanie, does that help you at all, or is it going to be easier just to read the whole thing back? And her testimony wasn't very long. Okay. Do you want to try to guess it based upon that description? Because we can always ask them whether or not that answered the question. Okay. What about from when she heard the shots to where she came back? I really, frankly, don't know what that means. See what they got.
So,
There's 2 or 3 envelopes over here. Ready on record? So this would be from the yellow jury. It's not signed. Can we please get an electronic copy of all counts? Question mark. So we can see as a group, ellipses.
Electronic copy, is that what they said?
Of all counts.
Like an electronic copy of the indictment?
We'll have to bring them out and ask them what they mean.
Intelligent with yeah, but potentially the instruction could be you receive the jury instructions for the highest charge for each count. Those are the charges that were charged.
Well, okay, well, let's just try to be it preemptively. I see it as they're asking possibly for 2 things. An electronic copy of the indictment or an electronic copy of the verdict forms. Is there any objection to them having a copy of the indictment?
For the defense, I don't know anything on the indictment that would be redacted.
What would need to be redacted?
I don't know.
What's the basis for the objection, Ms. Jamison?
I don't know that I have one, I'm just stating my preference.
Fair enough. I appreciate your candor. How about on behalf of Defendant Johnson? Candor with the tribunal is always a good strategy. How about on behalf of Defendant Johnson?
The answer to the question or?
No, whether you have an objection to them having a copy of the indictment.
I don't really have a posture as to.
Oh, fair enough. It's getting late.
I don't think we see anything.
You're correct. All right. Well, Melanie, any further progress on Beeks? No, but I'm just saying on what they mean from when she heard the shots to where she came back. Did you identify anything in there that it might be? Okay. Sure. All right, here's what we're going to do. Let them know that we'll get to them as soon as possible to continue deliberating. Keep looking at Ms. Beeks' testimony, see if we can avoid the full readback. Yeah, of course. Yes.
Would you like me to, or give the jurors the menus?
Yes, please. What time does the order have to be in?
Sooner the
Okay. All right. You may want to give Al's a heads up.
Okay, one moment.
Ms. Jameson, did Mr. Gascone excuse himself for the evening or just temporarily? Has he abandoned us?
Yeah, taking the boxes out to the vehicle, so.
Okay. Okay. All right, let's do that. I'm going to have the yellow. Anything, John?
I'm sorry, you want me to wait to give them the menus?
They should already have the menus.
No, not yet, so I'll do that.
Okay, who? All right, we need to get food in as soon as possible. So they have the yellow has the menus, John?
Yes.
Okay. But red does not?
Now they will have the menus, so now both can put in their order.
Okay. Let them know we want to get the dinner order in before we address this question formally. Awesome. Hesitate to give. I want them to order. materials and the discretionary materials that can go to the jury room, the indictment or information is not within the discretionary materials. No, I'm sorry. I take it back. It is. It's just not phrased that way. Copy of the charges against the defendant, so should be okay. 3.400. Mm-hmm. Nor have I. All right. Ms. Jamison, I think I heard you asked if the state would pay for his trip. Assuming neither one of you have that authority. Counts.
You're gonna ask them to clarify if
Yeah.
it's a charge document or something in the jury instructions?
Correct. All right. Yeah, have them come out and take their seats. Okay. You can be seated. The note, it's not signed. If you ask another question, remember the foreperson's supposed to sign it. That's not a big deal. So I've discussed your note with the attorneys. You've asked the following question: can we please get an electronic copy of all counts so we can see as a group? If I did not read the question correctly, raise your hand. All right, so at least we got that much right. We're not sure what you mean by all counts. Are you referring to a copy of the indictment? You can just sort of... Okay. All right. Yes, we can get you a copy of that. Well, I don't want it to get into a conversation, so let me do this. This is the indictment. This is the state's charging document. If you remember, we talked about it at the beginning of the case. It's not evidence. Can't consider it as proof of guilt. It's a mere formal charge against the defendant. So it has all 5 counts, and it has the legal charge. So like count 1, it was read to you during jury selection. It's Marcel Joshua Johnson and Contravious Tyree Garrard on December 3, 2022 in the county of Duval in the state of Florida did unlawfully and from a premeditated design to effect the death of Prince Holland, a child under the age of 18, and so on. Is that the document you're looking for? No. The verdict forms? Okay, so you want electronic copies of the verdict forms. All right, very good. Yes, so you have hard copies. Did you find those? Okay, so you want an electronic copy to display on the screen. All right, I'll see if we can do that. Okay, you can resume your deliberations. All right.
I can run back and get a disc, and I can get the verdict forms, just the verdict forms, and I can burn them to a disc.
Will USB drive work as well in there?
That will work as well, Your Honor.
Is that even easier, maybe?
If someone has one, then will it?
I don't have one. Whatever's fastest and easiest, Mr. Grau. I'll leave it to your discretion.
I got all this stuff there.
But the blank one, that's the problem. Or people have things they need on it and don't want to delete it all.
Right.
I have one here. I don't know if there's anything on it. It's been in my briefcase forever.
Thank you, Mr. Gascon.
Peter, I'm not on the domain. They're not even connected to me.
Or you can do mine. Mine's right there, so whichever.
from Ms. Beeks to be read back, the part from when she heard the shots to where she came back, and does she say blue car and what she saw pertaining to the cars that passed her, dash the other blue then white question mark. Our court reporter has identified portions of Ms. Beeks' testimony that she thinks are responsive to your questions. So what we will do is I will have her read back that testimony to you. And then once she has finished reading it back, I will inquire just by consensus, it doesn't have to be a specific person answering, whether or not that addresses the concerns you had about Ms. Beeks' testimony. So if you will read back. Do you need a microphone? Okay.
Question, what happened while you were at that intersection? Answer, when I was at that intersection, I just looked over and noticed that I forgot what you call it, but it was coming down and it was maybe like in the 20s. Question, you mean the little pedestrian? Answer, I knew the light was going to change. Then all of a sudden, I was just sitting there and I started hearing sounds like the sounds of, I thought it was fireworks. I honestly did not know it was gunshots. I just heard and felt boom, 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 boom. And then it dawned on me, it didn't take long, but I said, oh my God, it's gunshots. Because at first, I just assumed it was fireworks. December, it's early, people are out, you know. You see people at the gas pumps, you see people hanging out around the store, just talking, and the same thing with the restaurants. So a lot of people are out, and I was just thinking maybe somebody started early. Question, I got you. Answer. So once I did realize that's what it was, and it didn't take long, I eased down in my car, slipped down, and then I proceeded slowly to get back up. Then I noticed that the light had changed, so I was a little hesitant. I was just kind of frozen and scared to move, but I decided to proceed to go forward. And when I did that, a blue car that was probably kind of small, I would consider it kind of a small car, maybe a medium blue, like royal blue, passed by me very quickly and almost cut me off. I had to stop real abruptly. It passed by me and went this way. Question, I know you were using your hands for me, so let me go back and get some descriptors. Answer. Question, when the car first came up by you, was it on your left side or your right side? Answer, it was on my left side. Question, and then you said at some point it almost cut you off. Tell me what the car did in relationship to your car. Answer, it was about to hit me. I was getting ready to move because I was hesitant to go out, and I decided to go ahead and try to cross. But when I did, the car came, and it came like to me out of nowhere, and it almost hit me. I had to do like this. Question, so it was on your left side. Did it cut to the right and go in front of you? And yeah, it went this way. Question, it went right off to the right in front of you. Answer, yes. It went down there, and immediately another car, a white car, did the same thing. So I was almost about to get hit both times.
All right, members of the jury, does that address your concerns regarding Ms. Beeks' testimony? All right, very good. Thank you. You can return to your deliberations.